After 9 o'clock, I was waiting for two other committee members, Senator Hatchett and our minority leader, Gloria Butler. I think they're both en route, but we do have a quorum, so we'll call our meeting to order. This is the Senate Special Committee on Investigations. We have issued a subpoena on February 28th, and that was issued to Miss Ashleigh Merchant, who has been in the news quite a bit lately and had apparently quite a bit of documentation that we thought would be of interest. We also subpoenaed her to testify before the committee this morning, as is permitted by our rules. Ms. Merchant responded to the subpoena and as required by Monday at noon. And the Secretary of the Senate, Mr. David Cook, has all of the documents produced, and he will keep those in his safe room, I guess we'll call it, David, his repository. I can see you've got a couple of banker's boxes full of records. These are available for any committee member to review at your pleasure. Just get with Mr. Cook. We are keeping them under lock and key, so to speak, so they will not be made available to the public until we determine whether any of them involve confidential information or not. So we'll have those available. The minority whip took some time last night, and I think he may have been the first person to really review all of the records and spend a few hours there in the Secretary of the Senate's office to review this information. I'm going to make a determination after we have heard this testimony and heard from Ms. Merchant as to whether or not some or all of those documents will remain confidential. I remind the committee members, in our rules, you are bound to confidentiality unless things are publicly disclosed. So for now, we will be reviewing some of the documents during this testimony. But I will ask you, Ms. Merchant, to let us know if anything, in your opinion, is confidential that you would not like for us to publicly disclose for whatever reason. And then I will review the records as well. There are some personal financial records in there that I'm not comfortable at this time disclosing those publicly. But just to sort of set the ground rules here, I will conduct the interview with you. You will be sworn under oath. Miss Brenda Elwell is our court reporter. She will be making a transcript of all the proceedings, and that will be publicly disclosed for the press if you want to go back and double check and see exactly what was said. That will take and is also being live streamed, so it should be easily accessible to the public and anybody interested in this. I'll begin. Ms. Merchant, you are here under a subpoena to testify. I'd like to go ahead and swear you in. If you will please raise your right hand. Do you swear that the testimony that you will give before this committee will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
All right. So, well, if you will just continue with the transcript as we go. If you get hung up at any time and I fail to hit the right microphone and you can't hear who's saying anything, let me know. The way our procedures work is that I will be asking the questions, and minority party will have an opportunity upon request to ask questions as well. I've discussed this with the minority whip, Senator Jones, and he may or may not ask questions towards the conclusion, or maybe even at a break. If you want to, just let me know. Ms. Merchant, would you please just identify yourself and let the committee know? You see all our name tags to see who's on here. You know who we are, but let us know who you are and what your profession is, background, et cetera.
Definitely. My name is Ashleigh Merchant. My first name is spelled Ashleigh. Last name Merchant, M-E-R.
You're going to need to pull that mic a little closer to you.
Thank you. And is it okay? I have a notepad just in case I get two questions at the same time. I like to make a note to make sure that I remember.
The committee knows the rules. We passed them unanimously at our last meeting, and you actually have the right to counsel if you want to. It's not like a court proceeding where we're going to be having objections, et cetera. But since you are an attorney, apparently you're very comfortable responding. Okay, yes. Didn't mean to cut you off. Let's just make sure everybody can hear you there.
Thank you. Yes, I'm a criminal defense attorney. I was sworn in as a member of the bar in 2004. So I've been a criminal defense attorney for 20 years. I started out when I first graduated from law school. I came to Atlanta and I did an externship with the Southern Center for Human Rights. And then once I was sworn in as a member of the bar, I became a public defender in Fulton County. I was there for 4.5 years until I started my private practice, the Merchant Law Firm. We had an office in Fulton County at first. Now we're in Cobb County. I'm in practice with my husband, John Merchant, and we do criminal defense primarily.
So she knows Fani.
And do you have any other roles or affiliations? I've seen just press articles about you.
Yes. Yes. So I do. I've been very blessed to have a lot of active roles in the community. I was the former president of the Cobb County Bar Association Criminal Defense Section. I was sworn in January as the president of the Georgia Association of Criminal Defense Lawyers. I've been a member of that for 20 years, member of the Cobb County Bar Association, very active in both of those roles. I've been honored with several different awards, one from the Cobb County Bar Association, Defender of Justice, or Champion of Justice, I'm sorry, a couple years ago. And then, I've been honored with Rising Star Awards, Super Lawyers, and the Daily Report has different awards back when I was younger, 40 under 40. Wouldn't qualify, unfortunately, for that anymore. But, and then recently I was awarded at our annual meeting for the Georgia Association of Criminal Defense Lawyers. I was very honored to receive award about my work defending the Constitution.
She was also a supporter.
So
of
you are
Nathan
the current president of the Criminal Defense Lawyers Group.
Yes. And it's the Georgia Association of Criminal Defense Lawyers. We go by GACDL. We have about 1,500 members right now. We're aiming to get around 2,000, but we're one of the largest defense bars in the country.
And tell us a little bit about your trial experience over these last 20 years.
So I started doing post-conviction work, which is, after a person is convicted, doing appeals and habeas work. Then I went into misdemeanor trial work at first when I was a public defender. I moved into the complex felony division, which is where the majority of my practice has lied. I do about half of my practice is appeals, appellate work in the Georgia Supreme Court and the Georgia Court of Appeals. The other half is trial work. I specialize in complex felonies. So anything that's mostly in Superior Court. Every once in a while, I'll have a client who has a state court case, and so I will end up helping them on that, but primarily complex felonies.
All right. And during the course of your practice here in the Atlanta area, tell us a little bit about your involvement. And I'm just going to refer to these as the election interference cases. I think there's 16 or 17 defendants. You are involved in those cases, I know from seeing the news.
Yes.
Who do you represent?
I represent a gentleman named Michael Roman. I was hired late August, early September, I think it was late August, to represent him. He lives out of state, does not live in Georgia. Yeah. But so I've been his defense attorney since the time of indictment.
All right. So late August or September of 2023.
Yes. I began working on his case in late August of 23. I think I looked this morning, I filed my official entry on September 1st of 23. And then I negotiated bond for him, walked through the turn-in process and began negotiations with the prosecutor.
What exactly is he charged with? What's the offense he's been charged with?
He's charged with conspiring to violate the Racketeering Act, so RICO. He's also charged with some of the more specific allegations for him are attempted and conspiracy to file false documents. So essentially, I've classified the indictment. The easiest way for me to classify the indictment is there's the folks that are federal officers. There's the folks that are charged in the alternate elector process, and then there's Coffee County. He's in that middle section. So
that's the alternate elector process.
Yes.
And those are the documents that are deemed to be false. They're
Yes. That's what he's charged with. He's charged with false, filing false documents, false swearing, things like that, forgery.
And to be clear, you do not represent any of these alternate electors.
No, I only represent Michael Roman.
And you don't represent Donald Trump.
No, I do not represent Donald Trump.
Your involvement in the case is just for Michael Roman.
Yes, exclusively Michael Roman, and that's my duty.
You have produced quite a few documents to us.
Yes.
Do you have any concerns as to whether any of those documents are protected by attorney-client privilege?
I don't have any concerns about that. I do have some privacy concerns because you mentioned earlier that there was some financial documents that are not redacted, and so those would need to be redacted. That would be the only thing, but they're not. Phone numbers, I believe I redacted all the phone numbers, but there are some financial documents that are probably sensitive.
Okay. As far as Mr. Roman is concerned, is he giving you permission to speak freely about his case and about the evidence or documents you've accumulated in the course of his defense?
Yes, we went over the subpoena that I received and the classification of documents that I was asked to give. All of those were things that I obtained through discovery, not discovery from the state, but through my own. So we have a protective order in the case. So anything that I've obtained through the state could potentially be subject to that protective order. But these were all documents that I obtained through my investigation.
Okay. Most of the members of this committee are attorneys, but not all.
Okay.
And I recognize that the general public will be hearing some of this or either now or later. Tell me a little bit about when you're talking about state's discovery. What do you mean by that? I know, but everybody else may not.
Yeah, definitely.
Yeah.
So we have a statute in Georgia that allows us to do what called opt-in. So if we opt into the discovery statute, that means we're engaging in reciprocal discovery, which means that the state has to give us a copy of all of the material that they plan on using at trial. They also have to give us copies of anything that would be arguably exculpatory. And so in this case, there's been a lot of discovery exchanged because obviously there's a lot of defendants. And if they wanted to classify something as sensitive, they would do so. And then if we wanted to be able to disseminate it to any third party outside of our practice, we would have to have court permission to do that.
Yeah.
But when we are investigating a case, not everything comes through discovery. So in general, I would investigate a case on my own, and those items are things that I did not receive from the state. So we've got different classes of documents, the documents that I actually received from the state through discovery, through formal discovery, and then documents that I developed on my own.
Okay. And out of these documents that you've obtained from the state through formal discovery, that they're obligated to provide defense attorneys to fairly defend your client. Some of those have been deemed to be sensitive and that are not freely disseminated?
Yes. The state, how the protective order works, and the protective order is public. It was publicly filed. If the state deems something sensitive, they let us know that. And if we dispute that or we have some reason that we want it to be able to be disseminated, we would have to go to the court and basically argue over that.
Fair to say any of the documents you have provided to our committee were things that you obtained outside of that formal discovery process and are not subject to any protective order?
Yes, I did not. Nothing that was subject to the subpoena or that I provided was something that I got from the state. Okay. And nothing was subject to that protective order. I went through and was very clear on that.
Okay. And I'm wanting to make sure of this because this committee has made it clear from the beginning, it is not our intent in any way to interfere with the criminal prosecutions. And so I would not want to be circumventing a court order that was for the protection of the privacy of the parties to that case. It is not our job to interfere in that case at all or in your motion to disqualify Ms. Willis.
I appreciate that. And I was very cautious because I certainly don't want to go against a court order protecting. So I did not disclose any of those documents.
So tell me a little bit about the special grand jury process. It sounds like that occurred before you were ever even hired in this case.
It did. It occurred, and my client, Mr. Roman, was not involved in that at all. So he was never someone that was issued a target letter or a subpoena or contacted. So he was never involved in that either. So he didn't have counsel, obviously, since he was never involved in the special purpose grand jury. But in my role defending him now, I've obviously reviewed all of the things that happened with the special purpose grand jury that I have access to. So it's my understanding Ms. Willis obtained an order from, at the time, it was Chief Judge, I believe it was Judge Brasher, who was the Chief Judge at the time, obtained an order to impanel a special purpose grand jury, and I followed that in the news before I was involved in the case because it's very unique. It's not something that happens very often. Normally when we see a special purpose grand jury, it's some type of investigation into a jail or something like that. So it was kind of unique to see that. But from reading everything, my understanding is a lot of the witnesses weren't willing to necessarily talk without a grand jury. And so that's one of the reasons that they had to impanel a special purpose grand jury. But it was very unique.
I've been practicing here a long, long time, and I haven't seen a special purpose grand jury to basically advise the DA, apparently, or a subsequent grand jury as to whether there's evidence to prosecute. Is that essentially what it did?
That is exactly what it did. Yes. So, and now through the discovery process, I've been able to review a lot of the transcripts and also talk with a lot of the lawyers who were involved and witnesses that were involved in the special purpose grand jury. But that's what they did. They used that process to subpoena, particularly out-of-state witnesses. So in Georgia, it's always difficult when we have a witness who's out of state because we have the interstate compact. We have to get a certification to get a witness subpoenaed from out of state. It is not easy. It is one of the more difficult aspects of our job. So they used the grand jury process, the special purpose grand jury process, to bring in testimony and bring in, witnesses from out of state. They issued a lot of target letters to people back and forth. There was a lot of people that were targets and then weren't targets who testified, maybe negotiated some type of immunity, things like that throughout that special purpose grand jury.
Okay. And is that made public to other defense attorneys if immunity has been granted to any witnesses?
I don't know if it was made public originally. I know that some of it has been provided to us through discovery. We had a motions hearing where the judge ordered that the state give us copies of transcripts because they had everything recorded. So there's a transcript from the special purpose grand jury. It's my understanding there's a transcript from just about everything, but it does appear like sometimes that was cut off. So there are some sections that were recorded and then maybe a section wasn't recorded and then they went back on the record. But it was recorded, which we rarely get in a regular grand jury. We rarely, if ever, get that type of testimony. So that was very unique to have.
Is the state required to let you know if they've granted immunity to any witnesses that may have been utilized in this special grand jury process or in seeking the indictment?
Yes, they are. And, some of that has been given to us through discovery. Some of it has been given to us from other attorneys, the attorneys who maybe represented those parties. There was a lot of back and forth. There were a lot of, and this, I believe this was all public, that some of our state representatives, I think the governor in particular, were subpoenaed, and there was a back and forth over who could grant immunity, who had the power in that office to grant immunity. And that's something that I reviewed in my work on this motion with the DA's office, because Mr. Wade was the one that took over that power. And so the emails that were attached to a lot of the pleadings, it was interesting. It first started out that there was someone else in the DA's office who's actually an employee of the DA's office who was negotiating all of that. And then it evolved to another member of the DA's staff. And then ultimately it was Mr. Wade. And there's emails where he said, I'm the only one that can grant immunity. I'm the only one that has the power to do this. I'm in charge.
Was he engaged or involved in the special grand jury process?
Oh, very much so. He was by far the lead of it.
Right. And do you have the timeline of when that special grand jury was authorized and when it began to meet?
Yes, I don't know the dates off the top of my head, but there is an order and I can review it. I brought some of the pleadings with me, but it was authorized sometime. So he was appointed, the timeline, he was appointed in November 2021 to work on this case. It was sometime after that Ms. Willis sought the special purpose grand jury and got authority to do that. And then that went through, several months, and then they issued a report to her.
So he was hired by the Fulton County DA's office before the special grand jury was authorized or impaneled? Okay. And so he was involved from the very beginning of that process.
Yes, and he was actually hired, I believe, before it was even, I know it was before it was impaneled. I believe it was before the order was even issued, though.
And do you know what his role was as what's the official term? A special assistant district attorney?
It's a good question. I'm not sure. He usually goes by special counsel or special prosecutor. I don't believe he goes by special assistant district attorney. I don't think he's permitted to do that. I've studied these statutes a lot, and there's no real term for it. I've heard him go by independent counsel, things like that. But I don't really think independent counsel would be an appropriate term because he's not independent. So I've studied, I did not know this before, but I've studied, the structure of the independent counsel in the federal system. They're actually a separate office. They have their own appropriations to have a separate office, and they are kept separate from the U.S. Attorney's Office. So that would be where you get the independent counsel term from, or independent prosecutor. He goes by special usually, so special prosecutor or special counsel. And I think that's because he's not independent.
Is this commonly used in the state of Georgia? I don't know the scope of your practice. I'm not familiar with DAs doing this often.
No, and so I do practice throughout the state, and I've practiced in almost every county in the state at some point in my career, and it is very rare. I've had instances where there is special counsel, but those are very limited, and I can tell you about those, and then I can also tell you what I did to investigate that, because I had the same question. So first,
just so you'll know why we're asking, the scope of this committee is we've heard a lot of the allegations, and you, as a matter of fact, made most of them, or made
right.
Some of these public. And there's, of course, a public, outrage or uproar or concerns about some of the alleged improprieties that you brought forth, both, within the in the system, kind of what's appropriate conduct,
right.
And also financial improprieties. And we're tasked with investigating and finding the true facts, and not just taking the press at face value. And that's why we're asking you for documents, et cetera, so we can independently verify the various allegations that have been made. But we're also specifically tasked with, if necessary, amending existing statutes, right, or creating new statutes to build guardrails or whatever to essentially restore the public faith in our criminal justice system, in its impartiality and its fairness. And I have looked at some of the existing statutes, but it's very sketchy. What is the real authority? And we wonder if we need statutory authority or statutory limitations. And so I'm going to explore with you a little bit what the authority is for a special grand jury to be conducting a criminal investigation, and also the use of a special assistant district attorney is what I'm referring it to. Right. But and so that's the context. You have done that research, so help walk us through this just a little bit. Is there a statutory process that gives authority to utilize a special grand jury to advise a DA, or to essentially accumulate evidence for a DA to determine whether or not to indict?
Right. So the first question was about whether this happens throughout the state or not. I did do open records to every single district attorney in the entire state of Georgia to find out, because I wanted to know, I knew based on my practice that it was a very rare process, but I wanted to know, I wanted the data. I wanted to actually see it. So we did an open records for every single district attorney. We have received responses from almost all of them. There's only a couple that we haven't, but I don't know that those would be big factors. The few that were remaining, I think it was Augusta that I haven't received one from. But I talked with two of the prosecutors in those districts. There's only two that actually use something that would be akin to this. And one of them said they haven't done it in years, but they have done it. And they pay between $40 and $40 an hour, which tends to be about the going rate for appointed counsel. It's between $40 and $60 an hour, I know, for appointed counsel in most counties. And then the other county that did use them, they use a part-time solicitor. And that DA said every time that they would have maybe some overflow work, an appeal or something that they had extra work to do, they would hire this part-time solicitor. So it was someone who was already a government employee, and they would pay $45 an hour for this person to do work. So those are the only people. This is a very unique to Fulton County, which I assumed, but I didn't know until I did the research. Nobody does this but Fulton County. And the AG's office does it. And so we got a lot of arguments from the state about, well, the Attorney General's office does it, but that's a whole different statute. It's not even the same section. So the Attorney General is authorized because they represent all of the state agencies. They are authorized to hire outside counsel, and they have to because there's a lot of conflict issues. And so it makes sense. So you've got different needs for hiring outside counsel. You've got conflicts if there's a conflict. And if there's a conflict, you'd have to hire someone who's outside of the office. You couldn't hire someone like in this case, like Mr. Wade, to be special counsel because they're in the office. So you can't, when you have a legal conflict, you have to have the offices have to be separate. So with the AG, that's usually what happens. Sometimes it's specialized knowledge. I mean, you've got people who are representing commissioners, you've got people who are representing, people in certain agencies in the state, in certain types of power. And so it might be a specialized practice area. So the Attorney General is authorized, and they actually publish it on their website, all of the rates. It's very transparent. So I went through and looked at everybody's rate. I mean, it's very transparent. How much they pay, it's based on experience. They get approval for that. They get approval for the appropriations for it. And it's just extremely transparent, which is in direct contradiction to how it works in Fulton County.
And do you know how many judicial districts we have in Georgia? I don't.
I do not. I could look at my open records request. So the judicial districts, there would be a district attorney for each of those. And so those are who I sent all of this.
It's over 50.
It's over 50. I think it's 59, but I'm not positive.
That's what I think.
I think it's 59.
So out of those 59, you reached out to all of them to see if their district attorney's offices for each judicial circuit ever utilized a special assistant, outside counsel.
Yes.
Okay. And out of those, only 3 of them have ever done it?
Only 2.
Only 2.
Only 2 had ever done
Fulton
it.
County is one of them.
Only 2. Well, yes. I'm sorry. It's 3 counting Fulton County.
Okay.
I did not send an open records to Fulton County.
We are finding out information as relates
so
to
yeah.
Is there a
the hearing
statute that
they are
authorizes
holding
that?
here.
There is a statute, and I cite it, if I may, I cite it in my
interviewing
brief.
Ashley
Feel free.
Merchant.
Okay, thank you. I don't want
This
to
is
misquote it.
into DA Fani Willis, and this is the investigation that has ensued based on what's happened over the last month.
15-80-20.
Thank you for joining.
And how I came to learn that is I actually contacted the prosecuting attorney's counsel early on in this case, and because I was trying to figure out the legality of this. I did open records and I found out how much money the special counsels in this case were being paid. And there's about 20 different people in Fulton County that are paid under this type of arrangement. It's the largest personnel budget item in the DA's office.
Why wouldn't you just hire more assistant DAs and have them in-house?
That's what I didn't understand. And that's what, I mean, in my opinion, obviously, I think that's what should happen. But the reason that it wouldn't happen is because if you're hired as an assistant DA, you can't take private work. So the statutes, and they're all in section 1518, 15-18, the one that gives the authority for this is 20. But all of those, if you read all of them, it makes it very clear that if you're going to hire more assistant DAs, they have to be paid the statutory rate. So you can't just pay an assistant DA anything you want. You could not pay them $300,000, something like that.
What is that statutory
It's
rate?
I don't know it off the top of my head, but it is in the statute. I know that like District Attorney Willis, for example, I think it's around $200,000, and that's one of the top paid people. So most of the people are paid, somewhere between $100,000 and $150,000, something like that, depending on their role, depending on county supplements. So what the statute says is it gives a state salary, and then you can get a county supplement. But all of that is around that range. I'd say around $150,000. But there's limitations. So to answer your question, why you wouldn't just hire an assistant district attorney, first, they couldn't make as much money as independent counsels, or I'm sorry, not independent, special counsels, couldn't make that much money, but they also would be limited in their law practice. They wouldn't be able to have private practice, and that's by statute. So if you are hired as an assistant DA, you cannot have a private law practice also.
Do you know how many there are in Fulton County DA's office?
How many special prosecutors?
No, how many assistant district attorneys?
No, I actually opened records that, and it was declined. So we actually have a pending open records lawsuit, which I did bring. I asked for that. I asked for how many were hired, when they were hired, when they were fired, and they declined to give me that under the Open Records Act. So we ended up filing a lawsuit, and that's still pending.
Because it just occurs to me, I think there's certainly dozens of them.
Yes.
Maybe 100.
I think 100 would be a fair example, or a fair number based on just my knowledge of it. But there's quite a few, and if you had a certain amount of money that they spend several $1 million on these special prosecutors, that could be spent on a lot more assistant district attorneys. Do
you know the process in Fulton County on how you approve the budget for the DA's office? Is that something controlled by the county, or does the DA have total discretion?
It's controlled by the county, and I do know I actually went back and watched a lot of budget meetings. They have their budget meetings online. I read a lot of the transcripts, and so it's very interesting. It's kind of a long answer, though. Depending on who you are in Fulton County, depends on how your budget is approved. So, for example, the county attorney, if they want to hire special counsel, okay, and pay them hourly, like in this case, they go and they get that approved at the county level. They actually appear in front of the county Board of Commissioners and say, we need to hire this person at this rate, and they approve the rate. They monitor the bills. They do all of that stuff. So that's what happens at the county attorney's office.
Okay, the county attorney represents the county, is not prosecuting criminals like the DA does.
Correct. It's civil. So the county attorney does all civil things. In this case, they actually did end up representing the DA in some of the open records issues, which is a whole nother issue. So the county attorney, the civil body, they actually go and get county approval from the Board of Commissioners. And there's actually a resolution. So I think I attached as an example in one of my briefs, a copy of a resolution just to give as an example. I'm pretty sure I did. And it's very transparent. They get it approved. Yeah, here it is. It's called a resolution, and it's a resolution authorizing funding for additional personnel. And basically they go and they say, we need this for this project. We need this budgetary item, and it's approved. It comes out of their budget, though. So they're not going and asking for more money for the county attorney's budget. They're just asking to use the county money that they've already been allotted for this special counsel. The district attorney has taken a different position. And I was surprised. So I watched hundreds of hours of Board of County Commissioners meetings just to make sure that I wasn't missing anything, that she never went and asked for approval for any of these special prosecutors.
Her budget is granted through the Fulton County?
It is.
It's in part of its budget?
It is. These special prosecutors have been paid a couple different ways. They were paid with state seizure money. So the first, around $100,000 of Mr. Wade's funding came from state seizure money. It appeared from looking at the budgets for the state seizure that fund ran out. So then it started coming from the general fund. But it was money so Ms. Willis had a budget right around the time that she hired Mr. Wade and these other special prosecutors. She went and asked for more money for a backlog. And so she was given extra money, and that money's been renewed since. It was given to her to hire 55 additional personnel, and it's actually in the resolution. She went in front of the Board of County Commissioners and asked for it.
When was that? Do you know?
I do, actually, because I attached it to my brief. So I know the dates of things. September 15th, 2021. Is when she presented her PowerPoint to the Fulton County Board of County Commissioners. And she gave a lot of statistics about all the unindicted homicides. It was mainly about homicides. It is, there was some about sexual offenses, but it was almost all about homicides. She said that, why am I here? The great trifecta: crime is on the rise, historic mismanagement, and then the COVID backlog. And so she asked for quite a bit of money to hire additional personnel. It was, I can tell you, that year it was $780,000.
And that's in the fall of 2021, just before this special grand jury was impaneled?
Yes. So that happened. She was awarded that money September 15th, 2021. And she actually did get the resolution and the process that you would normally expect.
How much was that addition or increase to her budget?
Not to exceed $5 million.
Wow.
So she was awarded for the end of 2021, which this is September 15th. She was awarded for September until December 31st, $780,000. It said, and then the next year, not to exceed up to $5 million.
So hang on for 1 minute. My vice chairman here, Chairman Dolezal, is way more high-tech oriented than I am.
Okay.
He has downloaded some of your documents that you produced to us that I had asked him to have available so we could see them here. And I think you have produced to us this PowerPoint presentation that Ms. Willis made to the county commission in September of 21 to allegedly fund backlog of murder cases, et cetera.
Yes,
right?
that would be Exhibit A to that motion. Yes,
Okay.
that's it.
And is that what we have on the screen here? Let's see if we can flip this one right.
It is.
Okay, so this is part of her PowerPoint presentation for additional funding over and above her previously appropriated budget from the county.
Yes. Yes, it is.
Okay, all right. So what were the county procedures for approval of funding for, additional outside counsel, or in this case, it sounded like she was going to hire 55 people in-house to help
Right.
with the backlog. Does the county have guidelines or rules or regulations as to how you get funding approved for either additional staff to work on her backlog of homicides or for special counsel to assist you?
Oh, yeah. Yes.
What are those proper procedures?
You have to get approval by the Board of County Commissioners. And the statute that I cited originally, 1820, that statute actually is the one that it says that you can hire additional personnel like this, but it has to have county approval.
Okay.
So, the statute says it already. When you were asking about changing statutes, it's clear in the statute that it has to be approved by either local law or the governing authority, which would be the county in this place and in this instance. And it's very specific that it can't be paid with state funds.
Anything in that September 15th of 2021 proposal or request for funding that addressed or contemplated special counsel to pursue indictments against folks for election fraud?
No, not at all. And I watched the video. It's online. Her speech where she used the PowerPoint in the speech. There's nothing about that at all. And in fact, what was submitted was pretty specific. It was to hire 55 new employees, not contractors, employees, in November 2021 and December 2021. And I did open records based on this, asking who was hired and the dates of hire, because I wanted to be able to track that, and that was denied.
And who made
There's
that denial? The
something they're
DA's office or the county?
The DA's office. And
Yeah,
I did
they're
bring
hiding
the open
something.
records lawsuit, just in case you had any questions about that. So it was the county, and I can tell you when I filed it. Let me see. And we went back and forth, and I requested it several times, but it was Dexter Bond at the DA's office who sent a letter back and said, we don't have that. We don't have to give it to you.
He's like the chief assistant for Fani Willis.
He is, and he's also the one who went to the Board of County Commissioners whenever they needed funding. So, if they had some large printing, and they had a big rebranding campaign where they had a lot of money that was spent on this rebranding, like posters and things like that around the office. And he had to go and testify in front of the Board of County Commissioners to get that paid because they were not paying it. So he's sort of the go-between with the Board of County Commissioners. His official title is something like Chief Legal Officer or something like that. But he's an attorney.
So you've gone back and reviewed all of the Fulton County Commission's minutes and records to see what requests were made and if there was a resolution granting the additional funding?
Yes. Oh, yes.
Was there ever a request for additional funding for a special prosecutor to pursue these election cases?
No, there wasn't. And I knew that before we got the district attorney's response, but subsequently we got a response from the district attorney's office that said, we didn't do it. We don't have to do it. I'm a constitutional officer. So their argument was, we don't have to comply with those statutes or those rules because she's saying she's a constitutional officer, so she doesn't have to get county approval. She can spend her budget however she wants.
Then why would she have gotten county approval for the other 55 attorneys?
So what I've surmised is that was because those were staff members. And so she went and asked for additional budgetary money. She needed a higher budget. So for those 55 people, she went and asked for more money because she didn't have enough money. And once she was awarded that, it's her position now that she can spend that money however she wants.
Doesn't have to use it for 55 new staff. She can use it for special attorney general.
Yes.
Not attorney generals,
Special
DA.
counsel.
Okay,
Right. Yes. Essentially, that is their argument in their reply briefs that they filed in court, that they have inherent authority. They don't have to comply with the county ordinances, don't have to comply with the statute.
So they don't have to comply with our state statute.
That they have, once they're awarded the budget, they can use that budget. However, I mean, how their motion, and I'm happy to send the motion. It's public record, but how their motion argued it was, if they get $5 million, they can pay that to one person if they want, as long as because the voters authorized her to do that. So the county, their position is the county authorizes a budget, and she can pretty much has inherent authority to do it. However,
Even though she specifically asked for the money to prosecute backlogged homicide cases in Atlanta.
yes.
Okay. What's your opinion on that? You think the statute or county procedures permit that?
No, I do not. And I cited several different county ordinances. So when I read the statute, when I read 15-1820, and it makes sense, it makes sense intuitively. As lawyers, when we bill, someone is reviewing our bills. I mean, that's just, that's the process. If you're in private practice, your client authorizes your bills. If you're doing public defense, which I've done public defense, I've done appointed work, the governing agency approves my bills, and they will cut them. They will regularly cut them if they're too high. And so there's always some type of budgetary authority that's reviewing everything. So I thought it was very strange that in this case there isn't one, and that there's really no oversight because it is public money. So I know that it's an elected official, but it's still public money. And I don't live in Fulton County, so it would probably aggravate me more if I did.
So we have the code section up that you're referencing for prosecuting attorneys getting additional personnel. That's what Mr. Wade would qualify as, correct?
Yes. So under B, that's the section that authorizes the appointment of special counsel. And it says the manner and amount of compensation to be paid is fixed by either local act or by the district attorney with the approval of the county. And so that's where that's our argument that this was not appropriate expenditure because it did not have county approval.
So our state law requires if a DA is going to go seek outside counsel, I'm going to call them, that must be approved by the county commission.
Yes, without a doubt.
And there are only 3 circuits that have even utilized this procedure.
Yes.
Do you have any idea what rates of pay were approved in those other judicial districts, or, whether they went through some type of approval?
So one was $40 and one was $45, and the annual amount that they spent did not exceed $2,000.
And what did Mr. Wade receive?
He's received about $700,000 so far.
And what's he paid per hour?
$250 an hour.
Has Fulton County been given any opportunity to approve or reject those bills, or the fact that he's even hired?
No. So, and that's an interesting point. So one of the things that the district attorney argued in their motions was that they don't have to have the actual bills approved. So she is the one that approves the bills. So essentially what happens was he would submit an invoice and she would sign off on it and send it to purchasing, and then purchasing would pay for it. So their argument in their motion was that the oversight is by purchasing saying a pay, that she would be the one that reviewed the time. So Ms. Willis reviews the time, and then it gets submitted to purchasing, and purchasing then pays it. And so that's the oversight in her opinion. In the state's opinion, the oversight is from purchasing, but purchasing just gets a bill and pays it. They don't actually look at it and see if the work's done.
Does Ms. Willis do that? Is she required to approve these bills submitted by the special counsel?
So the contracts indicate that the bills are submitted to her. She doesn't sign off on all of them. A lot of them were signed off on by other people in her office, purchasing people and things like that. So there's no evidence that I was able to find that she actually scrutinized these bills or reviewed them or anything like that, but she may have.
Okay. And you mentioned that attorneys that are working for state agencies or whatever, including the special assistant attorney generals, submit bills on itemized statement on what services they've rendered?
Yes, and the attorney general has very specific guidelines on that. What you can bill for, how you have to bill, and is told to remind. There's a reminder that this is public service. So essentially be judicious in your billing.
Right. You go voluntarily get underpaid to be able to
right.
help the public.
And a lot of people view it as public service, I think.
Are those bills submitted in like tenths of, I do some billing, in my job, and it's usually tenth of an hour.
Yes.
Are there rules or guidelines or sort of standards of practice and how you bill?
Yes. So most law firms, I know because my husband used to work at a law firm, is 6-minute increments. And that's how most lawyers bill in the private sector. Public, it appears that most of them are in 10-minute increments. I know that that's what all of the indigent defense groups, they all are 10-minute increments, but I've never seen anything above that.
Okay. And on the open records request you made to the other judicial circuits, how did those outside counsel bill?
Honestly, I would have to go back and look. They were very small bills though. They were making less than $2,000 a year. So they were small bills, and they were project based, which I think is also different. They would be hired to do a certain project.
If Ms. Willis had hired a employee, one of these 55 employees, and tasked them with the job of going through a special grand jury process and helping seek indictments, investigate these allegations, what's the most they could have made?
Well, first, she couldn't have hired Mr. Wade because it violates county policy. So she would not have been able to hire Mr. Wade as an employee.
How does that violate county policy?
They have a lot of policies on nepotism, relationships, personal. There's a lot of guidelines in the county policies. So she would not have been able to hire him. It would not have been approved. And that would be something that actually did have to get approved by the county. And because of their relationship, that wouldn't happen.
So she wouldn't have been allowed to hire him because of violations of other county policies?
Yes.
He couldn't have been a direct employee of the district attorney's office?
Exactly. He could
This
not.
process circumvented those rules and ethical obligations?
Yes, it did.
Let's say it wasn't Mr. Wade.
So if it wasn't Mr. Wade and someone else, I believe most of the other prosecutors on this case make around $175,000 annually.
It's important to note that the
interrupted you, I'm
previous.
sorry.
That's okay. No, that was the
Attorney.
answer. So
It's-
if she had hired Mr. Wade or somebody else as a salaried employee, they would make around
Had some
$175,000.
sexual
Most likely.
indiscretion.
So
with
using this
employees.
technique
It's
that
important to
didn't
note that.
obtain approval and didn't have to follow the ethical guidelines of her own office, she was able to pay him $700,000 over 2 or 3 years.
Yes, and
Way more than he would have made as an employee.
way more. And also he's able to have a private practice, which is significant because you're not able to have a private practice if you're an employee. So that's a big issue.
Have you reviewed his billings?
Yes, I have.
Senator Dolezal, will you give us an example of one? I think we have one we're just going to pull up randomly kind of. Okay. Is that an example of the type of invoices he would submit?
Yes, it is. And so
That's an actual one, isn't it?
that is an actual one. And so there's a couple things on this. You asked earlier about the authorization, that stamp that says okay to pay. I believe that's Dexter Bond's signature. So that was one where, Ms. Willis didn't approve it or didn't review it, at least as far as we know from the signatures.
But her chief legal officer did.
Right. So they would do that stamp, okay to pay, sign it, and then send it to purchasing. But yes, this is one of the bills. And so he had monthly caps, which went up. There were a couple different contracts that were renewed. So he had one contract that expired, another contract, and the monthly cap was $35,000 a month. So that's where you see the total. But this billing is not something that you would normally see.
All right. Well, I'm noticing it lists the day and just a number of hours. There's no real itemization of exactly how much time you spend doing whatever type of task.
Right. There's none at all. And I also open records because in Fulton County you have a badge to access everywhere. So I didn't open records for his badge access. I was told he didn't have a badge. I was told by other witnesses that he did. So, I don't know. But that you would, if you were doing these things in the office, you would. I used to be a Fulton County employee. You have to scan, and they keep track of all of that. So you have to scan your badge to get in to certain places. So if he's doing this, even as a contractor, contractors at the jail have badges. The medical providers have badges. They all have the badges that they scan. I open records to the sheriff and the DA's office, and both of them told me that he did not have a card, an access card. But in order to do this, I would assume he would have to have one to get into the DA's office. And I have been told that he had one, and those you'd be able to see when he went in and out. Okay. But I was denied that.
Anything unusual or irregular about, this is just an example, Bill, about the way he billed the county?
Completely. I mean, you would never see this. This is what I would call block billing. So one of them, for example, it's 28 hours over the course of 2 or 3 days, team investigation meeting and drafting. I went back and looked to try and see, a lot of these were like drafting. And at the time, I'm not sure what would have been drafted because most of this was during the special purpose grand jury. So there's not really a whole lot of drafting. We've obviously never seen anything that he specifically has drafted, but I also calculated these team investigation meetings. So the majority of the billing are things like meeting with team. So if you see here, it's got team investigation meeting, then it's got team meeting and argument prep, and then meeting with team. Most of his billing is meeting with team meeting, team investigation, team brain drain. He called it different things like that. But I went through and that's the majority of the bill.
And this wouldn't be standard from what you see at block bill in 8-hour increments instead of, you said, 6-minute increments or
no.
More specifically, and does not really give a lot of identification of what's being done.
It gives pretty much zero, in my opinion, identification. This is not something that we would be able to submit to a client ever. I can't imagine. They would, if I billed them $2,000 for 8 hours of meeting with a team on one day, and just research without what I'm researching. You have to be detailed in your bills because that's accountability. That's the only way as lawyers we can be accountable. Our clients aren't sitting in our office while we're researching. So I have to say what I'm doing.
And somebody has to approve it.
Oh, yeah.
And it's ultimately Fani Willis that was approving these either personally or through her designated assistants.
Yes.
And there was a written contract with Mr. Wade and the Fulton County DA's office?
There was, yes.
All right, let's see if we can pull that up, Senator Dolezal. Am I right that I think I've reviewed your documents, that there were more than one contract?
Yes, there were.
Is this the first one?
Yes, that's the first one.
All right, so that says it shall commence November 1st of 2021 and go through October 31st of 22.
Yes.
Okay, so that contract began before there was even authorization to have a special grand jury, and later in November of 21?
Yes, it did.
Okay. Does it specify that that's what his role was going to be, or is there any way that's disclosed to the public what he was doing?
No, up at the top, I believe it says, let's see. It just says attorney consultant. This one, so if you look under whereas, the first whereas, it says to provide legal services regarding anti-corruption matters. The head of the anti-corruption unit is a lady named Sonia Allen, and she was the one that was originally in the emails that I talked about earlier, negotiating immunity and things like that. So she's the head of that unit.
So the DA's office has their own special anti-corruption unit already in-house?
They do, and they have a director of that. Sonia Allen is the director or chief assistant. She heads that unit, and she was the one that was originally on the emails negotiating immunity and things like that. And then it switched over to, there was some issue, I believe it was with Governor Kemp on him testifying when, all of that stuff. And Mr. Wade took over and said, I'm the only one with authority. And so Ms. Allen sort of stopped working on the case, and she hasn't really worked on the case since.
From your experience and your knowledge of Mr. Wade and Sonia Allen, does he have any special unique experience or expertise that would make him better at this anti-corruption work than the head of the anti-corruption department in the Fulton DA's office?
No, but other than, no, he would not. But Sonia Allen also hired Mr. Wade in Cobb County before this contract at, I think it was like $550 an hour or something, to investigate deaths in the Cobb County jail. So Sonia Allen was the chief. So when Neil Warren was the sheriff in Cobb County, Sonia Allen was the chief deputy. And so she basically ran the sheriff's office. They had a couple different deaths, and there were some lawsuits over access to that. A lot of the local lawyers wanted access to what was going on with the jail deaths. And Miss Allen hired Nathan Wade to do that work, to do an investigation. And so a lot of this came out because they were ultimately sued. So I reviewed part of what I did in this case was I reviewed all of those documents as well. Mr. Wade had to testify because one of the news organizations sued them and said that essentially Miss Allen hired Mr. Wade to try to get around open records, to say that it was an open investigation so that they didn't have to give the jail recordings to the families about how these inmates died. Mr. Wade was a witness and had to testify, and he had billed a lot of money, which I don't have a figure, but I've got the invoices, but he had billed quite a bit of money to Cobb County, but hadn't produced any documents. And so he had to testify, and his testimony was that everything was in his brain, that he didn't have any written documents from anything. But that's where
That was some years before.
that was some years. I think it was in 2020, maybe.
So
it was
when
right
did,
before
when
this.
did Miss Allen get hired by the Fulton DA's office?
When Miss Willis took office. So when Miss Willis took office was the same time that Mr. Warren, who was Miss Allen's boss, was no longer the sheriff in Cobb County. So a new sheriff was elected, Craig Owens, and so he was elected in Cobb County. He took over that office. Miss Allen no longer had a job, and she was hired by Miss Willis to head the anti-corruption unit.
Okay. So from your documents you've produced and your news stories that I've read it, apparently there were other special counsel that were hired by Miss Willis
Yes.
and to work on these specific RICO cases or election fraud cases.
Yes. So there's several. And so that's kind of a longer answer because there's a couple different classifications. Mr. Wade was, at the time that he got this contract, he was law partners with a gentleman named Terrence Bradley and another gentleman named Chris Campbell. So it was a three lawyer firm. Both Mr. Wade and Mr. Campbell had contracts also. They actually had contracts before Mr. Wade. So they both got contracts the month that Miss Willis took office. They got contracts to do what's called taint work, which is essentially if, for anti-corruption, because it's a lot of police brutality cases, if there's things that could be considered privilege. So let's say the police union had a lawyer doing an investigation, they subpoenaed those records, those are privileged. Somebody has to review those to see what the DA's office can actually see. So it's that wall, that privilege wall sort of. So both of Mr. Wade's law partners had contracts to do that privilege review, that taint review, conflict review.
So you're seeing if there's tainted evidence, something that should not be revealed might damage another case, or it might be privileged and not subject to disclosure.
Right, exactly. And when one of the best examples I could give is, in the Tex MacGyver case, he was a lawyer. They seized a lot of his documents. A lot of them were attorney-client privilege related to other people. The DA's office was not able to just go through all of those. So they had to have a taint team, is what they call it. And so that taint team, and I don't know which cases, but the taint team involved Mr. Bradley and Mr. Campbell, who were Mr. Wade's law partners.
Basically, they're reviewing documents to see whether they should be produced or privileged by attorney-client privilege or something else.
Exactly.
Not exactly prosecuting criminal cases then.
No, they weren't prosecuting criminal cases. But Mr. Wade testified that they were law partners at the time, so that he would have shared a third of whatever contracts they got. So those contracts he was getting paid essentially from the law firm as well.
Right. So on this case, these RICO cases that you're involved in, one of them, there are other special counsel in addition to Mr. Wade?
Yes. So there's two other, on this case particularly, there's a lady named Anna Cross and a gentleman named John Floyd. And John Floyd has worked with the DA's office for many years. I actually was involved in another RICO case year before this one, which luckily my client resolved his case, so I'm no longer involved in. But that case, John Floyd had also helped craft the indictment. And, he's sort of known as a go-to person for racketeering cases. So the district attorney would regularly call on him to help in drafting indictment. Anytime we would file what's called a demur, which is a motion to quash an indictment, he would usually be the one that came and argued it. And then Anna Cross was also hired, and she really focused on the work in federal court. And both of those sort of make sense to me because Fulton County prosecutors they're not necessarily barred in federal court. It's not something that would be required for your job. When I was a public defender in Fulton County, I wasn't barred in federal court. I had no need to. I wouldn't have paid the dues, wouldn't have done that. So, it's not something that would be required for their job, but Ms. Cross is experienced in that. So she was hired sort of as a subject matter expert to litigate some of the federal removal issues in this case.
Did those two individuals have contracts with the DA's office as well?
They have had contracts historically. They do not currently have contracts. Yeah. It's very odd.
Did you review their billings?
I did. I reviewed their billings. Stark contrast. So Mr. Floyd, for example, he was only paid at a rate of $150 an hour. And Same case. And he
more experience and expertise in RICO cases.
I mean, everybody would agree. I think that John Floyd is one of the preeminent experts on RICO. Yeah. I believe he testified in front of the Georgia legislature when RICO was passed.
Did he have to submit itemized invoices?
He did, and his were very different. His were significantly reduced, and the big difference was he billed for the time that he was working on the case, not necessarily like 8 hours for team meetings.
Do you have itemized billings?
Very much so,
and
yes.
What increments did he bill in?
I might have some of his contracts with me, but it was either 10 or 15 minute increments. Okay. And so did Anna Cross. Now, Anna Cross was paid $250 an hour. Anna Cross is very well-known, very experienced appellate, federal lawyer, does a lot of complex litigation. She was a DA for many years, handled a lot of high-profile cases for the district attorney's office. I mean, I know her back from when, we did death penalty work in Cobb County together 15 years ago. And then she went to DeKalb County and prosecuted a number of high-profile cases there, but just very well-known. And her bills were also submitted, but they were the same rate. They were $250 an hour, but they were much lower bills, not anywhere near the bills that Mr. Wade did.
Do you know how much Anna Cross has received during the course of this criminal prosecutions or
I'm not sure.
Investigations?
I might. Let's see.
Okay. You said Mr. Wade had about 700,000 so far?
Yeah. Oh, Miss Cross was under 100,000, I believe.
All right. So if she's under 100,000, what about Mr. Floyd?
Mr. Floyd, much lower, even lower than Anna Cross. He has not billed in a while. So I was subpoenaed, or not subpoenaed. I did subpoena, but I also did open records for all of his bills. We've not been provided anything recently from him. So I'm not sure if he actually did bill because his contract said you have to submit the bill within a certain amount of time. So I'm not really sure. They stopped responding to my open records requests. But when they did respond, they were very, very limited, very small bills.
Okay. And your open records request was to whom? The Fulton County government, the commission, or the DA's office?
I did them to all of them. And once especially that they stopped responding to them. So they have a portal, and if you go to the DA's office and you click open records, it takes you to the Fulton County portal. So if you try to submit it to the DA's office, it necessarily goes to a portal for the entire county. So you have to submit it through those. So that's where I would submit it. You can designate, I think this is the DA, I think this is budget, things like that. So I would be over-inclusive just to make sure that I wasn't missing somebody. But every single time they would route it to the DA's office. So I would get a response that said it's been routed to the DA's office and, we're waiting on the response. There were one or two that I got from the county that didn't appear to be routed to the DA's office.
Right. And so who's refusing to produce these records to you?
The letter came from Dexter Bonds at the DA's office.
And
Dexter
that's
Bond.
why you filed a lawsuit against the DA's office to force them to comply with open records?
Yes.
Okay, that's still pending?
It is still pending.
Fulton County Superior Court?
It's Fulton County Superior Court. It's assigned to Judge Krause, I believe. And the county attorney contacted us and says they're going to be responding. So the county attorney is actually defending that lawsuit.
Right. And so they're telling you they're going to respond to the case or respond to the request now? You're waiting to
I believe
see.
the case. I haven't received any documents, so.
Fairly recent filing you filed there, or that lawsuit?
Yeah, so we filed it in January, and then they had a little shutdown in Fulton County where nothing was able to be file stamped. Our process server couldn't serve it until it was file stamped, and the Odyssey, the e-file system in Fulton County was hacked, and so it was shut down for a while. So it took us a little bit of time to get a file stamp copy back, but it's now been served. But it was filed on January 30th.
Of 2024.
2024. And I have a copy, which
I don't have that. If you would provide us with
Happy
that,
to.
then we'll give it to the Secretary of the Senate as a supplemental response to the subpoena.
I'm happy to. This is a clean copy.
Okay.
Yes, so you all can.
So what's the relevance
this.
to you? Why did you seek these billing records of these attorneys?
I wanted to compare the different billing, the different styles of billing. Also, there had been an allegation that I was singling out Mr. Wade. And so I thought it was relevant to see the rates that the other attorneys were paid, their billing, what type of billing, if they billed for everything. Just for example, when we're in court, one of the prosecutors may be arguing, Mr. Floyd and Ms. Cross aren't there billing. But Mr. Wade is always there. So that was one thing that I noticed. And I understand now that their response is that he sort of is like a case manager almost. So I guess that would be why he's always there. But I wanted to compare them and see.
Okay. I think I want to show a couple of things. Senator Dolezal, I want to show some of the other billing records, particularly ones that showed the trips to DC. We hadn't had but a couple of days to review all your documents, and I skimmed these records because I wanted to know exactly what was going on. You'll see highlighted down here at the bottom on November 18th of 22, interview with DC White House, 8 hours. Do you know what that references?
Based on another motion that was filed in our case and the arguments that were made by the DA's office, I believe that was when they met with the Department of Justice. They met with the January 6th committee. So one of the co-defendants filed a motion to try and get some documents, and the state had to respond. It was a motion to compel. I was there for it. I joined it, but I didn't litigate it. And the state said that they had to meet off campus. So because they didn't have a record of it, I guess you have to have a record if you go into the White House. And so they met with the January 6th committee off campus, and they said they had a really hard time getting that meeting. And they had to have someone who had some source or something to get them to agree to the meeting. But that's what
right there.
So the motion to compel was based on this entry.
Yeah. And
this entry, in response, they said they were meeting with the DOJ and someone with January 6th.
Okay. There's also an entry, May 23rd, 22, travel to Athens conference with, what is that, White House?
Yes. And we've tried to figure out what and who that was, because there was something happening at UGA Law School, and so we just assumed that it was someone that was there, and that's why they met there. But I don't know.
Do you have reason to suspect, or can you confirm whether or not Ms. Willis or Mr. Wade were coordinating with the Biden White House in the course of this investigation and prosecution?
The discovery, they've got a lot of our discovery involves the January 6th. A lot of what we have in discovery is the same stuff that other places have. So they had to have gotten it from somewhere. And they also, they read a lot of the testimony. They played testimony in the special purpose grand jury. So, I don't know how they got all of that, but they got it somehow. And then, there's one of the other things I did was I did a open records for the White House access, and we had records that Ms. Willis and the mayor of Atlanta were at meeting with the vice president.
Okay, and so this is the access history. How does that work? The White House keeps records of anybody that comes in and has any kind of official meeting, for sure.
Yes, and my understanding is it's highly regulated who can access the White House, and so you have to apply in person or apply ahead of time, and then they give you a time when you make the appointment, and they give you a time when you're allowed to be in and when you have to be out by, and they track you. And that makes sense. They don't want anybody lingering in the White House, but they keep that, and so they're called WAVE records, I believe is what they're called. And I'm not sure what that's an acronym for, but they're publicly available. They're open records. And
this record that's shown on the screen shows Fani Willis was a visitor with V. POTUS. I presume that's Vice President of the United States.
Yes, it was.
And what was the date of that back in Was that February sometime of 23?
February 28, 2023.
Is that before the indictment?
Yes.
Okay. Any further explanation of why Ms. Willis was meeting with the Vice President of the United States?
No. I know Dexter Bonds, and I believe that's the same one that Mr. I think it's Dickinson or Dixon, the mayor of Atlanta, was also there.
Okay. We're going to take a short break. We've been going at this for a while. Let's take a somewhere between 5 and 10 minute recess, and we'll be back. Thank you. We're in recess.
Now it's really awesome because I know that Michael had mentioned the fact that we have this over the weekend, as you guys know, we have this, wow, I can't even put words on it, but now we have the fact that it has been stated that Mr. The guy, he was talking to another attorney out in the Cobb County area. You guys, they'll be back very soon. And I know that I'm not as monotone as they are, but hang out with us just a little bit longer. And when they come back, we'll go on ahead and resume. But according to what this particular attorney said out in Cobb County, this young man, the one who they said was his attorney, his divorce attorney, was more than likely hanging out in her office. And what happened while he was hanging out in the office was he received a phone call from Fani Willis. And at that time, the young lady stated she could hear, as most cell phones you can hear, especially if the volume is up, she could hear her telling him basically, you know, they're out to get us, they're on to us, don't say a word. And I'm paraphrasing here. This is very pivotal in this case because once the judge decided that day he was going to take 2 weeks, and, you know, he did make a statement at that time, and he said, hey, I'm going to take these 2 weeks unless something changes or unless I get more information, you know, I'll see you all in 2 weeks. And then only a couple of days later, this comes out. But here's something that I want to ask you guys, if you remember last week, before they started this last date, if you guys remember, there was another witness they stated that they had that would be available on that coming Friday. I don't know whether you guys remember that, but that stuck with me. So when I saw the article that stated this woman had this evidence that she wanted to, you know, basically share, it dawned on me that this is that lady, or this is the witness that they had all along. I believe that by adding this in at the later time frame, it actually allowed the focus to be put on the topic and not all of the mud that they had been throwing for quite some time. Someone here in the chat a little bit ago said, you know, and I'm paraphrasing, but basically, finally, somebody with sense. Finally, we can hear copious, you know, note-taking, the evidence of copious note-taking and conversation and just poignant questions, asking the questions that the people would want the answer to and getting an answer. And so I have to agree with that individual who put that in the chat. Also, it's very important to note that this individual, Fani Willis, went into the White House prior to sitting down and getting this thing underway with the actual case starting to roll. So you're getting your notes from somewhere. And if this does not expose anything, it does expose the fact that this is what RICO looks like. The co-conspiracy thing, everybody conspiring together, one putting this over here and one doing this over here, and then we'll hide this information here, and then we'll all together come together to do something wrong, to do something illegal. We're all banding together to do this. We're going to change the narrative of something. Why would they have had access to anything dealing with Jan 6? Why? Why would she have needed to sit down with anyone in that office? And wouldn't it dawn on you, if you are an ethical district attorney, that just the very idea of sitting down with the Veep, wouldn't that tell you that that is not right? Because they're an opponent. This seated president is the opponent of the individual that you are trying to convict. So there are too many things for people who claim to be smart, for individuals who are smart. Here's the problem. Fani Willis is the district attorney of Fulton County. Nathan Wade was a candidate for judge in Cobb County. Nathan Wade is an attorney. These are individuals who have gone to school, who have been tested, who have been tried and proven that they are eligible to obtain and hold a bar card. These are individuals who are attorneys. These are people who are, you know, people who are supposed to govern the court's laws and regulations and hold them close and dear to their heart. So if all of that is the case, why would you not know that going to the White House and dealing with the opponent of the individual that you're trying to convict, why didn't that dawn on you? Why is it not okay for us to put those two together? Because they want everybody to focus on the fact that it was her private sexual escapades and her private life that had nothing to do with anybody else that they want to draw attention to, because the feeble-minded would love to just hold on to that as the mindset that it doesn't matter. They were having sex. Big deal. I don't care who she sleeps with. That's not my business. This is far greater than that. It has everything to do with the fact that you guys conspired. And it doesn't matter if it was Donald Trump or Boo Boo the Fool. None of that matters. I don't care if it was Donald Trump, Boo Boo the Fool, Donald Duck. None of that matters. The fact is, this is what you did in order to lie to Fulton County. This is what you did. You literally shaped and framed how you were going to get all this money out of Fulton County, violate the county's laws, make yourself look like an extra stupid fool by standing up in the public's eye only a few years before, when you knew that the gentleman you were running against was accused of sexual indiscretions, and stating for a fact that you were not going to be sleeping with anyone under your employ. And this is what you were doing, sleeping with somebody under your employ. You were the person that signed off on the documents. You were the person that approved the expense accounts that he gave, the expense documents. You are the individual who set the bar for how much money he was going to be able to make. You are the one who went and requested a specific amount of money so that way you could hire other people. And you were the one who did not hire those individuals, as it is evidenced by the fact that when they were requesting those documents to show how many people you hired after you had gone through the proper channels to get the approval for the extra money that he later got, you hid that fact and you prevented Ashleigh Merchant and the team from gleaning that information freely, to the point that they had to set up a lawsuit just to give you the opportunity to give them the documents or buy time. This is RICO, my friends. This is what RICO looks like. This is how it looks. This is how it looks. And this is what we are seeing all across the United States. And I'm going to tell you something boldly. All these Black folks signing their names, and I know I'm going to lose a couple of people when I say this, but you better hold on to this and listen very carefully, because there are so many people that have signed up to assassinate the character of Trump. And I am not a Trumpster. Please understand that I am dealing with this particular case that happens to deal with him, right? But there are so many Black folk who have signed up, and Black women specifically, who have signed up to utilize their office, education, their history, their reputation, their name. They have signed up to get Trump. But baby, he's a part of the team. You not. They're going to use all of the women, specifically 4 of them. Okay? They even have a name for the team of Black women who are judges and who are district attorneys and who are AGs and all this other stuff. They actually have a name for the 4 chicks that are out to get him. They are going to use you, and when they are done using you, they are going to throw you away. And not only are they going to throw you away, you will be considered a laughing stock, because they're putting every single thing that you do and how ignorant you are out in the streets for people to see. And he is a part of the plan, dude. This man is a part of the team. There's two sides to every coin. And the coin that you're looking at is just one side because it's bread and circus, my friend. You sitting up here watching what goes on to keep you distracted, and you don't even know that the side of history that you're going to go down in is the side that says, look at this clown. Look at this fool. We gave all the opportunities in the world in America for everybody to excel. We removed all of this and that. And now go, girl, go. Go get your education. You don't need no man. You're an independent woman. And if people don't understand what this really is, this is what Black men are going through, hey, every single day, dealing with the Black woman. I know somebody gonna get upset, but it's okay. Let me fix it for you. Hold on. Don't run. Please listen. The women that you're looking at right now, and I'll use the four women who are the judges and who are the, of New York, the AG and all. I'm going to use those four women. These are the very women that were utilized to get Biden in, or they were the cover. They were the cover for how he got in, because there's some other stuff behind the cover. But as usual, the Black woman got on her bracelets looking like almighty ISIS. And I said that, if you know, you know. Looking like almighty ISIS, blocking off everything that anybody could say about Biden. And as soon as he was elected in, didn't need him too much until now. What do? Pull back that shield and bring them right back out again, bring them right back in the forefront. And now all of them same type of Black women, the independent Black woman who don't need no man, she's strong, she can do it herself. If a man's not making over $100,000 a year, he ain't no good to me. And so you got all of these dumb dodos running around now that are not those four women, in the streets and in relationships with poor Black men. And what y'all seeing right now is what Black brothers go through. Dealing with a woman who's sneaky, conniving, because she got the money, she's the boss. She'll do whatever she can to make you look a little bit good so that her friends don't talk about her for having a cat that make less than. So she fashions something to give it to him. Just like a witch with a wheel, she fashions the man. After she fashions and makes him have enough money to compare, have enough money to compete, have enough money to be able to look like somebody on my arm when I'm walking through, coming in here to this banquet or gala. And the truth is that this woman, specifically Fani, threw the regular cat to the side. But look here, she was diddling both of them dudes. And you have been following, you know what I'm talking about. I'm talking about Duke the DJ, if that was his name, Deuce the DJ, and Baldy. Okay? But this is what the Black man has been dealing with, and it's giving everybody now the bird's eye view of women who are not submissive, of women who believe that they can be successful, be ruthless, and be just like everybody else is in government. But baby, here's your problem. You got a little too much melanin to try to keep up in that old boys network. And it's that mindset that's made you stick it out as long as you have. And now you got all of these people stupid enough to say, well, I don't care what Fani did. They just need to leave her alone. You heard what she said in church. They're after her because she's a Black woman. They already knew that what she was doing was right. They just want to dig and they just want to talk. They want to take the focus off Trump. Dumb. That's not the case. Everything that's done has a double entendre to it. This is not just for the Trump situation. This is actually showing people who we are. Because, see, most of us already knew what was going on in the very beginning. We could see when we first saw this, and by we, I mean the Melanated Collective. When we first saw this, we all knew, yeah, he might be hitting that. Yeah, that might be what it is. I don't know. We knew. But at the same token, I have heard over and over and over again, and I have read over and over and over again, where Black folk, women specifically in droves, are believing that this is a nothing burger, that there is nothing there. When if you look at the bottom of the case, and if you look at all the specifics, if you look at every single thing, it's tapestry, as it were. It's all woven in deceit. The entire thing is woven in deceit. And it's that we need to focus on, not all the ancillary crap that's being thrown at that. See, they're throwing enough to cover up that. And if we allow ourselves to get distracted, we will lose the bigger picture. While all of this is going on in mass, communities from Chicago all the way to different parts of Illinois, different parts of New York, all over Los Angeles, Detroit. You've even got Michigan, different parts of Michigan in there, different parts of Michigan, not just Detroit, but different areas where the preponderance of these individuals that are coming across the border and being flown in. We just had a story here where Biden, his administration admits that they flew close to, 200,000 people over time into the United States? Flew them in, illegal aliens flew them in the cover of night. But we all knew this because we were seeing underground stories last year that showed this very thing. Hey, wake up. They pulling them up in everywhere USA, but they starting in the less expensive neighborhoods. They starting in the Black folk neighborhood. They in the hood. You can go undetected in the hood for a little while. What you're seeing on the news, what you're seeing dealing with New York and all of that stuff is nothing compared to what the inner city is seeing. But the inner city don't have a voice. Why? Because you got people like Fani that's spending the money, that's in control of the money. You have people with that character. I hope you guys see the correlation of what I'm trying to weave together for you, what I'm trying to sew together for you. I hope you see it, because this is very vital. And this is what the United States is right now. But I said it before. I've been saying it for over the past 2 years, that they are using the Black community to subdue this nation, because they have made everybody feel guilty. If you white, you feel guilty. If you white, you feel guilty because you don't want nobody calling you racist. But look at what's happening. When you see something, you should have done their adage. See something, say something. Robert Smith says 320,000 flew in. 320,000 flew in. I live in the country, and they are here too. I hope you guys understand where I'm coming from, because I can't fake it, and I cannot lie to you. I can't lie to you. I won't lie to you. I won't use this opportunity or platform to lie to you. I am telling you the truth. These are the things that are going on. These are the things that are going on. And so when Fani went out of her way, let's recap what we're looking here, because they should be coming back very shortly. The Senate of Georgia, the Georgia Senate, they ask very pointed questions on purpose in a very relaxed environment. It almost made you feel like, when are they going to get to it? When are they going to get to it? They were getting to it just by asking general questions and having those answers come back. These were all attorneys. She was sitting in front of nothing but attorneys. These senators know exactly what they're doing. These senators know exactly what they're doing when they are asking those questions, when they're getting the answers, when they're putting it all together. And I'm going to tell you something. That ignorant speech that Fani Willis utilized in that church is actually going to be the nail that does it. It's going to be the nail that does it. It will be. There is the woman in, let's see, she is in Cobb County, and she's a Cobb County attorney. I want to pull that up so we can read that while we're waiting here for the next couple of minutes, because it will give us some good background in what happened. Oh, wait a minute. Is anybody here that remembers me saying I would not be surprised if Nathan Wade wrote his own divorce decree and made that guy, whatever his name, the Chubsters, word up, sign it? Do you guys remember that? Do you guys remember that? Did anybody here remember me saying that? Because it would appear that's what had happened. It would appear, based on what we're about to read, that that's what happened. Okay, so here we are. I'm going to pull this up. The prosecutor is a key witness. This is a day ago. This is from Atlanta First News. All right, here we go. I'm going to pull this up for you guys so that we can see this all together. You guys remember? Oh, hallelujah. So glad you do. I'm so glad you guys remember that, because, well, that's what it's going to show us. So we're going to read this together until they get back, and I still have it. So I'll let me go ahead. Let me click this to share it with you guys here. Here, share that. And then I'm going to go back over here so that I can still hear it. I'm going to unmute it. So you guys may hear some noise when it comes back. All right. So let me click this out. All right, folks. So, we're back. Oh, this was juicy. Hold on. Hold on. Let me give it back to you guys. They're back.
In his involvement in the case, as I recall, it began on November 1st of 21. So this would be out of his first bill. I see on November 5th, prepare case for pretrial, 24 hours on one day. What do you make of that?
I mean, I thought it was astonishing that, you didn't sleep for 24 hours. I've been to trial. I'm sorry. I've been to trial and had to work long hours, but 24 straight. But we did question him about that at the hearing, and he said that that's when it was concluded. So how he explained it was November 5th is when the work was concluded. And so he had done that work up until then, and that he only billed when it was concluded. So he said that the 24 hours, who knows when it spanned, but that how he billed was
would have had to be between November 3rd and November 5th, though, right? So it had to be on the 4th and the 5th, 12 hours a day.
It had to
at
be.
least.
And, the other thing that I noticed with this is prepared cases for pretrial. At this point, it says anti-corruption unit. His two law partners are the conflict lawyers for the anti-corruption unit. So you've got it's like my husband couldn't represent someone who's adverse to me. Like, my husband is my law partner. He can't be doing privilege review on a case I'm prosecuting. So he's consulting on anti-corruption cases for the DA's office, where his two law partners are doing the privilege review at the same time. That's one, that plus the 24 hours are the two things that really struck out to me.
So, but the only role he had was this prosecution of this election fraud.
Yes. Okay. Yes. The only role.
Okay. So when it says anti-corruption, that's the corruption. We're looking at election interference.
Yes. He's never worked on any other case.
All right. Let's see that other bill there, Senator Dolezal. All right. So here's another one. If you can see that, okay. This is the one we put up earlier. It looks to be much more specific date-wise anyway than just, those 24-hour chunks like that. Okay.
Right. I mean, it's more specific, but it doesn't say what, like, just for example, team meeting and argument prep. Argument prep for what? I mean, normally when we do bills, we would say, argue motion to dismiss or argue whatever the motion is. Research. What are you researching? Researching statutory privilege, whatever it is.
Yeah. Now this one, he shows date ranges when it's over multiple days, like down at the bottom, 426 to 427, 18 hours. Right. If I'm reading that right, or 16 hours. But on that previous one, he just has one date, 24 hours.
Yes.
Okay. And you say these are approved by Fani Willis. By contract, she has to approve these billings.
Yes, she does. Okay. And those are approved by her. So if there were any questions, and as a lawyer, when we submit bills to clients, they regularly question, and I know when I've done appointed work, they regularly question that as well. You have to list exactly what you're in court for, exactly what you're drafting. You can't just say prepared cases. You've got to say, what did you prepare? What did you draft? So, the county in Cobb County, for example, they make you actually attach motions. If you do like an appeal or something and you're billing for that, you have to actually attach it to prove that you did the work. I did go back at the break, though, and I have an answer to one of your questions earlier. I just wanted to clear up. You had asked me when the special purpose grand jury had convened. I looked, the state filed a response. So this is DA Willis's response that was filed on February 2nd. They wrote on
This response to your motion to disqualify?
Yes, sir.
Okay.
Response to my motion. On page 13, they wrote, shortly after his appointment in January 2022, District Attorney Willis petitioned the Chief Judge of the Superior Court to convene the Superior Court judges to consider her request for the special purpose grand jury, to conduct an investigation into the facts and circumstances relating directly or indirectly to the possible attempts to disrupt the lawful administration of the 2020 elections of the state of Georgia. And they attached that exhibit. So you had asked me earlier when she petitioned. So it was, in their own words, shortly after his appointment.
Okay. So this whole, the cases are about attempts to disrupt, because obviously Georgia certified Biden as the winner and he got inaugurated, that following January. And this is years later, we're having this whole investigation.
Yes, attempts. And my client specifically is charged with attempt and conspiracy. So he's not charged with actually doing a specific act. He's charged with conspiring or attempt, depending on which section you're talking about in the charges.
Some of these itemized statements show drafting.
Yes.
Did Mr. Wade draft any documents to your knowledge, or
No.
prepare any legal documents at all?
No, not that I'm aware of. And that
Did
would
he
be
sign any pleadings as if he was the drafting attorney?
no, and he's not the one that usually files them. Will Wooten is the one that usually does the filing. There's two other prosecutors that also do it. Alex, and I don't want to butcher his last name, starts with a B, but he does it. And then Grant Rude. Anna Cross has also filed pleadings, but not Mr. Wade.
In your review of all of his billings, did you ever see where any of his time or bills were cut or reduced by whoever was reviewing them and approving them, either Ms. Willis or her deputy?
No, I never saw any questions. And her response or their office's response doesn't indicate that was ever done either.
And your experience when you were doing like your public defender work, that you were reviewed and they cut your time?
Oh my gosh, yes. Yeah, when I first left the public defender, I had a couple clients that were in the appeal process, because I was at that point, I was in the appeals division when I left, and I didn't want their cases to linger, and I didn't want a new lawyer to have to kind of just, pick up right when they were going to the, appellate courts. So I kept some of them. Some of them the judges appointed me, and so I would be paid, I think it was $50 an hour, $45 an hour, something like that. And then some I just took pro bono, but I had to get those bills approved. I mean, they were regularly cut.
On Mr. Wade's contract, he was allowed to bill, he was capped. He could not bill more than $35,000 in any given month.
Yes.
Okay.
And that was not, so the original contract before the special purpose grand jury was started was a lower cap. This was the cap for the majority of his work during the special purpose grand jury and then now. So he had a contract November 1st, 2021 up until October 31st, 2021. And the cap was lower for that. Then there was a period of, I think it's 15 or 16 days where he did not have a contract. Which also happened to be one of the times they were out of town. But so they re-upped the contract November 15th, and then it had a cap, but the cap was significantly higher. I mean, I don't remember the first cap, but it was not 35,000.
Here is a document you produced. I think you prepared this summary that shows all the payments that he received.
Either I did this or this might have come from Fulton County purchasing.
All right.
Okay.
So that was produced to you from Fulton County as
Yes.
all the payments he received?
Yes, this was produced from Fulton County, yes.
And what's the total? Is that just my eyes aren't so good. That looks like 22 all the way through 23.
Yes, 22 through 23. So, and so his first bill would have been paid in January of 2022. So he billed for time in November, December, and then you see those two bills. And so those were $15,000. I believe that was the cap. So in
Right.
January, he was paid for $15,000 for work in November, and then in December, he had work totaling $15,000, and he was paid for both of those in January.
That's why there's those top two invoices for 15,000.
Yes, that's why there's those top two invoices. And they produced some other documents to me as well that showed which funds they came out of. So I was able to track which ones came from state seizure money and then which ones came from county general fund.
And that was all before this grand jury was even approved.
The grand jury was not approved until June of 2022.
Okay, it was requested in January.
It was, and I just looked that up at the break. So it was requested in January. It was approved in June, the order actually. But what happened was they started picking. So it looks like they started picking the grand jurors on May 2nd of 2022. And they actually started hearing evidence June 1st of 2022.
Okay, so lots of this time was way before he would have been having to question any witnesses or attend grand jury hearings or anything.
Yes, he could not have attended a grand jury hearing until at the earliest May 2nd.
You were talking about the experience and expertise of the three outside, I'm gonna call them outside counsel, because they were not direct employees of the DA's office.
Correct.
Had Mr. Wade ever tried a felony case, prosecuted a felony case before this, to your knowledge?
No, that he has never prosecuted a felony case. And I asked his law partner that, who had been his law partner for some time, that he had never prosecuted that. I also did some independent research in the metro areas where I knew that he had worked in Cobb County. So I looked to see if he had ever been filed as a prosecutor in Cobb County for felonies. And he was actually just a solicitor, and solicitors is, because you said not everybody may understand the difference between solicitors and district attorneys.
We've got an ex-solicitor on this panel, so don't say anything negative about him.
So he can tell you all about it.
They prosecute misdemeanors only, right?
Yes, and in
Okay.
Cobb County specifically, they prosecute misdemeanors, yes.
Okay. It looks like he's pretty much hitting the maximum that he was allowed to under his contract.
Yes, most months he did.
Okay. And this is through that block billing that was not specifically itemized exactly what he was doing or how much time on each task.
Always block billed. He never itemized bills, never was specific.
What were the caps for the other two special counsel? Were they also limited? I assume you've received their contracts, or did they have a written contract?
They did. So they had written contracts, and I do have those, and they did have caps. They were significantly lower than Mr. Wade's. They do not currently have contracts. And I just found that out at a hearing because we had asked for that. We had asked for it in open records, and then I had subpoenaed it as well. Pretty much every subpoena I filed for the hearing, the state filed a motion to quash, including this one. And Ms. Cross was at the hearing, and she said, I can just tell you right now, I don't have a contract. So I had thought, I was under the impression that they just weren't giving me that contract. I had no idea that they just didn't have one. So apparently right now, Mr. Floyd and Ms. Cross don't have contracts.
Do you think that was intentional so that they don't have to disclose how much they're earning?
I think it was sloppy.
Yeah. Does Mr. Wade have a current contract?
Yes, he does. I also think it may have been, I don't know if it's disclosure, but I can tell you that they've changed since I started looking at this. They've changed what they put on the public documents. I used to be able to go to Open Checkbook and see every time he would get a check. And since I filed this, none of them have come up. So I don't know if he's not being paid anymore or if he hasn't filed any invoices, but the invoices are due, I believe, 30 days after. So, they regularly came up, but now all of a sudden they don't.
Okay. So eventually you sought to disqualify Ms. Willis from serving as counsel and prosecuting Mr. Roman's case.
I did.
Okay. Can you pull up that motion? That motion was filed here in January. I think it was January 8th of 2024.
Yes.
What was your motion to disqualify based on?
It was based on a number of things, but it was based on mostly the fact that Miss Willis and Mr. Wade had a romantic relationship, and they had been traveling, and he had been paying for a lot of that travel. So there were a couple different things. She had not followed the statute. So the statute I referenced earlier, 15-18-20, said that you had to have county approval. She didn't have that. So that was one thing. There were also—
You had figured that out through your financial records?
Yes, I had figured that out through my financial records, through open records, through reviewing all the Board of County Commissioners. And I actually, to that motion, I attached, just on this issue, I actually attached a document showing how independent special counsel would normally be appointed. I'm sorry, special counsel, because I found one where, and I think it's exhibit, let's see. It's exhibit J. I found one where Fulton County had actually been asked to approve a line item for an independent contractor agreement. And so this, I used it as an example of what normally would happen.
Was that for an attorney?
It was for an attorney.
So she's saying in pleadings now that she's not required to get county approval, but in the past, for people other than Wade, she had gotten approval?
This is actually the county attorney. So
Okay.
This document is the county attorney. I do not believe she's ever gotten approval for anybody. And her filing said she's doesn't. I mean, her filing, I at the break, I was looking at it. I mean, she said that that I incorrectly contend that the appointment exercised by, and in parentheses, a state constitutional officer must be followed by an approval of the local government's Board of Commissioners. And she says over and over again that I'm just wrong, that she doesn't have to because she's a state constitutional officer. So that was their position, that she doesn't have to.
So is that one of the grounds for your motion to disqualify these, let's just call them financial irregularities, that she had not complied with the state law or county policy of getting prior approval?
Yes, that was one of the primary bases. But then I also reviewed case law and saw, the conflict of interest. And, our motion, the theory, basically just to sum up the motion, is that essentially he's getting paid all of this money and they're not going through the proper procedures. And I go through it in the motion. I talk about how he didn't file an oath, which is rare. I'm one of those.
Didn't follow what?
He didn't file an oath of office. And I'm one of those people that I always, when I first start a case, I always make sure that everything is all the I's are dotted and the T's are crossed. So I always pull that. Anytime I've only ever had special counsel twice, and it's been people who were not paid, who were district attorneys in other jurisdictions who took the case on, which is the normal process in the state. But I've always pulled that just to see that they're sworn. That's something that's important to me. And I couldn't find it. So I did open records to the probate court, to the Superior Court, and there was no oath of office filed.
Sworn for the special assistant district attorney?
Yes. If you're going to be inside of a grand juries are highly regulated. I can't just go in a grand jury. None of us can just go into a grand jury. So you have to be a sworn officer of the state to actually be in there, particularly to present evidence. And so I wanted to see if he had taken an oath. And that's something that, you would file. It should be publicly available, not something that's really, highly contentious or secret. And there wasn't one. So, once I learned that, I was like, why are they not filing an oath? This is odd. There's no public approval of these contracts. There's no oath of office filed. This is different. What's going on? We later found out that he had taken an oath, but nobody had filed it,
Okay.
and the law requires, there's a statute that requires you actually file it.
I have looked at that. So the statute for a district attorney, their oath, when they are sworn in that position, says, I do swear that I will faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney and will only take my lawful compensation.
Yes.
So help me God. Did Ms. Willis sign her oath that swore she would not take any unlawful compensation?
Yes, she did that. And then she also filed some disclosure forms that are required. There's financial disclosure forms that Fulton County requires that you file every year. And you have to disclose if you've received any gift over $100. So from anybody doing business with the county. And Fulton County is I used to be a Fulton County employee. They are very strict on those types of things. So anytime there's anything that could be construed as a gift over $100. And I've gone to lunch with prosecutors before who wouldn't let me pay for lunch because they're like, what if it's over $100? So people do take that pretty seriously.
So that would apply to Ms. Willis would not be allowed to receive gifts from whom?
From anybody who was, and I actually believe I attached it as an exhibit. It's basically anybody who is doing business or seeking to do business with Fulton County.
Okay.
So, and it's one of
That would
those.
include Mr. Wade, obviously, then?
Oh, definitely.
Okay.
And that makes sense because that's one of those provisions that's supposed to, be guarding against honest services.
Like anti-kickback statute.
That's exactly what
Hire
it's based on.
somebody as a vendor and they give you gifts in exchange.
Yes. And so they require that you disclose that every year. It's signed under oath. You have to file it with Fulton County.
So how'd you learn about this relationship between Mr. Wade? I think this has been acknowledged now by both parties, correct?
It has, yes.
It's a dispute as to when it began, but it's acknowledged that they had I don't know if they still do, but at least had a romantic relationship.
Yes, that's
How'd
not.
you figure that out? How'd you find out?
So at first, I knew Mr. Wade and I knew Miss Willis, and a lot of people in the community were a little surprised to see Nathan, Mr. Wade handling this case. It was just a lot of people said that, and so a lot of people were talking about that, and it was kind of surprising because it's not really, he does a lot of law practice, but this isn't what you would imagine him doing.
Did you ever see him have other billings? I mean, how do you have time to represent anybody else when he's billing, 24 hours a day to Fulton County?
He had other people working for him. Like he had a law student working for him for a while, and then he had a first-year associate. So I'm assuming that they would probably do whatever other work he had.
Did you ever look at his calendar? Did you have access to that to see if it matched up?
No, I didn't have access to his calendar, and I didn't have access to their text messages. I mean, I was able to get his geolocation data through subpoena, but the one thing that really struck me is if I was accused of something and I was saying I didn't do it, I would download my phone. They have a system. It's called Celebrate, and Fulton County pays for it. City of Atlanta pays for it. It's literally a system that you can hook your phone into. I have an investigator that has it, and I have my clients do it all the time. You hook your phone up, and it can find deleted text. It can find everything, and you can limit it. You can say, I only want text with this person. So if I was being accused of having an affair with someone, and I said it didn't start until April, and someone else said it started in October, the easiest thing to do is to, download that phone. And for privacy concerns, you can file it under seal, but you could easily narrow it down and say, I want this timeline. I want all of our texts from, November 2021. And it would easily tell whether or not they were romantic in nature.
Before I leave the billing issues, did you ever compare Floyd and Cross's bills to Wade's to see if they were meeting together? Like there was that meeting with teams or what? Were they billing for the same meetings as well?
So I looked at that. One thing is we don't have most of Floyd's. So Floyd has not billed in quite some time. So I didn't have his to compare, but I did look at Anna Cross's. The one day that I remember looking at was when they were in federal court to see, because so Ms. Cross was the one actually litigating in federal court. But Mr. Wade was sitting there with them at counsel table, and they both billed for that. I wanted to see if he billed for time that he was sitting in court waiting, because I know in Cobb County, for example, with appointed work, if we're sitting in court waiting, we can't bill unless we're actually doing something. Like they won't pay for two people to sit there. And so I wanted to look at that, but they were both there in court that day.
What about the teams meeting where he billed for? Were either of them involved in that team since they're also outside special counsel?
No, they were not. So all of those people were people who would not have itemized that.
Okay.
Employees.
Right. Back to your uncovering the relationship.
Yes.
How did you figure it out?
So Terrence Bradley was Nathan Wade's law partner originally, and he was also his lawyer in the divorce. I did not at the time know that they had filed for divorce. I knew Nathan's wife. I knew both of them historically from Cobb County. I mean, they're, people knew them in Cobb County. Mr. Bradley actually called me after an article. We were looking into the financial irregularities. We're looking into how much money had been paid, because everybody in the case was kind of like, what, why do you have special counsel on this case? Yeah. Like,
was
why
Bradley still a partner with Wade at that time?
He was not. There was testimony that their partnership ended in summer of 2023. So it had just ended, is my understanding. And it's, it's kind of unclear, like what month. The testimony is very unclear as to when they actually, I have when they dissolved. I think it was September, but it's very unclear as to their partnership. And I will say their partnership was a loose partnership. They had a partnership with the bar, but they all had separate legal entities. So each of them were filed as the law office of Terrence Bradley, law office of Nathan Wade. They had some joint bank accounts, but then they had some separate bank accounts. So I don't really know the exact structure. It was a very loose type of organization, but they were working together. And so Terrence actually called me. He had seen an article where I had done open records with another lawyer, Manny Aurora, and we had uncovered how much money everybody had made. The news had gotten wind of that, and I later learned that the news had open records to get all of my open records. So every time I would get something, the news would get it, because I wondered how that happened. But so that somebody published that, and I had done some more open records. And Miss Willis actually called Mr. Bradley when I did these open records and said, they're looking into us. And he called me because he was worried about it. And so we had a conversation, and he actually asked me, do I need a lawyer? What's going on? What are you investigating? What's the parameters of this? And we had a conversation. And I said, well, my interests are different than yours. I represent Mr. Roman, so I can't advise you. That would be a conflict. He asked if John, my husband, could. And I said, no, that's a conflict too. If you feel like you need somebody, you need to talk to someone else. At the time, that was early in September. I had court in Cobb County, and I ran into Mr. Bradley. I was in Judge Harris's courtroom. I think it was either September 11th or 13th. I checked my calendar a week or so ago, but it was one of those dates. And I was taking a plea in front of Judge Harris, and Mr. Bradley was also there. Another lawyer who ultimately represented Mr. Bradley at our hearing, B.C. Chopra, he was there in court also. And then a friend of all of ours who's a district attorney, his name is Bert Cohen, he was taking the plea with me. And Bert and I have known each other for a long time. Terrence, BC, everybody's known each other for a long time. We were all sitting in a conference room attached to that courtroom, waiting for the pleas, chit-chatting, took the plea, went back in, and Mr. Bradley essentially went through the whole thing and said, well, this is what's really happening. I had a notepad, and I took notes on all the things to ask for open records.
So what did he say was really happening when he said, this is what's happening?
He said that they met at a judicial conference before. He was very specific that it was before she became DA, because that was one of the things that he couldn't remember when the judicial conference was, but he knew that it was before she became DA.
When did she become DA?
She became DA in it would have been January 2021.
Okay.
So she became DA January 1st, 2021, but she had a transition team leading up to that. So, and Mr. Wade was in charge of her transition team. So Mr. Bradley told me all of that. We met for about an hour. Said that they had been together. They met at this conference. Nathan was still married. And Mr. Bradley was upset because of what happened in the divorce. He was upset because they were still married, the Wades were still married, and he essentially just left her after meeting Miss Willis and dropping the kids off at college. So,
and Bradley was Wade's attorney in that divorce action you're talking about? Okay.
Yes, I didn't know that at the time.
But they were law partners.
They had been,
Okay.
yes.
Okay.
And I actually don't know if he was still his attorney when he talked to me. I don't know if he was or not.
All right.
Because at some point, Mr. Wade
That
represented
is
himself, and then he hired a
telling.
different lawyer. So I didn't know anything about the divorce at
Okay.
that time.
So Bradley did not like the way Wade had treated his wife,
He did not.
but he
did not.
represented him.
He did not like the
Okay.
way he had treated his wife. He didn't like what was happening in the divorce proceeding. Yes.
Okay.
And I mean, I remember specifically him saying, I handle my business, things like that. Like, that I don't leave my wife without alimony, because this, and we talked about it. I mean, Miss Wade had been a stay-at-home mom for, they'd been married almost 30 years. And literally it was right after they dropped their youngest off at college that he said, move out,
Oh my God.
And so we went through, I was obviously interested in, wait, what's happening? Walk me through this. And so he was telling me about the access cards, that Mr. Wade had access cards, telling me about the contracts, told me about their contract, that they had that Nathan had brought them the contract for the first appearance hearings. They had a contract for that. We didn't talk about that yet. That they had the contract for the taint work, and then ultimately that Nathan was hired as the attorney on this case. That they had been dating before, and he told me, they met at hotels. He would go to her place. And I remember him saying, you need to find her bestie who they had a falling out. That's the person whose condo it was that they would meet at. And
did you later determine who that bestie was?
Yes, it was Robin Yeardy. It was not until sometime later that I determined that. It was very difficult to determine who that was, because he did not remember her name.
But he knew her by sight.
He did.
Did he later confirm to you or identify who she was?
Yes. So I had sent him a couple pictures, or showed him a couple pictures of some other folks or
This
names.
was in January of 2024, right
Yes.
before your motion?
It was. It may have even been after I filed the motion. It was around the time. It was either before or around the time, but it was in January. I had gotten some open records requests from the DA's office.
Wow.
They had a contract.
This is amazing.
Yep.
We just put on the screen
There it is.
some of
Perfect.
the text messages that you produced to us.
Yes.
This
yes.
is from your phone.
It is. And
And
so
you're talking to Terrence Bradley, I see over there on the left.
yes. And so when you see on the 14th, that one that's right in the middle that says file attachment with MIME type, that
Yes.
is a picture of her. So it doesn't show up on this, but it's actually, there's a picture of
So
Miss
while
Yeardy.
you're texting, you're shooting him a picture to see if he can identify Robin Yeardy.
Yes. Yes.
Did he identify her?
He did. Yes. He said, yes, that's her. That's the East Point. And he thought the apartment was in East Point. I later found out it was in Hapeville.
Sonia Allen
Those are
affair?
very
Right.
close in close areas.
So he knew they would meet at that
There
apartment?
was an
He did.
affair.
Yes. He knew all
Okay.
about it. And it was hard to find Miss Yeardy. What happened, and she was Robin Bryant, and then she got married and was Yeardy. I did an open records request for a contract that the DA's office got. It's called critical mention. She has I guess he's an attorney, but he's sort of in charge of communications. His name is Jeff DeSantis. Right after Ms. Willis had opened the investigation in this case, that same week, he contracted a company called Critical Mention, which is a media monitoring company. They put a dollar figure basically on your media presence, and they give you these analytical reports. And they say, hey, you did great on MSNBC. That's $1 million worth of, stuff for your brand. The Fani Willis brand is doing well, or this phrase is doing well, things like that.
She had an employee in her office that was responsible for promoting her image, her publicity.
She had a publicly funded contract for this. So Jeff DeSantis contracted or called this company, and it's in the emails. I think I provided those as well, but contacted Critical Mention and said, we need to hire you to do media monitoring. And it was the same week that she had sent the letter to Raffensperger and Kemp about this case. Said, we need to have a contract to do media monitoring. Got $10,000 approved, paid $10,000 for a year contract for an annual contract.
Who approved that?
Jeff DeSantis's email said the county approved it, and his emails indicated that it was hard to get approved, that he had to really push, I think is what he said. There's some language to that, but the county paid for it.
Do other DAs do that?
I'd never even heard of media monitoring. I didn't even know it
Yeah.
existed. No, it was very shocking. But so I got some of the emails about this media monitoring. So I did open records, and again, once I got them, they shut me down and wouldn't give me anything else. But so these emails have attachments, they're PDFs, and you can see in the emails the hyperlink to them where you can actually see the analytical reports. That's what I wanted to get, and obviously nobody would give those to me. But these emails showed a trail where two people in her office, so Miss Willis, Mr. DeSantis, and then Robin Yeardy, were the ones that had access to this critical mention profile. It's a platform that you can log into and see, how am I doing in the media.
What was Robin Yeardy's role in the DA's office?
She was a liaison between the news organizations. So she said that when CNN, MSNBC wanted her on, they would call Robin and she would coordinate it. She would do her hair and makeup, and then she would coordinate her interviews. But so how I found Robin was I'm going through these emails, and all of a sudden I see an email from Mr. DeSantis saying, take Robin off of this account. She's no longer with the office. And I was like, oh, I wonder if that's her. And so I found a picture of her and I asked Terrence, is that her? Because I found out she had been fired or been let go or had quit or whatever it was. And so that's how I was able to figure out who Robin Yeardy was. Then we were able to run her information, get an address. And that's how we were able to narrow down where this Hapeville condo was.
Okay, so that's where basically Miss Willis and Mr. Wade would meet for
Yes.
their relationship.
Yes.
Yeah.
But Mr. Bradley told me at that first meeting that they would meet at hotels. He told me about a lot of travel. I mean, he detailed, he detailed a lot of stuff. He said that they traveled to Texas, they traveled to Florida, just, a lot of different travel. He said Belize. He specifically said Belize, a cruise, the Bahamas, things like that.
And you were later able to verify that through other subpoenas or open records request or whatever?
Yes, I was. I was able to, I subpoenaed bank records, I subpoenaed credit card records, and then I actually subpoenaed the travel agencies that Mr. Wade used for some of those trips. He used two of the cruises that they took, he used a travel agency. So there was a cruise to the Bahamas I got through a travel agency. There was a trip to Aruba that I got through the travel agency. And then there was another cruise, I think that one was to the Bahamas also, that I got through a different travel agency. And then his credit cards are the ones that showed all the Belize trips.
And they showed that he was buying the tickets for both himself and Miss Willis.
Oh, yes, the credit card statements. So because I guess he used a travel agency, his credit card statements actually had her name and seat number and all that on it.
Okay.
So, I mean, there was no disputing.
Clear it was paid for by him on his credit cards?
Yes. Oh, yes.
Is this the document you gave us from the Capital One there?
It is. Yes. And there you can see. So Clara Bowman is Mr. Wade's mom. So this was the cruise that happened October 31st, around that date. Mr. Wade paid for Miss Willis, Mr. Wade, and then his mother's plane tickets, and then also their cruise receipt. I think that one was Royal Caribbean.
Okay. So your summary here showing the trips, we know that in late October, they took a cruise to the Bahamas, and this is from his financial records. He paid for this for both tickets.
Yes, this is from his financial records. And I tried to be, there were a lot of Ubers and things like that. I did not include things like that, I wasn't positive. I wanted to be under-inclusive, not over-inclusive.
Right. And then you show the trip to Aruba, another one to Bahamas, one to Belize, one to Napa Valley, California. Yes. These are all from October 22 up till May of 23.
Yes.
Okay. This is a document you produced us?
Yes.
This summary, is this something we prepared?
No, it's a summary.
Okay. And so you discovered that and verified its accuracy through these credit card receipts, et cetera?
Yes. Oh, yes.
Okay. Do either of them deny these trips occurred?
No, not at all.
So is this the impropriety, the financial impropriety of getting financial benefit from the job that he's paying for her way on these trips with money?
Yes.
That she's paying him and approving? This
is what I would call undisputed. Some of the other stuff on his credit cards, it looks like there's trips to Charlotte and Florida and other things like that. But this is what we could undisputed say was with Miss Willis.
We are learning things we did not hear.
Back to
we wanted.
You're a good investigative reporter here. So you have heard these rumors, and now Mr. Bradley, just by almost happenstance, you're with him in court.
Yes.
And he spills the beans on it and verifies it. Then you go get the documents to prove it's accurate.
Yes.
And you identify year to get him to say, yeah, that's the woman whose condominium they would go to?
Yes.
Okay.
And I developed it. You joke about my investigative skills. I've done public defense most of my career, at some point or another at pro bono. It's hard to get money for investigators. So I've learned how to do a lot of it on my own. I dig a lot on things. So, and I do like to use the Open Records Act. So I was able to do that and get a lot of information. But what I did was I compiled all of the information Mr. Bradley gave me, and then I did various open records requests based on it. And then, once I would get something, I would reach out to him to verify, because I wanted to make sure that I wasn't tracking anything that was wrong. Yeah. I didn't want to make any allegations that didn't have support. So I would regularly verify with him. And I'd see him in court. We talked on the phone several times. I wasn't the only person that he told about this. There was another attorney on the case, Manny Aurora, who his client ultimately pled out. So he didn't continue this investigation, but he was involved in the investigation early on. And Mr. Bradley told him some of the same things that he told me. So, I was able to independently verify a lot of things, which to me, investigating is important, that the East Point location, that it was in Hateville. Robin Yeardy actually did quit. Mr. Bradley had told me.
Was she forced to quit, or what? How'd that come
about?
No,
I don't believe she was forced to quit. That was a point of contention in our hearing. She said she left, that she was sent to another division. It's my understanding she had some, she was outspoken about, she didn't like some of the things that was happening in that office. And when she voiced that, she was sent to a different department to work, and it wasn't something that she wanted to do, because she did the communications. And so she quit after that, is my understanding.
Okay.
Based on her testimony and, the allegations and all the pleadings.
All right. So after, I might be skipping parts of your investigation because it's pretty darn thorough, and you had gotten this Trackhawk, Cell Hawk, what's it called, where you're tracking the location. You were mentioning to me earlier when I kind of got you off that employees can have it on their own phone if they want to, and she could have gone back and proven that they had not been communicating before he was hired.
Yes.
Yeah.
So let me explain that, because there's two different systems, and I'm always learning new things about this. But cell phone data is one of the new things in criminal defense. We see it in a lot of cases. The CellHawk data that you just showed, that is geolocation data. That is different from the Cellbrite. So there's two different programs. CellHawk is the program that does geolocation data. Essentially what you do is you get all of the pings. So every time your phone, you see those cell phone towers everywhere. Every time you use your phone, it's trying to find the closest tower. So in a metro area like this, there's a lot of towers. That's why we get good signals. So when he's in Hapeville, there's a lot of towers. So we can really, really narrow it down. So what we had our investigator do, and I'm only talking about the geolocation stuff. I'll talk about the text in a minute. But what we had our investigator do was narrow it down. We got all the raw data and we had him narrow down, and we actually excluded a ton of things that were not right on top of this location. Like, we wanted to be very, very careful just to have what was literally right on top of this location. So he created a geolocation fence, which—
The location you're talking about is Miss Yeardy's condo.
Yes,
Okay.
It is Miss Yeardy's condo, that area. So he was able to find, essentially, just to summarize a couple of things, where Mr. Wade would call Miss Willis at midnight, something like that. And then all of a sudden his phone would travel, and you can actually watch it. When you do the live CellHawk, the app, it's pretty cool. You can actually watch the phone travel, and it's pinging because you're using it. If you have an app open, your phone's pinging. So my phone's pinging right now because I'm sure I have an app open. So it's pinging from his house all the way down to the condo at midnight, 1 a.m. And he calls her when he gets there. And then it goes silent for 4 or 5 hours. And then, early in the morning hours, he starts pinging again, driving back, and then he texts her when he gets home. So,
and this is before he gets hired in November of 21.
Yes.
Okay.
So, and there's a couple different ones, and I would defer to the experts on the CellHawk data, but that's the summaries based on what we had him do. And again, we tried to be very, very narrow. There were a lot of dates that it looked like it happened also, but maybe he was bouncing off a different location, and so we wanted to be very narrow.
So is that why y'all asked him in the hearing, how many times had you been to this you already kind of had the data on him?
Well, so that's an interesting point. All we have as defense lawyers is the right to subpoena evidence. I have to have an evidentiary hearing to do that. I could not issue a subpoena for AT&T for this evidence until I had a hearing date. So, and it takes a while to get this stuff. We got it that morning. So, the morning of the hearing, and obviously I'm kind of busy doing the hearing, we got that data. My paralegal was literally trying to download it for the investigator at the time and get it over. We knew we had the data, but we didn't know what it showed. So at that time, we didn't know, what it showed really until he was able to do the analysis. We had some preliminary reports from him, but nothing. It took a lot of hours. It's a lot of data. So it takes a lot of time to pinpoint this information. Yeah. But the other thing that I was talking about, so this is the CellHawk report, and heat map is just like how many times it's pinging, heavy concentration is, you're talking a lot at this time, or you're at that location a lot. There's a lot of usage. The other thing I was talking about, just to make sure it's clear, so that's CellHawk. Cellbrite is a different program. Cellbrite, and it's CELLEBRITE. Cellbrite is a program similar to CellHawk, but it downloads data in the phone. So like this one is you pinging off of towers. It's geolocation.
Showing where you were.
Exactly.
At a certain time.
Cellbrite actually can get your texts, your pictures, your app usage. All of that stuff. So it's one of those things that if a defendant is threatening someone by text and they delete it, they'll take their phone and hook it up to Cellbrite. Cellbrite it makes what's called a forensic copy of the phone, but you can also limit the data. So it's very expensive program. So not a lot of people have it. So when I have my clients use it, costs a lot of money for them to have it done, but the DA's office has it. They have the software, they pay for it. You can find that in their open checkbook. The city of Atlanta police have it as well. But what you can do is you can copy cell phone. So, what I had mentioned earlier is
you have to have the cell phone to do that?
You do. You have to have the cell phone.
So what did Mr. Bradley give y'all his cell phone? Or
No.
how'd you get Mr. Wade's cell phone?
So we did not get that data from Mr. Wade. So we only got the geolocation data from Mr. Wade. I do not have the power to get the text messages. I don't have that power. I would have to have a search warrant. The state's the only one that has the power to actually get someone's text messages out of their phone. But my whole point in saying that was if I had been accused of having an affair and it didn't start, and I said it started in April and someone else said it started in November, they have the ability. I don't have the ability. They have the ability to plug that phone into the Cellbrite and print out a report that shows all of the texts.
So Mr. Wade and Ms. Willis, had they wanted to disprove your allegations, could have just used that Cellbrite program and it would have shown no communications between them.
Yes. And it would have also showed the contents of the text. If the texts are romantic, if they're not romantic, if they're friendly, and they would control the data. So if there's something that was privileged, they could redact it. If there was something that, if they wanted to only limit it to we want to prove that we weren't talking romantically in November, they could limit it. So they could
have actually pulled up the text itself to say, hey, I need you to help me work on this case, or else, hey, I need you to meet me at the Love Nest.
Yes, 100%. Yes. I don't have that ability. So I don't have the ability to get a search warrant and get that data. All I have the ability to do is get that geofencing.
Well, who found out about these 12,000 texts and calls and all that kind of stuff?
That is what I was able to get by subpoena. So I was able to get the geolocation data by subpoena. What I can't get is what's inside of the phone. I can't get the texts inside the phone.
The words in the text.
Exactly.
But you were able to find out that they were texting each other.
Oh, yeah.
Prior to November 1st of 21.
Yes.
How did you find that data? Is that anything you've produced to us?
That is the CellHawk data actually analyzes that. So you can see, and we just summarized 2021. So approximately 12,000 interactions, that's voice and texts for the year of 2021. And again, remember 2021, he didn't get the contract until November of that year. So most of 2021, he's not under contract. Over 2,000 voice calls, almost 10,000 text messages.
How did they explain that? Did you confront? We're not privy to what all came out in evidence at the hearings that you've had. Did you get either one of them to say, that's not true, we didn't really talk 12,000 times? Or
no, what they did was they filed an affidavit saying that geolocation data is not always reliable.
Okay. Does that apply to Cellbrite data though?
No, it doesn't. And it was ironic because I have a number of cases. I mean, almost every murder case I've had in the last decade has had geolocation data.
Used by the prosecution against the defendant, right?
They use CellHawk data. I mean, literally, they're using this right now. So our investigator actually analyzed the same. There's a trial going on. It's called the YSL trial. There's this same data being used in that trial. And our investigator actually analyzed it for them in that case. So, I mean.
For them, you mean for the Fulton County DA's office?
No, for the defense looking at that data. So the point is, they're currently using the same data in another courtroom to prosecute someone, but their defense in our case was that it's not reliable.
So then they got to throw it out of the other one.
Got it.
I think.
The existence of the cell phone calls?
No. So the Cellbrite data, that would have to be voluntary on part of the DA to actually
So they could show you that to disprove your allegations?
100%.
Okay, didn't do it?
No.
Neither Wade nor Willis?
No.
Okay. All right, so you've done your investigation. You've determined you think there was a relationship that had begun before he was hired.
Yes.
And after having met with Mr. Bradley, you began to prepare a motion to disqualify and to dismiss the case altogether, right?
Yes, I actually started the motion in September
cell phone
and then added to it.
Messages. All right, and so then you somehow preserved, you had text communications with Mr. Bradley to confirm this?
Yes.
And was that because you didn't want to file a pleading that was inaccurate?
100%.
You wanted him to verify the accuracy of what you were claiming had happened?
I did not want to say one word that had not been verified.
Because he was the source.
Yes.
He's the guy that was his law partner and his divorce attorney.
Yes.
Who probably knew as well as anybody in the state.
They had been best friends also.
Okay. All right. And so let's pull these up, Senator Dolezal. When did you start? You kept these text messages somehow?
I did. So I actually, Mr. Bradley uses a Android, I believe. And so it was not easy to just download them. And I'm not the most tech savvy person. There's a lot of texts that just went into things that I thought would just embarrass people and weren't relevant. So what I did was I screenshotted the texts that I thought were relevant. I tried to use those in court, but the prosecutor kept objecting and saying I was hiding things because I wasn't showing all of my text. So they just kept on and on for days saying I was hiding things. And I explained to them, I let them look through my phone. They scrolled through all my texts.
Who's they?
It was Adam Abate was the prosecutor.
Okay.
So he just kept saying, that where's the beginning of that text? Where's the thing after that? Where's the other part of that text? These aren't complete, rule of completeness, kept objecting. And I had just screenshotted the texts that I thought were highly relevant, but weren't slanderous, I guess. I don't even know the word, but there were some that Miss Willis's daughter had failed out, like things like that. They were just ugly. They didn't need to be admitted.
Oh, yeah, I read that.
So I had tried really hard to just screenshot the relevant ones, but they kept saying that I was hiding stuff and I wasn't showing the whole thing. So when they objected to my text coming in the screenshots, they said they wanted the whole text chain, and the judge ordered me to, if I was going to admit the text, to go figure out a way to download all of them. So I bought a program for $20-$30 and took 3 hours. And I was very proud of myself for finally figuring out how to do it. But I was able to make a copy of it and then redact our phone numbers. So this actually showed like when they're read, when they're viewed.
What were you, all right, so up there on January 5th at 9:50 a.m.
Mm-hmm.
You're asking, what do you, read the question.
So I'm asking him, do you think it started before she hired him?
You're talking about the affair.
Yes, the affair.
And what's his response?
His response was absolutely. It started when she left the DA's office and was judge in South Fulton. And so, these are things that he had told me, but I was getting ready to file. My filing deadline was the 8th. And as we're doing this, I'm fact checking line by line, basically.
Right. So did you send him a copy of your proposed motion?
I did. And I actually admitted, so at the hearing that we had, I was able to admit the email where I sent him that. So I sent him a copy of the motion that weekend when I was I wanted him to review it. And then he had a text. He didn't write me back by email, but I submitted my email so that the court could see exactly when I sent it and when he responded. And then he responded that everything looked good. Because I asked, I said, I'm sending you this motion. I need you to look at it. And then he responded that everything looked good in it. Right. He actually told me at first he wanted me to make some changes because I had not included the information about how much money he had received. I had only included the information about how much Wade had received. And, I didn't know that it wasn't really highly relevant to my motion. But he was like, oh, that's going to tip them off that I'm talking to you. And he did not want anybody to know that he was talking. He was very concerned about what.
I'm going to let you just read through this chain.
Okay.
All right. We left off up there. Absolutely. It began when she was a judge in South Fulton. When was she a judge in South Fulton? She
became a judge in August of 2019. And I did an open records. I first asked, I first did an open records and they said no. So then I subpoenaed the records for the judicial conference, the municipal court conference.
So she was a municipal court judge.
They were both municipal court judges. So I got the
both? You mean Wade was the judge at the time also?
Wade was a judge. He was actually a speaker on the panel. It was October 2019. So I found online an old agenda where he was speaking, and Terrence Bradley had told me that they met at a conference where Wade was speaking and Willis had gone. So I knew that. So and it was in person. So I could narrow it down because of COVID. I figured out when COVID happened and when, all the conferences went virtual, narrowed down my timeline. So I searched for this specific time period, which is when Bradley had told me the relationship started.
And when was that conference?
It was October 2019. Right. So I found the agenda for that. So then I reached out to the municipal court judges CLE group and said, here's an open records request. I would like a list of attendees because I wanted to verify Miss Willis went there because I was trying to fact check. And they said no. So I subpoenaed them and they gave it to me. I also subpoenaed.
Was she in attendance?
She was. Where
was that conference?
It was at Lake Lanier.
Okay.
I also did an open records request to the city of South Fulton because I know that they have to sign off if your judge is going to go to a conference. So I did an open records request to them to make sure that they had actually sent her to that. So I verified from 2 different sources that she attended that conference, and that matched what Mr. Bradley had told me.
All right. So is that a part-time job, a municipal court job, a judge?
Yes,
okay.
It is.
So Wade could continue practicing law and do that on the side.
So she was a full-time, but Wade is a part-time, and Wade only did maybe once or twice a month at most.
Okay.
Because he was in the city of Marietta. I mean, he was just he was a fill-in judge for that. That wasn't his.
Okay. So you narrowed it down to that's when the relationship began. Scroll through here for us, and I can't read that green.
Okay,
What's
okay.
the next? If you don't mind, just sort of
No,
read
of course.
us through.
It says, is this accurate? And this was again on
So when
January.
you're saying, is this accurate? You're going over this brief and saying, I'm about to swear this in court. Will you verify it's accurate?
Yes.
Okay.
So at that time I was going through the actual statement because I was trying to figure out how to say it, and so I said, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And he corrected me and said, no, it was municipal court.
You had said magistrate court and he said no.
Right.
Okay.
And I slipped up. I should have said municipal court. I knew that.
So you say thank you. What was his response after that? No, this is 12 something PM on January 5th as you're getting your pleading ready.
He said, you can't put where they met. Not many people know that. I might be one of only, not even Chris Campbell.
Chris Campbell was their other law partner.
Yes.
Okay.
And I did not disclose Mr. Bradley in my initial filing. I didn't until the state forced me to.
Why was he afraid to be disclosed? Just because of his relationship with Wade, or was he afraid of these people, or just didn't want to betray them, or what?
Multiple reasons. I mean, it's the district attorney in Fulton County. I didn't really want to go, file something against her. It's not exactly a fun position to be in. Also, I mean, they have a lot of mutual friends. I'm sure it wasn't a fun position to be in, to be outing a friend of yours, but the attacks, I mean, it's a small legal community.
Were you able to get this into court? Because Bradley, I saw some of his testimony, all of a sudden can't remember anything about anything now. Were you able to use this to impeach him and show that he did know precisely what happened and when?
Yes, and he changed his testimony somewhat. At first, when he first testified, that he had never discussed this with me. And
then you showed his text messages where y'all discussed it.
Well, at that point, I that caught me off guard. So, I didn't expect that. So then I pulled my text messages, and I had some screenshots of them just in case. And I told his lawyer, do you want to look at my text messages? And so then he later came back and testified that yes, he had.
Had told you that.
Yes.
Okay. And did Wade testify at any of these hearings?
He did.
Did he acknowledge the relationship or not?
He acknowledged the relationship, yes.
Before he was hired?
No, he did not. So before I filed the motion, nobody acknowledged any relationship. So I filed the motion on January 8th, and then on Martin Luther King.
Walk us through that. What were the grounds why is it you feel like Fani Willis should be disqualified from continuing this prosecution?
Yeah, and so and these are things that I alleged in my initial motion that was filed on January 8th. I outlined this. My client in particular was not part of the special purpose grand jury. They did not recommend him to be indicted. He was not a subject. He wasn't part of that. So he was added on.
That's interesting, because I remember hearing that the special grand jury had recommended prosecuting like 40 something people.
They had.
He was not even in that list of 40.
He was not.
And they didn't take, or they, as in Fani Willis, did not take the advice of her own special grand jury as to more than half the people they wanted prosecuted.
Subsequently, there's been a book that was published that called "Find Me the Votes," that authors had exclusive access to her, and so all of her theories in how to indict people and who to indict was explored in that book. So from that, I was able to learn that she cut a lot of people. And I mean, I have.
Was that because they cut deals with them, immunity deals, or
some of them were that. Some of them I just don't think she wanted to bother with.
Then she added to the list, though, people that were not even recommended, or
my
at least your client.
My client, yes,
Okay.
She added him, so he was one of the ones. So there were some people, and it's publicly available in that book, like Senator Graham, Loeffler, those Purdue, those people.
They recommended prosecuting them.
Right. She had considered prosecuting them and taken them off the list. So there were a lot of people that had been on the consideration and then had been removed. And my client had not been considered, and then he was added. So to me, I was trying to figure out, why would you want to expand it? There's different ways you can go about prosecution.
Did you figure out why they add your client to the list?
No, but my allegation in my motion is that, the bigger the case is, the more money that's made. And that, that made sense to me. So for me to file the motion to disqualify, obviously we had to have some type of a basis, besides all of the violations. And so expanding the litigation, because of how large it is, the judge has said we're probably going to have 3 trials, and each of them is going to take several months. Where if you just imagine, just follow me down the path, if you only indicted one person and it was narrow, you could try it in a month. If you indict 19 people and, 3 different essentially alleged criminal schemes, like I divided it up earlier, that you now have 3 years of trial. You've now gone from a month of trial to 3 years of trial. That's a lot more money. And so that, to me, was a financial motive, particularly since my client was not recommended by the special purpose grand jury to be indicted.
And you had the data to show that she was financially benefiting from the continued prosecution.
Yes. And so to answer your question, you were saying, walk me through it. So January 8th, I have a deadline to file this. So I'm verifying, and that's what you can see in the text. You can see heavy text with Mr. Bradley right around then to verify everything. I file it. And at that point, the world is shocked. I mean, shocked because nobody had any idea. This had been hidden. This was even hidden from her father, who she had testified she talks to 10 times a day. So very few people knew about this relationship. And so they very much wanted to know who knew about it. Mr. Bradley, that next weekend, he gets some calls about, he gets a call, trying to fish to see if he's the leak is what it was couched as. He gets a call from a gentleman named Gabe Banks, who ultimately represented Chris Campbell he filed a motion to quash against Chris Campbell, who's the law partner.
Gabe Banks' wife works for the DA's office?
Yes, he does. She does.
Works for Fani Willis.
Yes. And I've not gotten it. I've not open records it, but I have been told that Mr. Banks also has one of these special counsel contracts. Again, I have not open records that, not part of my case. But so he calls Mr. Bradley, and Mr. Bradley calls me and another friend of ours. Her name's Cindy Yeager. She's a district attorney in Cobb County. And, he was upset. I talked to him. It was, I believe, a Saturday night, and I could tell he was upset by his text. I left my kids and went and talked to him because I was worried about him. And, he took it as what he described to me as the first shot against the bow, that they were trying to figure out if it was him, and they were trying to silence him. And
trying
Gabe didn't
silence him.
Mm-hmm. And he said Gabe didn't say anything that threatened him. He just out of the blue called him, and he hadn't talked to him in quite some time. So it was out of the norm for him to call. So Mr. Banks called and told him that was asking if he was the leak, meaning if he was my source. And Mr. Banks said that it was because he had seen a news article, and Mr. Bradley knew that wasn't the case. So he said, send me the news article. So he sent him some article that did not say he was the leak, and that put an end to it. But then the next day, Mr. Wade called Mr. Bradley's best friend and said to call, he didn't call Mr. Bradley directly, but told his friend to call Mr. Bradley and remind him of his privilege.
His attorney-client privilege.
Yes.
Who's the best friend? Can you tell me?
I'm not, he told me his name, and I'm not positive. I think I know who it is, but I'm not positive.
All right. So Wade calls Bradley's best friend, says, you better call Bradley, remind him he's got attorney-client privilege with me, and he better not spill the beans.
I do know the best friend works at a law firm called Beasley Allen. He told me that. He said his best friend's name, and then he said he works at Beasley Allen. And he was pretty upset about it. And it was the same day of Miss Yeager's birthday. So he didn't want to call Cindy, but he was upset. So he called me, and we talked about it. And we were both pretty upset about it because it seemed, why.
Tampering with witnesses.
It just seemed like tampering. And it's just, it's just an uncomfortable position to be in, and all of us were kind of worried how the state would react to all of this. But at that point, it's
Did
still.
he interpret that as Miss Willis trying to intimidate him from revealing this affair?
Or Mr. Wade.
Okay.
He took it as intimidation, yes.
All right.
Because what he called it as is the second shot across the bow. Those were his words. So he said first shot across the bow was Gabe Banks, second shot across the bow was Nathan Wade calling.
Okay.
So that's how he interpreted it. But at that point, I had not disclosed him as the witness, as the primary source. So nobody knew that. And I was trying to protect him as much as possible, just because I knew he didn't want these calls. It's not something that you want. So they filed some motions to quash, and I had to quash all of the subpoenas, pretty much every subpoena that I had issued.
So after you filed this motion to disqualify, I guess a hearing was scheduled?
Yes.
And then you started issuing subpoenas to line up your evidence?
Yes.
That's when this witness tampering occurred?
Yes.
After that, to try to intimidate your witnesses from coming to court?
Yes. So, and let me walk through the timeline. So I filed this on the 8th. The next thing that happened was Miss Willis testified. I say testified. She spoke at a church on Martin Luther King Sunday, and was making some statements about why did they single out Mr. Wade. Didn't say anything about that we singled him out because he's the only one she's having an affair with. Did not agree to that. Instead said that it was racially motivated.
And the other two special prosecutors were white.
Yes.
But they were making significantly less money.
Right. And she even said, to the church, she even said that I'm paying them the same rate, which is not true. Mr. Floyd's contract is for $150 an hour. It's never been $250 an hour. So that, one of my kids was listening to it and, said, come listen to this. And I listened to it and I was like, wait, that's not true. So that was one thing that she said that wasn't true. Also that it was racially motivated. She didn't say anything about, they're singling him out because he's the one I went on all these vacations with and he's the one I'm romantically involved in. Instead, she said that we were singling him out because of race. And then she said that they were all paid the same, which is not true. So I thought at that point, okay, they're not going to admit that they have this relationship. And so I'm texting with Mr. Bradley, oh my gosh, are they going to lie about this? Like, it's on their credit cards. Like, I don't know what's going to happen here. And so then in the divorce proceedings, Ms. Willis had been subpoenaed to testify, and she actually invoked her executive privilege as the DA.
That. She wouldn't testify.
She would not testify. So then
they settled it.
Right. And then they settled it because the judge said he was going to have to testify. So they settled it, and he did not have to testify. So at that point, the judge had given us a hearing date, so I was able to issue subpoenas. So my subpoenas started going, and I filed the returns of the subpoenas, and all of a sudden the motions to quash started coming in. Right around that time, the state filed their response where they admitted to this relationship, but they put limits on it. So their response that they filed, I believe it was February 2nd, I believe, February 2nd. So on February 2nd, they filed their opposition to our motion. They admit that there was a romantic relationship, but they claim that it started after he was hired and that all of the gifts and travel was roughly divided. They submit an affidavit from Mr. Wade, and they submitted a receipt from a credit card where she had paid for one plane ticket. So, it was a couple $100 on hers and then thousands of dollars on his. So then my subpoenas were filed, and every single one of them had a motion to quash. And they kept saying, I don't have a good faith basis. Kept very harshly saying that I was making this up and nobody had told me this, and it was, gossip, and I was lying and I should be sanctioned. So the court held a hearing on their motions to quash, and I was forced to disclose Mr. Bradley as a witness, which I did not want to do because I was worried because I knew they had called and all of these things. But I had to disclose him as a witness. And so at that point, I was still talking with Mr. Bradley fairly regularly. But that then changed.
Okay. So you're waiting on the judge to rule on your motion to disqualify.
Yes, sir.
In summation, the grounds for that are what? That this is improper for a prosecutor to have a relationship with the special prosecutor?
Yes, it is a conflict of interest.
Okay. And that's because the financial benefits, or just because?
Mainly the financial benefits. There's a couple different aspects to it. We've also alleged some other misconduct because the prosecutors aren't allowed to publicly condemn an accused prior to trial. And she made a speech at a church and said this was racially motivated, talked extensively about the clients being guilty. She testified at our hearing that our clients were guilty, that my client was, guilty of trying to, I don't even remember, subvert democracy or something. But she's made a number of public statements condemning their guilt, which is not allowed.
That's inappropriate conduct for a prosecutor.
Very much so. And there's case law on that. There's bar rules on that. So there were a lot of public speeches that were made along the way. And, they're you can kind of follow them through this media monitoring company. But so she makes these, and then she got disqualified from prosecuting another person she wanted to prosecute.
For making public statements? It was for a fundraising. She had thrown a fundraiser for his opponent, his political opponent.
Right. So when that happened, you sort of see her press stuff dwindle a little bit. So she stopped making as many public comments. But then when this motion came about, she made the church speech, as I'd call it, where she's, calls me and, my client racist, and says, condemns their guilt. And then she also gave interviews to this book. I don't know. The timing was just nuts. But the book came out right around the time that all this was happening, and it's called Find Me the Votes. And
that came out in 2024, you're saying?
It came out a month ago, if even. And she literally let the authors of this book in when she was deciding how to prosecute this case, who to indict, who not to indict. I mean, their whole thing is that they had unfettered, behind the scenes access to her thought process and stuff. So, and she's talking about all of this, that they're guilty. But the big thing for the forensic misconduct is she's in the church speech. She's saying, and she says this in the book too, that God has told her to prosecute them. So the theme between these two things is that God told her to do this and that she is doing the will of God by prosecuting our clients. And that is,
that's unethical,
in my opinion.
All right. So there was, I'm trying to recollect what I remember reading in basically the Atlanta newspapers about all this, because this was new to the state Senate as well, because all of this began on January 8th, which is that the day we started, 8th or 10th or something.
It did. And
it was the day session began, and all of a sudden these bombshell allegations come out. And I think that was the motivation for our Senate resolution forming this investigative committee to say, let's find out if this is true, independently of all you guys' legal issues or whatnot. So I remember she wouldn't testify in the divorce case.
Right.
But did you subpoena her to testify in your motion to disqualify?
Yes, and she filed a motion to quash.
She refused to testify, but then she came to court and did testify.
Yes.
Okay. And in that,
as they were arguing the motion to quash.
I wonder, okay, so in that testimony, did she deny the start date of this affair?
Yes, she said it started in early of 2022. There was some discrepancy between them, a month or two here and there, whether it started, generally it was around March is what Mr. Wade
So
and
what are the
Willis.
consequences for an attorney to give sworn testimony that she did if you're Bradley, what is it, Yerke? Yerty, your Trackhawk data, your other independent verifications are found to be truthful?
It's a crime. It's a felony. You'd lose your license.
Okay.
It's perjury.
Same for Wade.
Yes. And we have rules that are one of the, outside of privilege and confidentiality, we cannot suborn perjury. So if I have a client who tells me I did it, I can't put them on the stand to say I didn't do it.
Okay.
I would lose my license over that. I cannot do that.
And Yerty came to court and said, oh yeah, this started in 2019.
She saw them, she saw them together. She testified that she saw them romantically together. And they were very close.
Yeah. And you had Bradley's text message that showed he confirmed that absolutely back in January.
Yes. And he had a lot of details, little details that matched up.
Did you get other details from him by phone?
Yes.
That wasn't in the text. What did he?
A garage door opener that Mr. Wade had a garage door opener. And then I've subsequently learned that he told Mr. Aurora the same thing.
Garage door opener to her place?
To her place.
Okay.
Mm-hmm. Yeah, to her place. There were other things. Just a lot of context, things about how freely Mr. Wade could go in and out of the office, the DA's office, stuff about that they would sometimes use hotels. One thing that he told me was that Mr. Wade had, before he filed for divorce, had used Mr. Bradley's credit card and then paid him back in cash so that there wouldn't be a record of it.
Okay. All right. So I'm a little puzzled by the legal standard. I'm reading the newspaper articles that explain to us the difference between a conflict of interest and an appearance of a conflict or an appearance of impropriety.
That is the big argument right now. And I'm not the best person to explain that. My husband argued that part. But appearance of impropriety, it's one of those things like that if it undermines the outcome, undermines the confidence in the outcome. And we spent a lot of time in our brief talking about the constitutional underpinnings of this. Due process, that my client has a right to due process. He has a right to a fair and impartial prosecutor. And we don't think that's happened in this case. And so I think that would be more along the lines of the appearance of impropriety. And then actual impropriety is receiving money, like receiving money and not paying it back. And there was testimony about that. Miss Willis came in and testified, and Mr. Wade did, that she paid him back in these sums of cash, but there's no records of any of that or where she got it.
Anything shows him depositing cash or
No,
receiving cash?
no. And, we asked her like where you got it. She said that she said she borrowed it from her campaign. So, she said the original large sum of cash came from her campaign.
I
She
think
took
all
that
of
out.
us up here that have campaigns know you can't take campaign funds for personal use, right?
I'm not well versed in that area of law, but that is my
It's
understanding.
pretty black and white.
So she testified that she took that the majority of the cash she had on hand was from her campaign, that a loan she had given herself from the campaign. She was very clear about that. And then she also said that when it got low, she would supplement it by getting like $50 back at Publix. But I mean, she's giving him, $4,000, $2,500, so, large sums of cash. So, and there's no trail, obviously there's no record of any of that.
Right. In some of the documents you produced to us, there are a couple of IOLTA trust accounts.
Mhm.
Those were Mr. Wade's accounts?
Yes.
Okay. So he had more than one trust account in his law firm?
Yes, he did.
And did you find any discrepancy or whether these funds were deposited there?
Yes. And, so he testified because we asked him where he deposited the funds.
And these are the funds where his paychecks basically from Fulton DA's office?
Yes.
Okay.
At first, he deposited them to his joint IOLTA that he had with his law partners. And then he started depositing them to his when I say personal, just him IOLTA, an IOLTA that did not have anything to do with Mr. Bradley or Mr. Campbell.
Do you think Mr. Bradley was aware that he was running the money through a separate account,
I think it might have been part of the reason that they dissolved.
that they broke up?
Yes.
Do you think his ex-wife knew that this money was being held in a trust account rather than previously it had been going through his own bank account?
His ex-wife didn't have any idea. I mean, you could tell from the pleadings that he was even making this much money. I mean, he filed some interrogatories and some answers in that divorce case saying that he made a couple $1,000s a month. I mean, very, very minimal amounts.
Well, we knew he was making up to $35,000 a month under this contract.
Right. And he has a lot of money parked in one of those IOLTAs that's not disclosed in the divorce.
Okay. So that's, does it look like he was using his law firm trust account or his personal lawyer? IOLTA is a legal trust account, right?
Yes.
The interest from it goes to the state bar to help fund some
Yes.
indigent care or whatever, right?
Yes. As much as I wish we could park money in our IOLTAs that was earned and not pay ourselves, we can't do that. So when you earn money, you can't leave it in your IOLTA. IOLTAs are for client money. So they're a lawyer trust account. And essentially what they are is like if you settle a divorce case, not a divorce case, I'm sorry, you settle a civil rights case or a
Personal injury case.
Personal injury case,
Right.
and you get $100,000 and 60 of that's the clients and 40 of it's the lawyers. It has to go into your IOLTA. It sits there until you clear the case out. You finalize the case, you send a settlement letter, you get the amount and you have to put it in your actual business account, and then the client gets their check for their part. So IOLTAs are very highly regulated by the state bar. They can't commingle funds. It can't be earned money. It's got to be money that's not earned. And the interest does go to the state bar, but once you earn the money, you have to pay it. You have to have it in your account because you have to claim it on your taxes.
Right.
I mean, lawyers wish that they could keep money in IOLTAs and not have to pay taxes on it until it was a year that
Right. So
Financially,
sometimes
they wanted to.
attorneys may take a retainer up
Yes.
front and bill against that retainer. Say, you might do that on some of your criminal cases. So yeah,
Yes.
I'm going to take the $25,000, I'm going to put it in my trust, and then I'll submit an itemized statement and pay myself as I earn the money.
that's exactly what they do with
This is the
retainers.
Georgia
With
Senate
retainers that
hearing
are
for
refundable.
DA
So they would
Fani
ask,
Willis. This is an
$10,000
investigation
retainer, and then
carried
if
out
this month
by
I
the
billed
Georgia
$1,500,
Senate.
I send you a bill, and then I take the $1,500 and I transfer it to my business account.
Okay.
As soon as it's earned, you have to transfer it.
So these funds, if they in fact came from the contract with Fulton County, should have probably never been put in a trust account at all because they were already earned after he had done the work, and within some amount of time after that, he sent the bill and he got paid for work that had already been done.
I mean, if they were put in a trust account, they would need to be transferred quickly.
Is that the kind of
I don't do that, but
ethical violation that can get you disbarred?
they highly regulate the IOLTAs, highly regulate. I mean, the state bar, like there's a list of places that we can do banking because they're regulated by the state bar. I have to go in person for most of my IOLTA transfers. They're not something that I can do like online banking. I mean, it's a pain.
Okay.
But yeah, so they're highly regulated, and we know these were deposited in his IOLTAs because the back of the checks for Fulton County show where they were deposited.
And have you asked him about this? Has he given any explanation for why he ran this money through a trust account, or is it still in there? We don't.
I mean, the last I knew, he didn't give any explanation. I mean, he just said that he pays for everything through his business, and then he basically just said his accountant figures it all out.
Okay. I know you have a court appearance this afternoon. You've been very patient with us. I'm going to give Senator Harold Jones an opportunity to ask a few questions. Under our rules, we do allow at least one member of the minority party to participate. And Senator Jones, you're not time limited. If when the buzzer hits and you've got to go to court, you tell us, but I feel like we got at least 15, 20 minutes.
You definitely do. And I'm happy to answer any questions you have. My court's at 1:15 in Fulton County. So, if I get in trouble, if you can call the judge, then I'm fine.
You got it.
I just wanted to go back to the issue about the conflict, because I think that's kind of what brought us all here to some extent. On one issue, in your brief, the most recent one that you filed.
The second one?
Right.
Okay.
On page 21 of that, you went ahead and acknowledged that the aspect about him not signing, I believe, or being duly authorized to be a prosecutor, that's already been handled in one court, but you're still bringing that issue back up. But it has been decided in the negative. In one court, of course, you are still bringing that issue back up.
Yeah, so you're talking about the oath,
right?
The oath issue. Yeah, so Manny Aurora was working on this issue early on, and he filed a motion about the oath. At the time, it hadn't been filed, and in and of itself, that's not, that's not filing an oath. That's not going to get rid of a case. That's not going to disqualify in and of itself. Clearly, the judge told us that in an order, but I was trying to paint the entire picture and how I felt that it was relevant. And it definitely is not a ground that I was arguing for disqualification, but I felt that it was relevant because it shows that they were hiding this relationship, and all the evidence indicates that.
Right. And I was just kind of showing why I'm moving on to this next particular point here, which goes to page 24 of your brief, which deals with, I think, the thing that's really out there in the media, which deals with the relationship and aspects of that in some kind of way this creates a conflict of interest. And of course, the judge is going to rule on that, but I still think it's important to kind of go through it. And you cite the case of Whitworth versus State. What in that case actually applies to this particular case?
I don't know if I'm looking. You said it was the last one that I filed?
Yeah.
So February 9th.
Yes, page 24.
Page 24. You said Woodward?
Whitworth.
I don't see Whitworth.
At the bottom, Georgia courts have developed their own standard for disqualification of prosecutors.
That's not my page 24. You must be looking at a different, the one that was filed February 9th at 3:47.
We can't hear you.
I'm so sorry.
Just
I'm so
pull
sorry.
the microphone just pull it closer to you.
Yes, I want to make sure I'm following the same one. You're talking about the defendant supplemental reply that was filed on February 9th at 3:47?
No, let's go back.
Okay.
Let's use your first one.
Okay.
Yeah. One that's a little bit more. Okay. So that one there on the Whitworth case, tell me how that actually impacts this particular case.
Which page are you referring to?
Page 24.
Page 24. Okay. So the site is Whitworth. The court recognized a conflict of interest as a ground for disqualification. Held to arise where the prosecutor had acquired a personal interest or stake in the defendant's conviction. And I don't, I wish I had that case in front of me. I don't have the case in front of me, but essentially to answer your question, that first of all is physical precedent only. So
right.
Yes. And
but you did cite it.
And said that it's physical precedent only.
And you're using that as the basis really to say it's a conflict. There's no other case law that you actually use in this particular brief to say it's a conflict other than Whitworth, and also amusement sales, which deals with contingency fee.
Right.
And so in Whitworth, and I have the case if you want to go through it, it actually talks about that there's ways of citing the conflict.
Right.
Number one would be if he had or prosecutor had actually spoken to the defendant. Has that taken place?
No.
Okay. Second, has he represented the defendant?
No, he hasn't. There was a motion early on. I didn't even bring this up here, and I don't think we talked about it in the brief, but there was a motion early on because Mr. Campbell, who's Mr. Wade's law partner, actually sent a mailer out to my client and all of the other defendants. Yeah. So I don't think anybody called based on that, but they did advertise to them saying, call us to represent you.
And then they came with the third, which says there has to be a personal stake in the defendant's conviction.
Right.
So is that what you're relying on there, that there's a personal stake in his conviction?
No, in the prosecution also. So, and in that case, that's physical present only. And I don't remember the specific facts of that case, but it's not just a conviction. And obviously the state wants it to be just a conviction. And we argued this extensively over 3 hours, I think, in front of the court. But it's also a personal stake in the prosecution. And that was an amusement, prosecution. In that case, that was a contingency fee case. So
that's
that was
correct.
Completely different. Yeah.
And so in amusement, it was a contingency fee case. So they had a personal stake actually really in the conviction because they only received the contingency fee when the conviction happened.
Right.
So what you're really saying is that they had a personal stake in just bringing the case because there's no personal stake in the conviction similar to amusement, correct?
Well, so amusement's a little bit different because there is no conviction in a forfeiture.
Correct. But they're going to get money if they win.
Right. But there's no conviction.
But they're going to get money if they win. That's the key.
They get money if they keep the forfeiture. So it's where that was a forfeiture case. I think that was like game slots.
That's correct.
Yes.
But they get money if they win.
Right. But
that's the only way they get money.
Yes.
But they don't get money for bringing it.
So I just wanted to make sure it was clear.
Right.
That was not conviction because you can't have a conviction.
But they only get money if they're the victor. He's receiving his funds. Mr. Wade is receiving his funds because he's billing because the case is going on, correct?
Oh, yes.
Not because he wins a case.
No, he can lose the case and still make a ton of money off of it.
So what you're saying is the actual conflict is just bringing it.
No, the actual conflict is, that's a long answer. The actual conflict is lying on your disclosures about how much money
I'm talking as far as this issue is concerned right here. When you use with worth, you use amusement sales, and they say that there has to be an actual conflict. And amusement sales, and let's go back to Whitworth if we can, because in Whitworth, the person was actually told, the prosecutor was actually told by another prosecutor that they want the case to actually resolve in a conviction. Because what had happened was the defense attorney came to the prosecutor and said, we would like to plead. Mm-hmm. And the prosecutor basically said, no. He went and got advice from somebody, and that prosecutor said, we would like this case to resolve in a conviction.
Right.
And so the question, and that then was held not to be a conflict. They said that still is not an actual conflict, even though someone told that prosecutor. We want to see a conviction. We actually want to see it go to the end. Don't plea him out. And the court said, no, that's not an actual conflict, because what you have to show is there's an actual unfairness to the defendant in the trial.
Right.
Can you point to any unfairness in the trial that's taking place?
It's not in the trial. So it's not limited just to the trial. But to answer the first part of your question, when you were asking about the conviction of personal mistake, Ms. Willis has made numerous public statements about her interest in a conviction. There's some emails that had been admitted as part of it, as part of some of the exhibits in the case. There's a lot of pleading, so I don't know which one exactly, but talking about her desire for there to be a conviction and jail time. And then in my case, for example, so Mr. Wade offered my client misdemeanor probation. So we were the first people to get an offer, and we said, no, we wanted a dismissal because he was not guilty, and that did not happen. So obviously there's an interest in him being convicted of something, because when the plea offer was for him to pay a $5,000 fine and have a misdemeanor.
So in reality, because you said that he wanted to extend the case out, he was actually trying to end your client's case
with a $5,000.
But it was going to end. It would be no more billing on that case, because earlier you said that you believe, which was total speculation, that they created this case against your client to do more billing. And what you're just telling me now is that he was willing to stop his billing because he offered your client a misdemeanor and you rejected it. You're the one who's continuing the billing.
But he wasn't even a part of the original.
No, you're the one that's continuing to make him bill. He was willing to cut that off.
This man's
You
not
said,
coming out.
I believe that they created this case against my client so they can continue to bill.
Not
Well, he
just
basically went out and said, I'm tired of billing. I'm going to offer a misdemeanor.
Okay, let
And
me
you said no.
take a couple notes because you had a couple questions there. I want to make sure I answer all of them. So the billing, so as far as the billing and the offer. So what I was trying to explain, and I'm glad you gave me this opportunity to sort of go into it in a little more detail. I tried to explain that there are really 3 classifications is how I broke the indictment down. There's the folks that are involved at the federal level. You see those people having, they were in DC. Then you see the electors. Then you see coffee. These cases could have been
Ms.
handled.
Merchant, we can't even hear you.
Oh,
hardly
I'm
up
so
here.
sorry.
Just pull
I
it
didn't-
up right
sorry.
to you. Pull it to the edge of the desk if you have to, so everybody
Okay.
can hear.
Sorry. Okay. So how I was trying to explain it is I separate this down into 3 different types of cases. And it could have been handled that way. Coffee County could have been prosecuted in Coffee County if it had been chosen to do that. The stuff with the federal could have been handled in federal court if they had chosen to do that. Then the electors would have been the only remaining case that could have been prosecuted in Fulton County. Instead of choosing to do that, and it's not just my client in particular, but that group in the middle, by putting them all 3 together, it expands the litigation. How it expands it is a couple different ways. It expands it because when you charge a RICO case, you can bring in evidence of everything. So essentially, instead of having a case, a quick case, a case where there's evidence against Michael Roman, only Michael Roman, we litigate that. They expanded it to include these 3 different classifications. What does that do? That means the trial is going to be a year. They can plead people out. They can plead Michael Roman out. They can plead this person out. They can plead people out, but they're always going to have that large enterprise. And it actually does, even if they pled my client out, the offer was for him to testify. So, for him to testify, even though he would not be on trial, his acts would still allegedly be on trial, which still expands the litigation because he's not gone. The deal's not, you can plea out and you're gone. Bye. We're not taking up time with you. It still expands it. So my whole point earlier was that this expands the litigation, because imagine if we just had, like you see in other cases, 1 defendant. You can limit the information to just that crime and that case, or you could have 3 separate indictments. But what we've done here is we've put them all together. You've made it so that it's necessary to try them to have 3 trials because there's no courtroom that can fit all of those people. So that expands the litigation.
So in the case that you cited,
Mhm.
physical or not,
Which one? Whitworth?
Whitworth, it says specifically that when the prosecutor goes up, Morgan, who is the person who's not supposed to, who's talking to him, who's the prosecutor, Hobbs informs Morgan, who is the prosecutor, that he anticipated a successful criminal prosecution, but that any decision regarding Whitworth's proposal to Morgan was Morgan's to make. Morgan decided to continue to go forward. And they said that was not a conflict, that was the prosecutor's decision to make. And you're saying, this is the case you cite. Well, in your case, they actually came to you and said, we're willing to give you a plea. And you said no, which is perfectly fine. But then you say, well, they want to extend prosecution on my client. They were willing to cut it off. And so therefore, the case that you cite is totally opposite than what the situation that you're dealing with. How would you say that you have a conflict in this case? Based on this case, just based on this case. That was your first case that you cited in your brief.
I don't think it was actually the first case, but
The first was actually a federal case, but the first Georgia case you cited was
This
Whitworth
man is
on
so
this
off,
particular
and let me
issue.
tell you
Right,
why
on this
he's off,
particular
because
issue.
he's
Correct.
And again,
doing exactly like
I don't
what
have
Fani
Whitworth
did.
in front of me, and there's a lot of
Nitpicking
different
BS.
facts about these cases. I would be happy to review it and let you know. But what I can tell you is that I still, and we still believe that this is to expand the litigation. And even if it's minor, the law says over $100, that's enough to have a personal interest. So what we've got is these financial disclosures where they're not being truthful. Ms. Willis is lying under oath.
Thank you.
Which is the same thing my client is charged with conspiring to do, lying under oath about receiving a benefit over $100. So you've got those. You've got this concerted effort, which we have seen, unfortunately,
So glad
drag
you
out over the last
redirected.
couple months, this concerted effort to hide this information from the public, to keep this information out. I think that it is very reasonable for a court to think that that is a conflict of interest. And whether or not it's a stake in the conviction, a stake in the prosecution, we definitely have seen a stake in the prosecution. And Whitworth, the problem with Whitworth, and this is
Who actually brings the case?
the district attorney. Well,
How do they get the case?
well, we know a lot more now because of the book Find Me the Votes. So we know a lot more than we normally would know. So, and that's one of the things that I talk about in my motion. In this case, it was actually Nathan Wade. So he's the one that he presented most of the witnesses,
How is your client charged? How are these clients charged?
My
Answer
client
the
was charged
first
just in the
question.
actual grand jury.
Okay.
Yeah.
So a grand jury.
Yes.
Okay. So we had a special grand jury, and then you had a grand jury
Yes.
who made this determination.
Well, yes.
They
And
made
I-
a determination to bring charges, basically, to
Yeah.
indict,
Not
correct?
against her
Yes, and
client.
I
So are they part of all of this?
no. But I've never had the privilege of being inside of a grand jury, but I have heard a lot about what happens inside of a grand jury. It is a witness who comes, and in this case, it was actually the investigator for the DA's office. So just understand this: it is a very low standard of proof. It's probable cause. I have had clients who were dead indicted. I actually had a lawyer that I worked with at the public defender that was indicted along with his client because the DA presented an indictment that actually had the lawyer's name on it by accident, and the grand jury indicted him.
So you're saying the grand jury has flaws?
100%.
Oh, so would you think it'd be better for just the prosecutor to draw the
Or
accusations?
have several
No.
seats. You're in the
No,
So the
and I
grand
know
jury-
I know you guys have a bill doing that right now. No, I definitely don't think so. The grand jury is better than no oversight,
Correct.
definitely. But
Right.
it's a continuum. So my point in bringing that up is the grand jury is not perfect. The grand jury is. I'm not allowed to be part of the grand jury. It is not what I would call adversarial. So the grand jury is one-sided. They only hear from the prosecutor. So, and they hear hearsay. So in this case, using it as an example, the investigator for the DA's office listened to all the January 6th testimony, read all the testimony, went in there and summed it up for the grand jury. They present, the grand jury doesn't draw up the indictment. The prosecutor brings that indictment and then they vote and it's a majority. So all they have to do is a majority vote and it's by a very low standard. It's a probable cause, which is about 25% proof. So you've got hearsay, you've got a witness who hasn't actually witnessed anything personally. You've got a standard of 25%. I think there should be much more safeguards on the grand jury process personally, but that's for another day.
So you went through special grand jury and they made their recommendations. Then went to a grand jury and they, of course, made their recommendations. And how many persons have actually pled in this particular case?
2 or 3.
2 or 3
And
already.
they were lawyer. Well, there was one. So the first gentleman who pled, he was a bondsman, and he was not, because of the state law for bonding agents, he's not able to actually run his business while he's on bond. So he had a significant financial interest in entering a plea early on because he was essentially couldn't work if he didn't enter a plea. And I mean, he got probation. It was not what you would imagine in a huge racketeering case. You would not imagine probation and a $5,000 fine. The other 2 people who pled are both lawyers at the end of their career. And, I can imagine when I'm close to retirement and I have my retirement funds, if I would want to spend them on a criminal trial or spend them seeing my grandchildren, I would spend them seeing my grandchildren.
One of the things we've been talking about is Mr. Wade's kind of qualification. So,
Oh, yes.
but you did mention early on that he was very instrumental in the special grand jury process. So he's been there. He's been part of this process.
Oh, you can see that by his bills. Yes.
Right. So other than just his bills, you said that you recognize that he's been part of the process. So even though he's very, I guess, what everyone's saying is inexperienced, he was able to go to a special grand jury and get their positive recommendations, I guess, from state side. He's able to go to a grand jury and get indictments, which positive for the state side. And he's actually had some persons actually plead guilty. So this inexperienced former assistant solicitor, I mean, he's not doing too bad, is he?
That would be up for
cares?
dispute. I mean, if you want to talk about his qualifications and whether I think he's qualified, I'm happy to talk about
No,
that.
I'm just saying. I mean, when you say that someone's totally unqualified, that's basically what's been going on. It's very surprising he was able to go to a special grand jury. You say he's integral
Oh,
in
that's
that.
not surprising at all.
And he's going to a grand jury. You say he's integral in that. Then why even say that he's inexperienced and he's getting people to plead guilty? But basically, you're saying those are just lawyers that don't want to do anything anymore, and they just pled their clients guilty.
No.
I understand.
No. So the special purpose grand jury, first of all, remember my client was not recommended as far as that.
I understand.
The special purpose grand jury, I've had the opportunity to read a lot of the transcripts from that. It's direct examination. So you're bringing a witness in and you're talking and you're saying, tell me what happened. So did that along with Mr. Wooten, and he never did it all by himself. He definitely led it, but Mr. Wooten asked a lot of questions, and there were some other prosecutors in and out, but he was always there. But that, I mean, special purpose grand jury is really just to investigate and get testimony.
I understand.
So it's not.
But when a person's trying to insinuate that somebody's basically totally unqualified, it is important to realize that they've walked this case to this particular point. Very complicated case, I'd imagine.
I mean, that's something that we can debate. You know, if walking someone through the grand jury, the special purpose grand jury is complicated or not. You know, asking questions, and again, there's a team of 10 lawyers. So
now it's a team of 10 lawyers.
Who knows what part he's doing? But the question would be then, why him? Why not all of the public servants who are taking government salaries and, you know, restricted in their private law practice? Why do they need him there when there's all these other people? As far as the qualifications, asking questions in a special purpose grand jury in and of itself, I mean, there's no opponent, there's no adversary, there's no judge.
Once it became adversarial, you've had persons start pleading, and maybe more potentially, correct? Possibly, but we'll find out. But let me ask you this though, because you're talking about the staff. One of the reasons you may go outside to outside counsel could be the fact that if you actually put this type of case within the office, just speculating, but to some extent we all are, the office would basically shut down. It's a potential that the DA's office would actually basically shut down.
Oh God, no. If you took the $1 million that he's been paid, you could hire 5 lawyers.
You could do that, but how long would you be able to keep them? In other words, if you hired 5 new inexperienced ADAs, they're not tackling this case. And also,
inexperienced ADAs are not going to make $200,000. So if you're hiring inexperienced ADAs, you'd probably be able to hire 20. But that's not what.
But the key thing is that job that you're talking about, that you're going to hire with that, with the $1 million that you'd have paid him. Yeah. If that's your theory on it, that's not going to stay. That's not necessarily going to be long term if you're just doing it for, you're just saying the money you paid him, you could have done this, because his is a short term kind of situation. His is on contract, so it's short term. It's not a long term contract. It's not going to last for a person's career. So I understand the back and forth when persons were saying, well, they could have used this money for that.
I could just hear their conversation. Don't worry, Fred. I got
him
you.
On the short term.
She's coming to the Senate
project, so to speak.
I got you.
So it's not anything that a person would come in long term and actually necessarily do. But at the same time, that would be up to the district attorney to make that decision how she's doing that. I just make the point that so far, from a district attorney standpoint, I would say that they probably believe that so far the case is successful. And we can argue about what's qualified, what's not, but certainly I think that they would argue at this point the case has gone from a successful pattern for somebody that's been denigrated and said is totally unqualified. I did want to go into these trips. How much was the money? Go ahead. Thank you.
Was that a question? Because I'd like to respond if it is.
Yes.
Okay. I took notes because there were a couple different questions in there. So the first one, you said about how much money. So Ms. Willis had stated that it would be between $3 or $4 million to actually pay Mr. Wade completely to prosecute this case. So you'd be able to hire a number of prosecutors. Some of them do come and go, but most of the prosecutors we've seen on this case have been there since the beginning. So, you know, unfortunately, these cases take time, so people may leave. You also asked me about that this money was delegated for this, and I just wanted to make sure that my testimony was accurate. This money was never delegated for this. The county did not ever delegate this. The county was not involved in that at all. Ms. Willis is the one that decided, and there's no budget. There's no transparency at all on this.
She does the contract with him, and I believe you showed those contracts. So in that sense, is delegated to him because that contract can end at any time. She could say, hey, the contract based, because he works at her pleasure. Oh, yes. So that contract can actually end at any time. That would be the point. Yes. On the trips, how much total were the trips?
About $20,000.
And I think it was about 17,059. But even if we say 20,000, what was the average cost of each one of those trips?
I don't know. Unfortunately, they did not provide all of the records. So I can't tell you exactly. All I can tell you is what Mr. Wade charged on his credit cards. I can't tell you. Most of it was paid in cash. So there's no record. So I wish I could tell you, but.
Going by your slide, one was 3,335, one was 4,453.
Which one? Hold on. I want to make sure I'm clear on each.
You had 6 trips.
Okay, but which trip are you talking? Well, you said one is 3,000 something. I want to make sure I'm clear.
Yeah, put it back up for me, please.
Yeah.
There we go.
He's
Okay.
So the
trying
first one,
to
Royal
not
Caribbean,
realize
3,335,
only black
Aruba,
people care about
4,453. And then we see the next one, and then the next two. How would that compare? I mean, what is that so unusual for on price points as far as trips are concerned?
No, I mean, I don't think so. The Royal Caribbean, so I can tell you because I know these records really well. I mean, Royal Caribbean, I specifically kept out the money that he spent on his mom's cabin. So they had two cabins. His mom had a cabin. They had an oceanfront balcony. For the Bahamas, I think oceanfront balcony is probably, upper middle, but I don't know that it matters. Flew, comfort class, not unnormal for a lawyer.
You know what maybe the average American spends on vacation?
Not this much.
You don't think?
Does it matter?
Have you looked?
No, I haven't, but I would
Oh,
imagine
those are
most of the
free.
Fulton County taxpayers would love to go on any of these trips.
Well, if you, since you speculate a lot, I could speculate and say that you did look, and that's why you didn't put it in your brief,
I did
because
not.
Forbes actually says that the average is about $3,700 that a person spends.
All right, let me
on a
interject here.
vacation.
I
For a
gotta
single
stop
person
this
or a
guy.
family?
I
Family
wanna
of
make
four,
this
with
thing-
at
he's
that
not
time,
doing
they were
anything
taking
but
2 or
making
3
himself
at
look
a
like an
time.
That
ass.
So
makes sense.
that makes,
So
that's
these,
about
no,
normal.
hold on. I want
Here's
to make
the
sure that's
point.
clear. You said they were taking 2 or 3 at a time. All of these, I made very certain that my numbers only included the 2 of them. So the one trip that they took
But
his
it's
mother on,
2 adults.
2 adults, yes.
It's nothing extraordinary.
Okay, so here's the
you said
deal.
3,700 for
This
a
is
family
the
of 4.
problem.
That does not surprise me.
She
For families
received
that can't
gifts
afford to go on
in
vacation,
excess
does
of
not surprise me.
$100
So basically what
and
the average
did
American
not
would do.
report it.
So
That's the issue.
Yes.
This
But
is
see,
half
black
of that
folk,
for 2 people.
just
So
like
you
what
said
you see my
3,700 for a
friend
family of 4.
That's
This
the
is for 2
problem.
people.
They want to have something
Right, it's just 2 people.
fantastic. Oh,
Right.
we told them.
So
Yes.
You're an
that-
idiot because you don't know that he
Yes.
told them nothing.
So it wouldn't necessarily be
Same
average.
stuff
It's
that's
2
going on
adults.
every day.
Bottom line is it's not extravagant. It's not lavish, is it?
The law only says $100. So
But it's not lavish.
that's one of the reasons I didn't include all the Ubers. I quite frankly didn't want to do the math. But there were a ton of Ubers on each of these trips. There was a hotel at the beginning of the Royal Bahamas. I didn't include that. I didn't want to do the math, and I also did not want to.
And how much does Ms. Willis make?
200 and something thousand a year?
And so your
in my brief.
argument is that a person who makes $200,000 a year
Mhm.
is actually setting up prosecutions to go on a trip that costs $3,500. That's your argument.
No, not in isolation. I mean, you're talking about in isolation.
No, I'm
in
not talking about in isolation. I'm talking about what's in briefs. I don't know what else you may be speculating about. I'm just talking about what's in briefs that says this is the benefit that she got. And all I'm saying is that I got a person who's making $200,000, and the benefit that you're putting into the briefs, not what you may say that you may find elsewhere, but the benefit in the briefs is I go on a trip with $3,300, $4,400, and they have made up all these prosecutions to go on a 3-day cruise for $3,300. I mean, that's your
Okay,
argument.
while
If-
he
that's your
tried
argument.
to
That's
be
your
a
argument.
travel
That's not-
director,
That's in
the
the
point
brief.
is that this
that's not our
is
argument. So
not
we did
What
our
else
oath
is
for
in the
about
brief?
3
happening
hours.
at
What else
all.
is in the brief?
What else is in the brief?
Yes.
A lot of facts, a lot of law.
No, as far as actual financial benefit.
So the financial benefit that I put in the brief was what I could prove. I did not want to have any, as you call it, speculation. I did not want to speculate about anything else. So I did not know if Mr. Wade paid for an Uber that Miss Willis was literally sitting in at the same time. You can kind of assume because it's from the airport to the hotel, but I did not want to speculate to that. So I didn't include those in the numbers. So the hard numbers in here are all of these numbers that are
That's
on
what's in the
trips.
brief.
Yes, the ones
Right.
that I actually had hard numbers that I knew that she had. Yes, that's in the brief.
In our business, we deal with proof. And so that's the proof that we have.
Exactly. That's what I
That
did.
person
Yes.
is doing all of this for that.
Right.
Okay.
Oh yeah. And
Understand.
so what I included was what I had the actual hard proof of. And then some of it's attached to the brief. Some of it I got by subpoena. So some of it is actually exhibits that were admitted. I think I submitted to you all the certified business records from a couple different travel agencies. Those are actually admitted. And there were a lot of other receipts that I had that I did not know for sure if they were joined. And so I didn't include those. And I haven't
And
talked
you
about it
should,
today.
correct?
Exactly.
That's correct.
I 100% agree.
So this is what we're dealing with.
Yes, you're dealing with the stuff
Okay.
that's hard proof.
Correct. That. So my next question then becomes going to conflict as far as his salary is concerned. Just curious. Is it the amount of salary that you really creates the conflict? I mean, because we get stuck on money a lot. So is the amount of salary that is creating this conflict in your mind?
No,
Or
it's
is
the
just the
fact that
fact that he gets any salary at all?
No, it has nothing to do with that. I did not make any allegations against Mr. Floyd or Ms. Cross. It's the fact that they were sleeping together and he was paying for trips for them to go on, and they were hiding it from the taxpayers.
We just discussed that.
That's why.
So if there's not a trip, then you don't believe there's a conflict.
Oh, I do, because of the Fulton County laws. The laws say that they
I'm
can.
not understanding the county codes, but I'm talking about as far as like what the case law says, which is what the judge is actually going to. If there's no,
Please shut up, sir.
if we're not
You're embarrassing yourself.
hiding that or against the Fulton County ordinances,
They were hiding it, though.
do you believe that there's a conflict? If they brought it out and said, hey, we're dating, is it a conflict in your mind?
They only brought it out once I alleged it, and they called me a liar multiple times.
What I'm saying is that they brought it out, would it be a conflict in your mind?
If
Is
they,
it a conflict?
Here in a
And what would be the
Oh,
conflict?
So in a perfect world, what you're asking is if Miss Willis had gone to the Board of County Commissioners and said, I'm having an affair with this man, but he is brilliant and he would be an amazing prosecutor on this election interference case. Can I have an appropriations of $3 million and I will get it done? And she had said, and I'm going to go on vacations with him and we're going to date and we're actually going to go home to the safe house that Fulton County's paying for. And he's going to be here for 4 hours at night. If she had said all that and they had given what they gave in Exhibit J, knowing that, Exhibit J, we wouldn't be here.
So then your client actually has no conflict because that would still exist. Your client has no hard conflict then. There's no actual conflict. It doesn't matter if you disclose a conflict. If you disclose a conflict, it still exists. And that's exactly what they said in one of the cases that you cited. If a person says, I got a conflict, but I'm still going to testify against you. I know I represented you and I have a conflict and I'm going to go testify against you. Conflict is now over. Absolutely not.
So,
if you have an actual conflict where your client is harmed, just because they disclose it doesn't end that conflict.
no.
So what you're describing is not a conflict at all. You're just saying, I caught somebody, so therefore I'm going to create something and call it a conflict. You cannot waive a conflict like that. You just could. If your client is, you could not do that for your own client. If your client is actually suffering harm, as far as how the prosecution is taking place, because that's what a conflict is. Just because she says, oh, I'm doing these things, you're not going to go to your client and say, you actually have actual harm, but she said it, so we're going to still go forward. That makes absolutely no sense.
I'm sorry, I don't understand your question. I don't know what
you
you're
don't
asking.
have a conflict if you're saying if she disclosed it, it would go away. Then there is no conflict.
No. I did not say that. I said we would not be here if that had happened.
Right, because you wouldn't claim there's a conflict.
No, because we wouldn't be here because it violates so many of the Fulton County statutes and ordinances and the state statutes that we wouldn't be here because it wouldn't have been approved.
But if she disclosed it, not the way you said it,
if
it was disclosed, it's disclosed now. What is the conflict?
The undisputed facts, the facts that we all, your side and my side.
How is your client harmed? That's my question.
Hold on. I'm trying to answer your first question now. So if all the undisputed facts, if those had been in front of the Board of County Commissioners, we wouldn't be here because there would not have been a contract because it's in contravention of law. So we would not be here. I would not be bringing a motion because who knows if my client would have been indicted. Now, I wish we could go back in time and undo that and see, but we can't. And so Mr. Wade was in the grand jury. He should not have been there. He should not have been appointed. Had the Board of County Commissioners known all of the facts of the case, he would never have been appointed to this case. So we can't now speculate as to what could have happened.
What case law do you point to prove that?
Oh, the statutes. No,
it's not a statute, not Fulton County statute. I'm asking for Georgia Court of Appeals, Georgia Supreme Court. Is there any case that says that? And there's not.
No, and it's really not surprising, honestly, because can you imagine this happening? I mean, honestly, in December, would you have imagined this happening? I think most people wouldn't.
All sorts of conflicts are taken up by the Court of Appeals.
I can tell you, I have found some cases in other jurisdictions, but I have never found a case in Georgia where, and mind you, this only happens in Fulton County. So we're talking about Fulton County cases where there would be a special prosecutor appointed because it's the only place that this happens. So otherwise, maybe the AG. So you're talking about a prosecutor sleeping with the person that she is appointing to do this work, paying exorbitant amount of money, not getting county approval, not filing.
Is she paying him, or is he earning the money because he's actually billing hours because he's prosecuting the case?
I don't.
He's billing hours because he's prosecuting the case, correct? A case that a grand jury indicted.
I would hope that he's billing based on work that he's doing. I don't know because I don't have proof of that, and the billing is very irregular. But I don't know, so I don't.
But I mean,
wanna
words
speculate.
do matter when we say that she's not paying him in that sense. He's earning money for a case that he is in charge of prosecuting, that a grand jury indicted, and that's where we are.
You're correct. She is not paying him. The Fulton County taxpayers are.
As they pay every prosecutor, as they pay every public defender,
But you
and
brought
every
it up.
government official that
You brought
actually
it up.
exists.
Employees, yes.
100%. And that he is part of that process. And he is prosecuting a case that you're involved in, correct? He's prosecuting, and he's been integral in that prosecution. And you've said that.
I mean, he has been very involved. Integral to me means that he is necessary.
Senator Jones, are you getting close?
Yes, sir. I just had one last question, and that was, in the case that you cited, it clearly says
Which case? I'm sorry.
in Witten,
Witten?
Whitworth versus State, it clearly says the prosecutor should see no unfair advantage in taking advantage of the accused. That creates the conflict. What unfair advantage has he done in this case?
And you've asked me a lot of questions about Whitworth. I would love a chance to read it if you have a few minutes, just so I can actually respond. I don't have it in front of me, and there's a lot of cases out there, and I want to make sure I respond accurately.
Sure, I have it.
Okay. Fine.
Yeah, absolutely.
Thank you. I'm sorry. I'm one of those people, I'm visual. I like to see it.
He does it down to-
Thank you.
This guy is an idiot. He's grasping at straws. He's cut from the exact same.
While she's
fabric
looking at
that
this,
Fani
we're
Willis
going to wrap up
and
here in a
Nathan
few
Wade
minutes.
are cut
I
from.
wanted to let the public know how you can get information to us. Each senator on the committee has a separate email address for committee business, and it's simply the last name of the senator. In my case, it would be calcert.inv@senate.ga.gov. INV, obviously, for investigation committee. So each senator, their last name, .inv@senate.ga.gov. And David Cook is sitting over here in the corner as the Secretary of the Senate. He is going to be the safekeeper of any documents or evidence that we accumulate. His email address for this purpose will be cook.inv@senate.ga.gov. I've had a number of citizens that have reached out and wanted to provide information or be heard or testify possibly in front of this committee. And
so
we are
even though he's doing
encouraging
that,
anybody that
what I
has
will say
input
is-
or information that might be helpful to us to provide it
there are
to a
going to be a
committee
lot of
member.
people coming out in the public.
Ideally to
and do this under the cover of anonymity.
cook.inv@senate.ga.gov, because Secretary Cook will provide it to all committee members. We don't have a next meeting scheduled yet, but it will be no more than a couple of weeks away. Ms. Merchant, you may not be able to have completed your testimony today, and we may have to call you back for additional questioning after today, but I'm not rushing. Take your time, read that.
Can it not be the first week of April?
Yeah,
Cobb County spring break, please.
that'd be fine.
Thank you. Okay, yeah, no, I'm so glad. So this is Morgan. When you said Morgan, it should have, J-Tom, it should have struck with me. I remember this now. So this case, J-Tom was actually the district attorney when he first took this case, and he was not.
Don't talk. Wait.
Oh, I'm sorry, I forgot the microphone. I'm not good at that, sorry. He took employment later on. So the employment, so it's different than our case because he took employment later on. He wasn't actually paid hourly. He was a member of Prosecuting Attorneys Council. And I'm glad you brought that up because that was one thing that I didn't really go into earlier. The other way that counsel is usually appointed in these cases is the Prosecuting Attorneys Council actually appoints it. And that's what happened in that case. But they sometimes will pay an hourly rate if it's something that is needed. But in that case, he was actually the district attorney in another county. And that's what I've experienced before. So the 2 times I've had special counsel, it's been because it's somebody from outside in another jurisdiction that's brought in. So that's what happened in this case. But then he took a job later. The other big difference with that case, and this came up in our oral arguments with the judge, that's a post-conviction case. The standard of review is very different post-trial than it is pre-trial. We're in a pre-trial posture. And we talked about that because the judge asked us a similar question about how to distinguish that. That's the big issue. And the judge pointed that out. That is post-trial. Post-trial, we have harmless error review. It's not a great review. So, it's just like ineffective assistance of counsel. If you stop the harm before it happens, it's a different review than if you fix the harm after it's already done. It's really hard to overturn a conviction once the conviction happens. And that's what you have there.
But in this case, they never got to the harmless error because they said that no conflict existed. I understand what you're talking about by the harmless error, but they never discussed that because no conflict existed. And you're right, it is post-conviction,
That
but
case
bottom
has
line
nothing
is
to do with
you
it.
really did not address the aspects that I was talking about when they say is a conflict. And it's not me putting this case in talking about a conflict. It was the case that you guys actually did cite. With
Yeah.
that, Mr. Chair, I yield.
Well, can I at least answer that question?
Sure you can.
We definitely cite it because we have, both myself and my husband have a very strong policy of citing everything. We don't hide cases. So if there's something that's adverse to our position, we're going to cite it and we're going to explain it. We don't hide behind it. So we cite adverse authority all the time.
Adverse authority, but that's fine.
All right.
The oral arguments that we did, that was how the oral arguments started. So.
All right, so that line of question deals specifically with the legal principles involved in your motion to disqualify. As I understand it, you're not really claiming a conflict of interest between defendants, et cetera. It's the conduct of the prosecutor.
Yes.
that
Yeah, there's
is
no
improper
conflict.
Conduct.
Yeah, we're not talking about the conflict between defense.
We're talking about the fact that the DA's office failed to follow state law and get an approval, failed to follow county policies to get approval of her budget and this contract, that he was not eligible to have been hired had he been disclosed because of, you referred to it as nepotism, but it's relationships
Yes.
with, and your complaints are of she's receiving a financial benefit of gifts of more than $100, which violate county policies.
Yes, county and state. So
And state.
and we attached that to one of the briefs, her return where she filed it under oath that says,
Okay.
I mean, it specifically says if you've got something over $100, you have to disclose it.
And
Oh, here it
then-
is. It's so it's called the Fulton County Income and Financial Disclosure Report. And that says, and it says pursuant to section 2-79 of the Fulton County Code of Ethics, that anytime you've got each gift or favor from a single prohibited source in the aggregate amount of $100 or more. And then it says, for purposes of this section, gift and favors means anything of value given by or received from a prohibited source. Prohibited source means any person, business, or entity that the involved officer, so Ms. Willis, knows or should know is seeking official action or seeking to do or doing business with the county. So obviously that would apply.
Okay. And failing to respond to your open records request and potentially giving false testimony under oath if your version of facts is proven to be true.
Yes.
Keep us posted. I guess we'll keep reading the press as to how your case progresses, I guess there. I'm troubled about this Find the Votes book. Are you saying that the prosecutor has been discussing an ongoing prosecution and her prosecutorial strategy and indictment strategy to authors of a book during the course of the prosecution?
Yes.
And
yes.
that book has now come out?
It is. It's.
And
I don't think I brought it with me. No, I have a copy. We admitted a copy at the hearing. No, it's out there. It was published.
Is that a violation of ethical obligations in some way to be publicly discussing, just like the public statements you made about the guilt of a defendant, et cetera?
Yes, definitely. And we allege that and argued that as far as forensic misconduct. It's very surprising, shocking. And, I don't know that there's a ton of cases on it. But that book, also, we talked about it somewhat in our hearing because it goes into a lot of details about the financial troubles that Ms. Willis had prior to becoming DA. And so, it talks about that a lot.
Okay. Is she getting a financial benefit from that book?
I don't know.
Is she getting a royalty or a payment for having been a contributor to it?
I have no idea.
Okay.
But I know her dad testified that he was interviewed for it. He came to the district attorney's office and was interviewed for it as well. And I think that was when her dad first learned that she had dated Mr. Wade, I think. But I may be wrong. Or maybe that's the first time they met, something like that.
All right. Well, thank you for your willingness to testify before us, and the documents you provided, we'll need some time to analyze and review those. And again, all committee members have access to those. At David Cook's office, he's got them literally locked up in a room. We are not making copies or disseminating those. I will review the documents in more detail, and I'll confer with you, Senator Jones, if you're able to. We might can agree on what should be kept confidential there. I noticed some bank records and things that if it were me being investigated, I probably wouldn't want it divulged to the public. I don't think that's necessary for us to do our job here. I do appreciate everybody's attendance, and thank you all for making time to be here on our committee day. We'll keep you posted for the meetings. The meeting is adjourned.
So before we leave, let me go ahead and give you this document, or let you see the document that was currently being reviewed or being admitted, or they hope to admit this. Let me say this correctly. If they decide to allow other evidence to be entered, Judge McAfee has been requested to enter this document. We need to quickly understand and redirect. Every time we listen to anything here, we have to redirect, because what happens is we get a lot of mud on the wall and it covers up what the point is. And that's exactly what Senator Jones just did. A new court filing suggests a key witness in Fulton County District Attorney Fani Willis's disqualification hearing wasn't telling the truth on the stand. And by that, they are referring to Terrence. Okay? Let me make this a little larger so that you all can see it. In tandem with that, I can actually take this to a totally different browser. If I take this to the Edge browser, it'll give us just the clear and concise part that we want to see and not this other stuff. So let me put that over there to that browser, and then I'll go ahead and open that window so it'll take it off of the screen for a second. All right, let me fix this for us. Here we go. All right, so we'll use the immersive reader. Yeah, great. So it's going to give us everything that we need. Let me take this off. And I also want to show you somebody else, because there is a young woman by the name of Sonia Allen. I'm going to pull that over as well. Very pretty lady, but according to some reports, as you can see on what we're about to read, she is apparently another woman that Mr. Wade allegedly was having an affair with. The question was asked in the documents that we just saw from Ashleigh Merchant if Fani Willis knew about Sonia Allen. So with that said, we'll get right into this window so we can see it. Hold on just a moment. All right, let me give this to you guys. This is very telling. It gives us some information on how exactly all this stuff works. All right, there you go. So this is the court filing. Court filing, Cobb County prosecutor says key witness was untruthful in hearings about Fani Willis. You guys let me know if my sound is okay. The reason for me asking you that is it's been going louder, and then it's been lower, and then it's been louder and lower. So let me know that I'm 5 by 5. Yeah, you know what I've learned to answer this question before, so that I can get an answer about the sound. Robert, here's what I've learned. I've learned that a lot of people, both men and women who are cheaters, will be dual cheaters or tri-cheaters. They will have a spouse or the main person that they're dealing with, and then they'll have somebody else that they're seeing, and then they'll be cheating on that person. There's my brother. Thank you, Anthony. All right, so here we go. Let me get over here to this side. I'm going back to the Edge. All right. Now, a new court filing suggests a key witness in Fulton County District Attorney Fani Willis's disqualification hearing wasn't telling the truth on the stand. The document was filed by attorneys for David Schaefer, the former chairman of the Georgia Republican Party and the co-defendant in former President Donald Trump's Georgia racketeering case on Monday. It says Cindy Lee Yeager, co-chief deputy district attorney for Cobb County District Attorney's Office, would testify that Terrence Bradley told her a different story than what he told the court. Terrence Bradley, of course, is the former law partner of Nathan Wade, as well as his alleged, and I say alleged because I don't believe that he was, but his alleged divorce attorney. Here's the full filing. Bradley is the former law partner and divorce attorney of Nathan Wade, a special prosecutor on the Trump case whose former relationship with Willis may have crossed financial and ethical boundaries, the defense argues. In a series of hearings deciding whether Willis would be removed from the case, Bradley was called to testify 3 times. When grilled on details about the relationship, Bradley often said that he couldn't recall specifics, claiming that he had no personal knowledge of when the relationship started. But according to the filing, he spoke with Yeager multiple times in person around August of 2023 and again January of 2024, saying the relationship started after the two met at a 2019 conference and was ongoing when Willis was running for district attorney. Both Willis and Wade have testified that the relationship started in 2022 after she hired him as a special prosecutor. Around September of 2023, Bradley was visiting Yeager in her office when he got a call from Willis, Yeager said. Yeager claims the overheard conversation was about an article discussing how much money Wade and his law partners were paid in the Trump case. They are coming for us, Willis allegedly told Bradley. You don't need to talk to them about anything about us. This is what she's alleged to have said. Now, in the filing, Yeager said that she was concerned about the mismatching information while watching Bradley's testimony. The details Bradley allegedly told Yeager are similar to what he texted Ashleigh Merchant. And let me put a pencil here. We just heard Ashleigh Merchant say that Yeager was a friend of hers. And we also heard Ashleigh Merchant say that because it is a small network of attorneys, they all sort of know each other. And she also added that they thought I was a little curious when Wade was assigned to this case because, like most of us in our respective fields, they all knew that he had never done anything, not even a felony case. So they all thought, what's really going on? And in that, she even alleged, if you go back and look at it, that they sort of all knew under the wire that Nathan Wade and Willis were in an affair. But I digress. The attorney for another Trump co-defendant, this is what the article continues with. It says, when pressured by the defense, Bradley told the court that he was merely speculating when messaging Merchant, but the defense wasn't buying it. Quote, let's speak truth here. You're under oath, Trump co-defendant attorney Richard Price told Bradley at the hearing on the 27th of February. Did you lie to her about any of those details, he asks. I don't recall whether any of it was a lie or not, Bradley answered. Wow. Now on the stand, Robin Bryant Yurting, a former friend of Willis, also said the two's relationship started in 2019. Judge Scott McAfee, the Trump judge, said the Fulton case is expected. He's going to make the decision in about 2 weeks. But here's how we got here, where we are right now. Willis is the locally elected district attorney who issued dozens of indictments in August of 2023, accusing Trump and his allies of trying to overturn Georgia's 2020 election results. She bit off too much. She had too much dip on her chips, to be honest with you. But nonetheless, let's continue. But in early January, an explosive court filing by Michael Roman, one of Trump's co-defendants, and his attorney, Ashleigh Merchant, accused Willis and special prosecutor Nathan Wade of having a romantic relationship. Roman, a former White House aide who served as the director of Trump's Election Day operations, prosecutors alleged Roman was involved in the efforts to put forth a set of fake electors after the 2020 election, a charge which Roman was pleaded. He had pleaded not guilty to that charge altogether. Roman's court filing claims that Willis and Wade took lavish vacations together and that Wade used part of his salary from the district attorney's office to travel with Willis. Merchant also claims to have discovered outside of the court filings that Willis and Wade went on trips together. Now, here is Willis saying these are all lies. This is dangerous. This is, it's funny. but it's quite dangerous. This is dangerous. Nonetheless, it says that Roman then filed another stunning court document claiming Bradley would testify Willis and Wade had a personal relationship before Willis was hired. This is the crux of the case. Now, I cannot show you the documents. Are the documents here? Let me see if this is going to let us click it and see the documents, because there's actual documents here. Court filing. Maybe this will allow us to see it. Oh, there it is right there. Hopefully we won't have the big mess that you get. So we're going to look at this just a little bit. I don't know how much of this we can see, unfortunately, because I'm not really good at doing this. Is this the full screen? Pop out? All right. So let me give this to you guys. I'm going to pull this over on the other side so you all can see it. I'll copy it. And I hope you guys can still see where I am, because, child, I'm lost. Hold on. I don't need anything but this on that side. Yeah, you guys can see it, but you don't see the pop out. Okay. Let me double check. Thank you guys for your patience, because what I have to do is I have to continue to go back and forth. All right, now you can see it. Let me blow it up for you and give you the entire screen, so that way you can actually see what's printed here. So I'm going to blow it up. All right. I think that's pretty big, because that's almost the width of my entire screen. Perfect. Now I'm going to give you the screen so you guys can see the whole thing. All right. Wonderful. Now we're good to go. All right. So it comes now the defendant, Michael Roman, by and through his undersigned counsel and pursuant to all this yada, yada, yada stuff. Yada, 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 yada. I don't want to go to this. What I want to go down to is an instant motion. Da-da-da, shanana, shanana. If Ronnie.d.Mann were here, he would not like that I'm shanana. But I want to get to the good part. This is 41 pages. So let's see. Hold on. Hold on. Roman, this is his dismissal. You guys, I don't want to read his dismissal. So here's what I'm going to do while I fish around for the other document that's very telling. What I'm going to do is I'm going to switch up to this screen right here so that we can look at the fact that this woman, making sure that you guys can see that. Yeah, this is Sonia Allen. This is Sonia Allen. Let me make it larger. What's the relevance here, Felicia? Well, the relevance here is this is the woman that, if you remember, while Ashleigh Merchant was speaking and they showed the text messages, she asked Terrence Bradley if Fani Willis knew about Sonia Allen, because according to them, Sonia Allen and Nathan Wade were already sleeping with each other. I wish I had some dun, dun, dun music. I wish I had that. I wish I had that. But that's who she is. Sonia Allen, the Deputy District Attorney, Anti-Corruption Division. She is the senior chief. Well, it's no reason why she was not working in this case. It's no reason why, once it all began, that she was not the person working or handling it. Remember, this is what the senator asked Ashleigh Merchant just within like the last hour or so. And by the senator, I mean the first gentleman, the one with the silver hair. He asked, so they already have an actual team, a division. And she goes, yeah, they've got a team, and they have a person who's a deputy district attorney that's over that. All right. So Sonia Allen joins the team of the newly created anti-corruption unit with the district attorney's office as the senior assistant district attorney, as a part of Madam District Attorney Fani Willis's promise to her constituents. This unit's purpose is to evaluate issues of government corruption and law enforcement misconduct, to include elected officials, election tampering, sheriff deputies, and police officers. As a born public servant, Sonia Allen brings a wealth of knowledge to this unit of the district attorney's office. She has had a vast legal career of over 29 years managing law enforcement officers from an agency with jurisdiction stretching across the great state of Georgia. She specializes in analyzing the merits of criminal cases and internal and external affair assessments. Sonia's skill set attraction to the attention of surrounding agencies who frequently requested her expertise in investigating high-profile criminal cases, interviewing the toughest witnesses, and evaluating evidence for prosecution. She most notably led the internal investigative team in the Brian Nichols attack, focusing on issues of agency policy violations as well as officer misconduct. Sonia's background is varied in that it encompasses a vast knowledge of developing litigation strategies for complex cases, and ultimately led her to be appointed as the second in command of a workforce of over 800 sworn civilian employees with a budget of over $100 million. Sonia was the legal counsel to the past Cobb County sheriff, where she handled all legal issues concerning his office. She has been involved in the prosecution of hundreds of cases over the span of her legal career. Sonia is excited to put her experience to use at the Fulton County District Attorney's Office. Cobb County is where Nathan Wade was originally. Now, that's where he was originally, and that's where she hails from. So it goes on to say she is a graduate of the University of Georgia and John Marshall Law School. In 2020, she was the recipient of the Medal of Distinction for her lifetime of achievements throughout her career. Here comes the part that somebody pointed out earlier when they asked, was Fani part of those Freemason type groups? Here we go. Sonia enjoys volunteering and serving her community through nonprofits and her beloved sorority, Alpha Kappa Alpha Sorority Incorporated. Now, this is important because to my knowledge, Fani Willis is an AKA. And what they created for the vice president, who is, Kamala Harris, they fashioned this story that says she was an AKA. Wouldn't it be funny if they were talking about something happening and that's the reason why Fani Willis was in DC meeting with the vice president? Wouldn't it be funny if they said, well, we're just sorors and we were talking about this or we were talking about that? Just so happens we're both sorority sisters. It had nothing to do with this litigation against Trump and a whole bunch of other people. I guarantee you somebody going to lean on that because I know for a fact they're sorority sisters. And I do not believe that Kamala Harris is a real AKA. She didn't even know what ski-wee was. She didn't even know that annoying sound they make on all college campuses. When she was asked in an interview, if you saw one of your sorors coming toward you in the airport, tell me what you would say. Give me the sound you would make. And she just looked at the interviewer and cracked up laughing. I don't know. And she goes, come on, tell me, what would you say? She goes, hey, girl. And the lady looked, and I said, she's not an AKA, because anybody would know that. Deltas know, okay? A Delta know that sound. A Sigma Gamma Rho know that sound. Everybody know that sound, but you don't? Child, bye. Anyway, it goes, it says, when away from the office, she also enjoys coaching, gymnastics, and is an official gymnastics judge for the Georgia High School Association varsity group. Here's my point to bringing this chick up. She better run. She better run. She better run and run fast and go tell that. Oh, I appreciate you so much. Thank you so much for thinking of the Lockhart perspective and headlines with a voice. Maybe I have a different taste in my mouth, but she reminds me of Mark Furman. We will talk about it one day. She really does, doesn't she? She honestly does. There was a lot with that Mark Furman situation. I'm glad you mentioned that. But here's the deal to us bringing this up. The Ghost OG J Speed. The Ghost OG J Speed. Here's the deal. The deal is, when this woman's name was brought up in that text message, it sent off an alarm in my head that tells me that if she's got any good sense, she's going to run and tell that, because she is the second in command. And the best thing to do is to clear your name by getting your hands out of this pot, lady, because if you don't, you're going to go down. And you guys, let me know what you think about this in the chat. if she does not speak up, she's most assuredly going to go down with them. And they're going down because that's what time it is. Listen, that's who Sambo was. Sambo did the bidding of quote unquote Massa. Sambo did the bidding of Massa. But who was the one that was a good dude? That was none other than an Uncle Tom. Uncle Tom was the good dude because he was helping everybody, make sure everybody was straight. This right here is some Sambo-ish. This right here is some Massa-ish because they were trying their best to make a name for themselves, thinking, if I do this to Trump, this is going to happen. And again, I ain't got a dog in the hunt. Whether you vote for Trump or whether you vote for Biden, I don't care. I'm not voting for either one of them. That is your choice and your choice only. I'm making a point that what is going on in America right now is they are using melanated individuals to exact their revenge on anybody that they want. Specifically, in this case, it's Trump. Because like we said earlier today, there are at least 4 women who are melanated, Black folk, quote unquote, Black folk here in America. Okay, quote unquote, African American, named after 2 continents, which means you really don't exist. Black mean you don't exist. Nonetheless, I digress. There are 4 Black women that they are using right now to push a narrative that Trump bad. Trump is bad. Trump is a bad guy. And he just might be. He might be all of that. My point is, they're going to use you, ladies. They're going to use you, squeeze out all of your life, every bit of juice that's in you. They're going to squeeze out your political career. And if you maybe cow down a little bit more, maybe you'll be in there a few more years where you'll be unrecognizable like Maxine Waters in the next 25 years, where you walk in looking sort of cute with a decent waist and you walk out looking like James Brown with a bad wig. Okay. If you decide you want to hang out and play their game a little bit, maybe that's how you'll be. But at this point, what I see is you losing all of your credibility to anybody. Ain't nobody going to deal with you but somebody who is a snake, a hamster on a wheel. That's what you're going to end up with. And that's what I see. So I appreciate each and every one of you all for hanging out with us today. Thank you so very much for allowing us to look at this bird's eye view of what really is happening. This is what's really going on. What we just saw is what's going on. And I'm so happy that we had the opportunity to see it in totality. That makes me very pleased. Very, very pleased, because we never got to hear everything while this was going on. All we got to hear was a lot of objections and a lot of interruptions and a lot of stuff, which was not cool. It wasn't cool at all. And now that we have it like this, we at least got the chance to hear everything that she was trying to say that she could not say because the judge did not have control over that court. He did not have control. And by which judge I'm referring to, Judge McAfee. Judge McAfee. He did not have any control over the court. And because he didn't, we were not able to really get the full essence of what was being said. Because every time one of the individuals on the other side of Fani Willis stood up to say anything, what did we get faced with? They were met with objection after objection. But today, we got to see exactly what they're utilizing in order for them to go forward in this case. And I'm glad. What I wish is that more of our people would just be quiet. I wish that more of our people would just be quiet when you see somebody doing what's wrong. That gentleman, Mr. That gentleman, Mr. Jones, who was one of the senators there in Georgia, unfortunately for him, he made himself look like an idiot. And for what? And for what? For absolutely nothing. He made himself look like a plumb fool, getting up there, going in like he was going in. And that is what I'm talking about. Here's the irony before we close. Let me just say this. Don't you find it curious that Black folk, again, I'm saying Black folk, even though I know we not Black. We got to use a term that they've given. Let's use it. Don't you find it curious that they generally will not stand together when it comes to doing the right thing, but each and every time you see somebody whittling something made of wood with a little knife over in the corner, they be whittling all the bad stuff, they be jumping right there. Yeah, protect him because he said bad. He say the wrong thing, so I got to sit over here and I got to protect him. Well, you're protecting somebody, but whether you realize it or not, you should be protecting the people who doing good. But we don't do that. We never stand together for anything that brings any value to our community or that can help our community. But you will see a boatload of people all sticking together doing something that's wrong. Case in point, look up there in Dalton, Illinois. Look up there in Dalton, Illinois. And I'm telling you guys right now, I said it publicly 3 weeks ago, and I said it again after that, and I'm saying it again today. That situation has more than you know involved in it, more than the smoke screens that we are being pushed in the media. That stuff that we're reading, even things that I've reported on, that ain't it, baby. There is something heavier, and I'm digging. It's something deeper, and I am definitely digging. And I want to tell you guys something else. When that chick keeps saying, oh, I'm going to get off on this and I'm going to get off on that, and I didn't do anything and I'm safe and I'm that, baby, she got one of the baddest attorneys sitting next to her. That man named Mr. Delgado. That's all he deals with. That's all he deals with is townships. He deals with states. He deals with cities. He handles all of that. This man is well-versed, and trust and believe me, the circus that these poor individuals there that are dealing with her, the little little trail they have them running on, that is nothing but a distraction. Those people are going to continue to run themselves into a corner because the dude that she has from the Delgado Law Group is off the chain. What I've been able to investigate dealing with this man is he's not joking. So the stuff that she's doing undoubtedly is some type of laws that she's getting away with because he knows the law. She's as dumb as 2 bags of hair. Okay, she's dumb as a bag of Indie Remy marked down at the beauty supply store from Miss Kim. She that dumb. She dumb. So this dude, he's not leading her astray. Trust me when I tell you. Trust me when I tell you. Okay? Now, oh yeah, okay. Omni is too much. Okay, but Dr. Lockhart, he needed to stand up for the Black woman because we block. But I'm telling you guys something, there's something to him. This man also does, get this, he does immigration law as well. He helps not in the essence that he's helping people get in, but he deals with specific things and he takes cases dealing with immigration. That's why I'm telling y'all what I'm digging up. This chick's not all the way gone. She's a pawn, but she ain't all the way gone, but she's definitely being used. And I strongly believe that when they do get the opportunity to vote her out on 2025, unless of course she missteps while she double dutching. If she misstep, they're going to snatch her out and put somebody else in. But I guarantee you there's a need and a reason for this chick. There is a need and there is a reason. And I'm digging. And I'm going to keep on digging until I come to the bottom of it. Because what I got now is telling me that every single one of us, myself included, as a blogger, as a vlogger, as a whatever, we've been looking at what is public, but we ain't been looking down below. But as we get a little deeper, as you guys know who follows this channel, both channels, you guys know what I do. I get down on the ground and I start scrolling around. I start squirming around, getting, what is it called? Stop, drop, and roll. Where the smoke is, I get down there on the ground where the smoke's not. Where there's no smoke, so that I can see whose feet are in the room at the time. Based on those feet, I know exactly what time it is and what party I'm at. With that said, do not discount that. Don't think that it's what you see. And when she says that she's right, that she's legal, that she's okay, 110% the law is on her side from what I've been able to see. And that ain't good. But what it's doing is exposing the United States, our frivolous laws, and the laws that we're currently using to invade our own country. Let me tell you something before I leave. I know I lied, baby, and I said I was going to be leaving in a second, but I'm going to really leave after this. Let me tell you this. Our laws, we're switching reels, okay? Our laws are written in such a way that they have been used against us. We are using asylum laws to bring in people into our country. Again, we just had the White House admit that they had brought in, what was the number? Somebody put the number up early, the amount of people that were coming in our country illegally by way of plane, by way of an airplane, airplanes. Our president was bringing loads of people over here by way of airplanes. I can't find it now, but somebody put it in there. Somebody put the number in the chat that knows the exact amount of people that were coming in by way of plane here in the United States. Illegal aliens being chartered on flights by the United States government, bringing the people in. And they were coming here. The Biden administration just admitted this is what he was doing. We're using our own laws to move troops. What troops, Felicia? What you talking about? Oh, you don't know what I'm talking about? Do you know what the UN troops look like? Let me show you what UN troops look like, just so that you know what I'm trying to say. Let me give it to you straight, no chaser. Let me give you some. Let me see. Let you get a gander. All right, baby. Here you go. You don't know what I'm talking about? Because see, Bubba and Bobo them, they ain't going to kick in your door because they know your mama and them. But you get some cats that look a little bit like you. Okay? You get some cats that look a little bit like you, kicking indoors and coming in. See, these are the UN troops right here. You may not be able to see them that well because of the way Google jacked themselves up by this stuff they think is so awesome now. Okay. But these are UN troops. Okay. You have them. They call them peacekeeping troops, the peacekeepers. But these are the individuals that they bring into different countries. All right. You see these cats right here? Don't those cats resemble some of the dudes that's walking on the streets of New York right now? Yeah, they do. Yeah, they do. That look like them, don't it? 300,000. Thank you, Brother Anthony. Anthony Van Zandt says 300,000. They brought 300,000 people here. And so did Robert Smith. 300,000 people here by way of airplanes. This is an invasion. And when you hear them all complaining about Texas, moving them into Chicago and dropping them off in Detroit, all they doing is moving them from a MEP station, if you will. It's just like moving them from one MEP station and moving them where the next place they're going to go before they get their orders. Do you see this? People thought I was crazy about 5 years ago when I kept saying we're being invaded from the inside out. Our country is being destroyed from the inside out. No, it's not. No, it's not. Now everybody and their great grandmama's saying it, but don't nobody know what to do. You don't know what to do because the propaganda is so big and it's so wide and you're hearing about it so much and it's all over the news that they're here, but you don't know why they really here. You see them dudes, those dudes right there, based on the list that your name is on, will come in your house. And that's all I'm going to say once they get in. Okay, you do the math. But everything that you see right now, when they say they're moving busloads of them over here, 25 busloads just landed in Chicago, and this amount just moved over here, and this, they are moving troops. Anybody who's ever been in the military in the house, they are moving troops. It's just like you just got in and you went to the MEP station and then they sat there and then they processed all your paperwork. And after they was done processing all your paperwork, then they give you, you're going to go over here. Then after you go here, this is going to be boot camp. This is where you're going to be. We're going to put you in this area. And after boot camp, you're going to go to AIT. And after this, we may have something that you have to be involved in. And because we done paid you to come all the way over here to the tunes of $1,000 a month on a UN debit card. Y'all ain't hearing me. Please, just hit the like. Just hit the like for me. If you can just do that, we'll be straight. Because I'm trying to tell y'all something. Okay? This is what's real. Because see, before, what did they do? They kept all of this stuff so shrouded that everybody thought, oh, they're coming through the Mexican border, so it must be Mexicans. But wait a minute. What about Guatemala? What about Venezuela? What about the fact that they just opened up and found out that there has been some type of disruption in Haiti? I think it's close to 4,000 to 6,000 How do 4 or 6,000? I don't remember the number. Somebody pull that up for us. It's either 4,000 or 6,000 that just escaped from Haitian prison as their president was out of the state, out of the country. Their president was out of the country. It's either 4 or 6,000 of them, and they escaped from a prison, and can't nobody find them. Yo, they on a plane. They in your backyard. Hello, Florida. Hello, Florida. Welcome, Florida. Come on in, Florida. Come on in, Florida, baby. Come on. I'm trying to tell you something. Keep your eyes open. And if you guys are one of these people that's running around talking about, oh, I don't believe in carrying X, Y, or Z. Why? They got them. Did you just see the legislation that passed to say, oh, if they meet a specific criteria, yeah, they can get a blam blam, and they can keep the blam blam on them. Baby, you all better wake up. It's not what we think it is. It's not what we think it is. Moving people from one state to another in the public eye, they got to tell you. He just moved them from Texas to there. Yeah, because he's a meth station. And the reason why you're seeing all of these cats do crazy stuff like they doing up there in New York, beating up the popos and all of that other stuff, the reason why they going off on the popos is because they know their purpose of being here, and they already know the dum-dums have already said to defund the police, and that there have been some dum-dums in some cities and some jurisdictions that have decided to decrease the amount of cats that they got on the road. So you ain't got to worry, because the ones that's left are really the scary ones. Okay, there are some of the popos that decided, you know what, I ain't taking this. Let me go do something else, and they bounce. But then you got the other ones who don't even who won't even gamble if their life depended on it. They just hold on to the job because they needed security and they like what they like what they're doing. So those are the cats that they whooping on and beating up. But see, the dudes that's jumping on these folks, they know the assignment. And they know that all they got to do is wait for the whistle to blow. And when that whistle blow, it's on and popping. So all you're seeing is a glimpse of what their knowledge is. And that is why they're here. 4,000. You see that? 4,000. They're worse. The baddest dudes in Haiti. They said that they escaped. How you get 4,000 cats to just escape and you can't find them now? They over here, baby. Trust me. Y'all, keep your eyes open. Don't walk around la 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 la. I'm just going to the mall, and I don't live near a border state. I heard some ignorant woman, I think it was one of those dum-dums on MSNBC, one of those great dodos that were sitting there saying, you know, it's amazing to me that we're using this to really put people in a state of fear, talking about, you know, immigration was their number one reason for voting the way that they voted. But listen, we don't live in a border state, you idiot. If you got Massachusetts taking old military barracks with a contractor that mowed down some of those barracks and converted them into high-rise apartments, and they're giving them to these individuals to the tune of 2 years for free, then what does a border state statement have to do with what you're talking about? Because Massachusetts is nowhere near South America. Massachusetts is up. Maine, they got them in Maine. Maine is cold as all get out. They're up in Maine. Now you want to say, okay, well, they're coming through Canada, but that ain't who they're talking about. That ain't what they're talking about. Michigan, where the Great Lakes, they ain't coming from Canada. And the ones that are coming from Canada, baby, you can believe that they come in here, and it ain't for what you think. Listen, we have the replacements here. These are the replacements. These are the replacements. Here's one of our mods, Deborah Johnson. She says, Georgia judge assigns UN Special Master Jason Carter to oversee the 2024 election. People are like, you know what folks are probably thinking, Deborah, how could that happen? Because you all are not aware of what's going on, because they're keeping everybody so distracted, you guys. They're having the whole bread and circus thing. It's like the Roman circus out there. They're keeping everybody so confused with all of the stuff and divisiveness that folks are thinking that it's not what it is. So check that out. Check out what we're looking at. Remember, my point to bringing all of this up, even though we switched reels, was the fact that they are using these cases to give us enough distraction to where we won't focus on the amount of time that passes. And if we're not looking at the amount of time that passes, then what we're doing is feeding right into it by not executing a great usage of our time. You see how we did that? And we didn't even sound goofy like the camel toe Harris did with the passage of time. And it's the time and the passage of time. We didn't do any of that. We just basically let you know that what time it is for our eyes to wake up and to see exactly what's in front of us. Please do, because it could be only a matter of months in my feeling, in my gut, and I could be so off. I could be wrong. This is me, not y'all. This is not anything that I'm getting as a divine story. I just feel like because these guys are committing the crimes that they're committing so brazenly, that it's just a matter of time before they are activated like troops and they're out here cutting up, doing all kinds of craziness. That's just me. That's just what I feel. Abbott bust the illegals north. Why? The border was just a few miles away. That's exactly what I'm saying. That is what I'm saying. That is what I'm saying. Because you would look at that area, Texas, for example, as an area where you would be receiving troops, processing them, and then moving them to their duty station. Please look at everything that way. Does everybody in the chat know that they are considering, if they have not already approved it, utilizing the people who are coming over the border in our military? Please tell me that everybody knows this. Please tell me. Put a 1 in the chat if you knew this. Put a 1 in the chat if you knew this. That they are considering. I want to get the name of the senator. Let's see. Yeah, it's Dick Durbin. Oh, wow. Yeah, Dick Durbin. He wants to do it. Let's see if we can find a video with this. Oh, it's on C-SPAN, so that's even better. Let's go on ahead and look at this. All right, see, there he is. He needs to go sit down. He needs to have several seats. Before we go, let's take a gander at this, okay? Hold on. Let's just have a gander at it. Dick Durbin. Let's go.
There's been resistance throughout our history, unless we needed cheap labor to build the Transcontinental Railroad when we invited Chinese workers to come in. We treated them, unfortunately, in an inhumane fashion and didn't give them largely eligibility to become citizens. But we needed the labor, we needed the workers. It's happened many times before. What troubles me about the debate now about the southern border is it is one half of the immigration equation. Yes, we need order at the border. Yes, we need to have changes in the laws that reflect the reality of the overwhelming numbers from all over the world who are coming to our shores and our border. But there's also an incredible demand for legal immigration into this country even now. The presiding officer, my colleague from the state of Illinois, has legislation which addresses one aspect of that. Her bill, and I hope I describe it accurately, says that if you're an undocumented person in this country and you can pass the physical and the required test, background test, the like, you can serve in our military, and if you do it honorably, we will make you citizens of the United States. Do we need that? Do you know what the recruiting numbers are at the Army and the Navy and the Air Force? They can't reach their quotas each month. They can't find enough people to join our military forces. And there are those who are undocumented who want the chance to serve and risk their lives for this country.
All right. And to this point right here, let's look at this. Let's look at this. All right. We have another point before we leave here. New York is one of those places that if you're not a U.S. citizen, you can be a police officer. So let's just go ahead. Let's find us a video with that because it does exist. And I think I want to use something that's free. So let's go here. This is New York, and then there's also California. Hold on just a second. Now, these are things that we need to know because, see, we'll get into arguments. I've been on a couple of podcasts and I've just sat silently when we start to get into these questions about the immigration issue and all these other things. And when I see that people want to challenge it based on stupidity, I don't even get involved. I just let it go because I know people don't know. But I'm glad you all are here because that way you'll be able to see this. Okay. All right. Let's see.
Closed captioning for this program is brought to you by Robert A. Clifford and Clifford Law Offices, serving Chicago as a personal injury law firm since 1984.
A new Illinois law has become a flashpoint in the culture wars, with figures like Florida Governor Ron DeSantis condemning it and Governor J.B. Pritzker defending it. The law will soon allow certain non-citizens who are eligible to work in the U.S. and are authorized to possess firearms under federal law become police officers and deputy sheriffs. The law extends this opportunity to legal permanent residents and DACA recipients. The move comes amid 1,000 plus vacancies in Chicago's police department, and it was passed with majority Republican support. And joining us to dissect and discuss the law are State Representative Barbara Hernandez, a Democrat from Aurora who sponsored the bill, and George Fishman, a senior legal fellow at the Center for Immigration Studies. Welcome, both of you. Representative Hernandez, you sponsored this law, so let's start with you. Under it, who is eligible to become sworn law enforcement and who isn't?
Thank you for that question. It's very important. I think there's a lot of misinformation going on right now with this law. Legal permanent residents and DACA recipients to become officers if they apply and they are able to qualify. However, the DACA portion at the moment is symbolic, simply because they can't carry a gun at the moment.
And at the moment, this bill, why did you believe it was important?
I think it's very important that overall we're seeing a shortage in the police right now. There's a lot of people that are retiring, a lot of people that are not joining the force. So there's a big pool of individuals that want to. So allowing them to apply and hopefully they qualify and go through the testing and become officers, that would be a great opportunity for both them and the police departments to fill in those gaps.
All right, George Fishman, why do you believe that these non-citizens who do have work authorization, why do you believe they should not become police officers?
First, I should say that I spent much of my career drafting legislation for the U.S. Congress. And my reading of the Illinois law is that it would allow aliens not eligible to work under federal law to become police officers, not with regard to police officers, but with regard to deputy sheriffs. The way it is written, all DACA recipients, putting aside the firearms issue, could become deputy sheriffs. The problem is that not all DACA recipients are work authorized. They have to apply for work authorization to DHS, and they'll only receive it if they can demonstrate an economic necessity. So it's certainly possible that the statute could result in non-work authorized aliens becoming deputy sheriffs. That involves both civil and criminal violations of federal immigration law.
Let's clear that up. Let's clear that up then. Representative Hernandez, is that the case? Would it allow some DACA recipients that don't have work authorization to become deputy sheriffs?
No, they will not. It is very specific. The bill is very specific to only legal permanent residents and DACA recipients upon federal approval if the federal government does allow them to purchase or own a gun.
All right, George Fishman, I want to read a tweet here from downstate Congresswoman Mary Miller. She says, quote, when no one was paying attention, Governor Pritzker signed a bill to allow illegal immigrants to become police officers, giving non-citizens the power to arrest citizens in our state. No sane state would allow foreign nationals to arrest their citizens. This is madness, kind of along the lines of what you're saying. However, this bill passed unanimously in the House with all Republicans. It passed with most Republicans in the Senate. FOPs were in support of it. Chris Miller, the conservative state representative who is married to Mary Miller, voted yes on it. Why are Republicans opposing this now when they supported this when it came up?
Well, without getting into a marital dispute, which I certainly don't want to do, Are U.S. citizens bigoted for wanting to be policed only by other U.S. citizens? I certainly don't think so. The concerns that Ms. Miller and others have expressed are the exact same concerns that the U.S. Supreme Court expressed in 1978 when it came to the conclusion that states have the constitutional right to limit eligibility to be police officers to U.S. citizens. The Supreme Court didn't say that states had to do that. It said they were certainly within their rights to do that.
My question, though, is
And
about
so-
Republicans. This was not controversial among Republicans when it was being voted on, including very conservative Republicans. Why do you think that is?
The CIS is a nonpartisan organization, and certainly, as many have pointed out, many non-citizens perform bravely and admirably in the U.S. Armed Forces. But in terms of, as the Supreme Court said, impacting U.S. citizens in the most sensitive areas of daily life, in terms of being able to arrest and do things of that nature on their own initiative, it's certainly understandable and reasonable that citizens might want only to be policed by other U.S. citizens. It's not impugning anyone else. It's just something that, again, the Supreme Court was very comfortable with.
All right, let's go back to Representative Hernandez. There are some concerns from some downstate sheriffs. In Vienna, the sheriff there posed the question of it might be difficult to run a background check on folks that are non-citizens. There might not be that much information on them. How about those concerns, Representative?
I think honestly, most of the individuals that are making those concerns should be educated on the process itself, especially legal permanent residents are already here for many years. There's a pathway for citizenship as well. They have to wait up maybe 4 years in order to do that, but there's a lot of background information on them already. When it comes to DACA, this was established in 2012, and with the requirements of background checks, and enable, in order to get DACA. So all this claims that they are going to do background checks in other countries and so on, it's not really true. It's not, because it's most of the individuals, especially DACA recipients, have been here for when they were probably 2 years old, and there's a lot of background information on them already.
All right, we do have to leave it there. The law goes into effect January of next year. We appreciate you being here, Representative Barbara Hernandez and George Fishman. Thanks very much.
Thank you.
Thank you.
Okay, so now let me remove this. So there you can see now there has been other laws that has allowed them to carry. Let's see what this says. DC and municipalities in 3 states allowed non-citizens to vote in local elections as of June of 2023, California, Maryland, and Vermont. And this is the link that she's using, and it is ballotopia.org, ballotpedia.org, law permitting non-citizens to vote in the United States. There are so many people who do not know these things. And that's a problem, because by not knowing these things, you walk around saying things to people like, no, you wrong. The government ain't going to allow that. Ain't nobody going to allow that. Yeah, it's allowed. Not only that, at the close of the year, from what I've been able to gather, they did allow DACA to carry the guns if they are in a position that requires it, such as law enforcement. And that is a problem. That is a problem. All right. I'm trying to give you guys that article. If somebody else has it and they know about it, where it is, you guys just throw it out there at me and I will go ahead and read it. But there is definitely the law on the books that says if they are using them in certain states, this is for certain states, if they're using the gun as a part of their job and law enforcement, then yes, DACA recipients can have a weapon in that case, right? But the problem is now it's so difficult for you to find information that you'd almost have to, print it out and use it that way. Let's see, January 2024, California made it legal for DACA immigrants to work as police, which departments are hiring them. Now, let me let you guys see this, and we'll you know, I know we're a little off the topic of what we started for. We'll change the name of this video. We'll break it up, you know, into maybe 4 parts or whatnot. But these are important things for us to talk about. There's a lot of stupid stuff we could talk about, but this by far is important for us. Okay. Yeah. Well, I'm not surprised, you know, at all by the amount of delegates that were gleaned. So let me give it to you here. All right. So this is California made it legal for DACA immigrants to work as police. Which departments are hiring them? Dated January 24th, 2024, written by it looks like that's what his name is, Justo Robles. I'm sorry, it's a J, so it's Justo Robles. All right. Dressed in their pristine blues. Is there a weapon on their hip? Yeah, is that a weapon? I don't know. Let's see. Dressed in their pristine blues, dark blue uniform, Ernesto Moran raised his right hand and sworn to defend the Constitution of the state he wasn't born in, but that he has called home for more than 2 decades. That December afternoon, the 26-year-old Mexican-born man became the first officer hired by the UC Davis Police Department under a 1-year-old California law that repealed the U.S. citizenship requirement to become a peace officer in the state. Here's what he had to say. I was always told to be afraid of the police officers because I would get deported, Moran recently told Cal Matters. Now I want to help this community and help other people that are in my same shoes. Please note that he said that. He didn't stutter. He said it. That are in my same shoes. Before the law took effect, California, like most states, had required its peace officers to be U.S. citizens or lawful permanent residents who have applied for citizenship. The state law, SB 960, makes applicants with federal work authorization eligible to become officers. Supporters said the new law would make it an effective recruiting tool at a time of persistent patrol officer shortages and declining staff levels. They said if immigrants were encouraged to apply, law enforcement agencies could gain more diverse, multilingual officers. Senator Nancy Skinner, the Democrat from Oakland who sponsored the law, called the citizenship rule archaic in a statement and said the new law could improve the current relationship between law enforcement and communities, quote unquote, of color by increasing the visibility and representation of people from the neighborhood. But an informal Cal Matters poll of the largest local and state police departments in California suggests many have been slow to hire the newly eligible immigrants. Moran is one of about a dozen California law officers, I think I said that right though, who got jobs through the law, which went into effect January 1st of last year. And this is the crackpot who made the statement, State Senator Nancy Skinner. At the Culinary Institute of America there in Napa Valley. Look at the hands on that woman. Makes me question a couple of things. Anyway, our police officers are facing a workforce shortage as other professions are, Skinner said. She continues with, we need to have people that want to serve in these public safety roles. So we want to eliminate any unreasonable barriers for people from being able to serve. Why not getting Pookie and Ray Ray now, since you're getting a whole bunch of people you don't really know about? All you know is they were born elsewhere and they were raised here. But if they didn't commit a crime, you don't know what they've done. And if they did commit a crime and somebody withheld that information, as it was stated on Fox the other day, you may as well got Pookie and Ray Ray now. I mean, some of the best cops is crooks. That was a good one, actually. California cities are struggling to hire enough officers, especially after the pandemic. The Public Policy Institute of California this month reported the number of patrol officers per 100,000 people is at its lowest point since 1991. Though the steepest declines occurred during the Great Recession from 2007 to 2009, staffing levels still have not recovered. In 2022 alone, the state commission that certifies newly trained officers issued 2,424 basic certifications, down from 53% in 2020, when it awarded 4,530 certifications. The UC Davis Police Chief Joe Farrow swore Moran in as a law enforcement officer after months of advocating for him and others like him. Farrow, before joining the University Police in 2017, had served as a commissioner of the California Highway Patrol for 10 years. Soon after starting at UC Davis, he spoke with students about the potential careers in law enforcement and realized many couldn't be hired as officers because they were undocumented, because they not citizens, stupids. I'm sorry, I said that aloud, and I was only thinking it. But anyway, most were beneficiaries of a federal program known as the Deferred Action for Childhood Arrivals, or DACA, which since 2012 has protected from deportation more than 500,000 undocumented immigrants brought into the United States as children. Farrow saw Moran a hope for a future where police agencies recruit new officers from among immigrant communities. They are a part of our community. They go to school here. They learn here. They teach here. So having undocumented police officers was the next step to completing the idea of representing our community. I think you guys know what we're talking about, okay? I think you guys get it. And this, of course, is Officer Joe Farrow. That's him. There you go. All right. Hey, Joe. You want to give it a go? What's going on, Joe? Let's look at Joe. Let's look real close at Joe. Joe's the advocate. Joe's the reason. Do you see Joe? Do you see Joe? That's Joe. Thank you so much for supporting the channel, sis. Watch Jason Rink and Rawl. It's on J6 documentary. Oh, okay. So it has CCTV, body cams, and live footage exonerate Trump against the DNC planted pipe bomb, J5, to trigger continuity of government. That's another day. Girl, I could go on for days with that. The money and the perks they are giving them are payment in advance. There's the link that Deborah, one of our mods, is sharing. Cartels have deep roots. But look at Joe. There's Joe. Hi, Joe. Hey, Joe. Hey, Joe. Look at Joe. Joe felt sorry for the young man, and he's the one who helped to push this through. It says, though the Golden State is home to the country's largest immigrant populations, for years it barred them from many careers because professional licensures required Social Security numbers. So they just gave them one. Then new laws took effect in 2014, allowing undocumented immigrants to obtain professional licenses. Today, they can be lawyers, doctors, nurses, and other licensed professionals. It took nearly a decade for California to join states like Colorado, and Illinois, which allowed DACA beneficiaries to put on a badge. Quote, I find it highly ironic that you can be a U.S. military officer without being a U.S. citizen. So you can serve in our armed forces and, in effect, be the law enforcement for our armed forces, Skinner said. And yet, California had a rule that you could not be a police officer. Yeah. Well, this is his face. This is what he's thinking. This is Ernesto Moran. Ernesto, Moron. Moran? No, there's no A. Ernesto Moran. Born in Mexico, the state of Jalisco, and brought to the United States as a child. He's the first DACA recipient hired by UC Davis's police department. And all I ever wanted to do was to be a police officer, and they gave me the opportunity. Y'all, I want to let you guys know something, because people keep asking the question, well, where's all these people going to fit if they keep making them automatic citizens? How is this going to work if they keep making everybody an automatic citizen? They are going to wipe out the older individuals first. What generation is X? Are they older or are they young people? What disease did they just say that we had to look out for? I think it was called Disease X, right? I want to thank each and every one of you guys for being with me today. Remember what we always say here on this channel, and that is to take care of yourself first. Because if you don't take care of yourself, nobody else is going to take care of you. That's the important thing to know. And I also want you guys to make sure that you check out my friend, our friend of both channels, and that is Judge Joe Brown. Some of you have already bought the barbecue sauce and told me that it was delicious, and I want to thank you. Here you go. Hey everyone, it's me, Felicia, of the Lockhart Perspective and Headlines with a Voice. I want to tell you a little secret. This is what I used to do because I don't do it anymore. I would go to the store, buy the barbecue sauce, pour it inside of a bowl, put a whole bunch of different spices, a dash of brown sugar, a dash of maple, and a dash of mustard, stir it all around, and everybody would be like, oh my gosh, this is the best, this is the best. But I was exhausted after all of that, and a lot of times I couldn't remember how many dashes of what I put in it. But I don't have to do that anymore because now I just go to Judge Joe Brown's website and I order his 3-pack of bottled barbecue sauce. It is by far the best, and I do mean the best barbecue sauce I've ever eaten. And when you go to his website and you order his 3-pack, you'll see exactly what I mean. Head on over to jjbbbbq.com and order Judge Joe Brown's barbecue sauce. You'll be glad you did, and you're going to tell me about it. I know you will. Well, we got a little frozen there. It looks like somebody's not happy with me, but they'll be okay. I just want to thank you guys. For those of you who've already gone over and made a purchase with him, thank you so much for sharing it with me. And thank you for making sure that you told me it was good so that people know that I am not tripping. It is delicious. So I want to thank all of y'all for hanging out as long as you guys did. And for those of you who have given and supported the channel today, that would be none other than Jay Speed, as well as Deborah Johnson. I want to thank you two for supporting the channel and being today's sponsors. Jay Speed and Deborah Johnson, I so appreciate both of you. You guys are really helpful. And I want to thank you from the bottom of my heart for taking care of the channel today. All right? All right, folks, you guys take care of one another. And remember what we always say, that man shall not live by bread alone, but by every word that proceeds out of the mouth of the Most High. You guys take care of yourselves, and please take care of one another. Until we see each other again, please take care of my friend, because my friend is you. Be blessed. To receive instant notification each time I upload, please hit the subscribe button and the bell notification.